Mic testing 1, 2, 3, 4, 5.
Shri Rao Inderjit Singh will be arriving shortly. I request all the guests to kindly be seated and keep their phones on silent mode, please. Ladies and gentlemen, our chief guest for the occasion, Honorable Minister of State, Shri Rao Inderjit Singh is arriving. To be able to do that, you can give it to ITT. That's मुझे कुछ नहीं करना है. Ladies and gentlemen, may we have a huge round of applause to welcome our esteemed guest on the dais. I welcome you all to this event of International Research Conference on Insolvency and Bankruptcy organized by IBBI in association with IIM Ahmedabad. May I please call upon Professor Sanket Mohapatra, Chairperson, Mishra Center for Financial Markets and Economy, to welcome our esteemed guest on the dais. Sir, may I please request you to address the audience, please?
1 minute, Mr. Rao is coming.
Yes, we'll wait.
Governor,
Definitely, we'll wait.
1 minute.
Thank you.
Should we start? So good morning, everyone. On behalf of IIM Ahmedabad and the Mishra Center for Financial Markets and Economy, I extend a hearty welcome to all the distinguished guests, participants, esteemed faculty colleagues, researchers, and students to the International Research Conference on Insolvency and Bankruptcy. The two-day International Research Conference brings together academics and researchers, lawyers, economists, regulators, and the private sector to promote research and discourse in the field of insolvency and bankruptcy. This conference is organized jointly by IIM Ahmedabad and the Insolvency and Bankruptcy Board of India, marking a confluence of policy and research. I would like to acknowledge the important role played by Professors Abhiman Das and MP Ram Mohan of IIM Ahmedabad, along with colleagues from the IBBI and the Ministry of Corporate Affairs, Dr. Kokila Jayaram, Dr. Anuradha Guru, and Shri Ritesh Kabdia in organizing the conference. The Mishra Center at IIM Ahmedabad is pleased to support the conference. The Mishra Center is involved in building quality data, analytics, and insightful knowledge of the Indian financial markets and the economy, and engages with relevant stakeholders who influence policies as well as those who are significantly affected by policies. With that, let me take the opportunity to introduce the distinguished guests. Today, we are fortunate to have with us Shri Rao Inderjit Singh, Honorable Minister of State with independent charge for the Ministry of Statistics and Program Implementation, the Ministry of Planning, and the Ministry of Corporate Affairs. Shri Rajesh Verma, Secretary for the Ministry of Corporate Affairs. Shri M. Rajeshwar Rao, Deputy Governor of the Reserve Bank of India. Shri Ravi Mittal, Chairperson of the Insolvency and the Bankruptcy Board of India, and Professor Errol D'Souza, Director of IIM Ahmedabad. I would now request the esteemed guests to come to the dais for lighting the lamp.
Thank you, dear dignitaries. I would now like to request our esteemed guest, Professor Errol D'Souza, to deliver the welcome address, please. Mr. D'Souza is a professor of economics and the director at Indian Institute of Management, Ahmedabad. He has been associated with various government departments in his illustrious career. Sir, may I please request you to deliver the welcoming remarks? Thank you.
Shri Rao Inderjit Singh, who is the Honorable Minister of State, who is with us. Shri Ravi Mittal, Chairperson of the IBBI. Shri Rajeshwar Rao, the Deputy Governor of the RBI, and Shri Rajesh Verma, Secretary, and other colleagues who are here, including the justices who have come from the NCLT and many others who I see, esteemed colleagues. It's a pleasure to welcome you all at IMA for this very important conference. This is actually the second that we have had, and unfortunately we couldn't have one after the 2019 one, which was on a similar theme because of COVID, obviously, and it's great to see people back in a physical setting at this conference. Okay? Just a few months ago, the Parliamentary Standing Committee on Finance, had put up some issues with regard to the insolvency and bankruptcy issues, and some of the findings that they reported were interesting, and we thought it's a great opportunity to go back to the drawing board and think about what's happening in this very important part of the economy. Some of the findings were that you actually had haircuts given in something like 95% of the cases. You had delays beyond 180 days, again in some 70% or more of the cases. And most interestingly, when they were there were disciplinary orders on solvency professionals. If I remember the data correctly, it was something like 123 insolvency professionals were caught for disciplinary orders out of some 203 who had actually been looked at. So it's not it's just a good opportunity to go back and think about what's been happening, and some of the papers that I've just saw are going to be presented, are going to be talking about some of these issues and making recommendations on how to go about taking this very important institution forward, because there's no doubt about the fact that this has been a landmark change in the Indian setup. Okay? If we go back to just thinking about actually what a good bankruptcy procedure is, and if we were to go back to just thinking about design principles on this, then there are some very clear guidelines, and it seems like we've gone through that path quite carefully. If there were no bankruptcy law, then effectively someone who had credit due to them would basically have two recourses. If they were a secured creditor, then you would really ask that the collateral be sort of handed over to you. And if you're unsecured, you would go to a judge and ask that some of the assets of the organization be sold, and you get paid back. Okay? We know the problems with that. It is that if there are a large number of creditors, then everyone would want to go and make sure the assets are sold off as fast as possible. That is a huge loss of value for the organization, and so it's great to have a bankruptcy procedure in place. Okay? The first thing about such a procedure obviously is that this must be efficient ex ante. Okay? And when we say it should be efficient ex ante, we know that it basically means that when you issue debt, and you are foregoing equity, you're in a sense making a commitment to make payments out of future cash flows. And so you should ensure that that commitment is met if by chance the firm goes under. Okay? And there's no better way to do that than to say that shareholders should actually lose some of their rights, and maybe management should not have a right to continue either. Okay? And so a bankruptcy procedure is a very important part of making sure that that happens. Okay? But of course there is the problem of how do you then distribute the value which is there in the organization. Okay? And mostly bankruptcy procedures follow some sort of a priority rule, which is that senior creditors should be paid off first, and then junior creditors, and eventually shareholders. Okay? And that seems to make sense, except when you think about it, ex ante, if you are in an organization which is you have the sense that it's going to go bankrupt, then there is an incentive for the management of the firm, to go for broke, because you would then ensure that you get some of the upside of the firm, and the risk is not yours, because anyway, if it goes broke, it is going to go under a bankruptcy, routine. And that means that we know about this in finance. We talk about this as asset substitution. The fact that even though you have a high quality project, you would substitute it with a low quality project just because there is a high chance, that you would get better returns, and you would be able to keep the organization afloat. But that's not good for the organization. So a good distribution of value must have some role to play for shareholders. And that's something I find often missing in bankruptcy procedures, which is that it is all given to the creditors, which is to actually look at how to unwind the assets or how to liquidate the ongoing concern. If you look at it from the point of view of incentives, which is what people in finance and economics study, it's not the right structure of incentives maybe. Some value must be kept for shareholders so that they don't take this option of actually going for broke. After thinking about that, the second thing obviously is about what is the correct way of assigning decision rights. And obviously in our context, we've decided that we give it to creditors. There's a committee of creditors which will sort of look at the problem and would actually have a say in how to unwind the firm. But just think of an organization where the debt is approximately equal to the liquidation value, and supposing you give creditors the right to look at the problem. Obviously, their incentive is to liquidate the firm so that they get paid off. But the incentive of shareholders would be different. Their incentive would be try your best to reorganize the thing, because we will share in the upside, even though the risks might be there. So who do you give priority in terms of unwinding assets is again a very important sort of a component. In our case, the insolvency professional basically has a time window within which they have to come up with some plan. And they can, in that plan could involve a rejig of the corporate organization or a change in management or whatever. But finally, it has to be okayed by the committee of creditors. But even before the 180 days, the committee of creditors has the right to liquidate the firm. So that, to my mind, leads to what we in decision making call a type 1 error, because you're really pushing towards liquidation. If the firm is efficient and the assets are not really a problem, you should be reorganizing. But the whole incentive structure is really to move towards liquidation. It's the opposite of what would happen, let's say, in the US bankruptcy system, where they would make type 2 errors, which is that actually if the firm is inefficient, the incentive is to reorganize rather than to liquidate. So both systems do have problems, but we should recognize, that these problems are very much inherent, and that we are actually going down a path that we have predetermined, rather than kept it open as to what's the best valuation that can happen from a firm which is turned bankrupt. Finally, my small thoughts also on once you give creditors this sort of power, then obviously the argument is from the supply side, there would be an incentive for them to increase the flow of credit, and that's good news, right? Because now you're more in control of that flow of credit. And so actually that's a supply side phenomenon that we would actually see more credit flow in the economy, more new firms, and if firms go down, actually the capital gets restructured. But think of the demand side story. On the firm side, they would be more careful knowing that now there is more power on the creditor's side. And would they actually therefore take more capital? And if they would, how would they actually think about project financing? I'm not sure we have the empirical answer to this. I hope one of the papers in this thing is actually looking at something like this, because we focus too much on the supply side story. Okay? The demand side story is that if I'm on the management of a firm and I know creditor rights are very strong, okay, I would think twice about the type of loans that I take, and I would try to substitute with various other types of finance. Okay? So it is a problem that we need to also think about. Okay? So it is an opportune time to actually think about many issues. Okay? And this conference is an appropriate juncture for us to do so. Thank you so much to all of you for being here. I don't think we thought we would have, the type of response we got in terms of the number of paper presenters, etc. Otherwise, we would have chosen a bigger room for the inauguration. But it's a pleasure that honorable ministers also decided to come, and we are most heartened by our collaboration with the IBBI, who have actually been with us, on this journey, thinking about insolvency and bankruptcy for a few years. We look forward to the deliberations of the conference. We hope you have a pleasant stay. It's hot, yes, but I hope the ideas that are generated as heated and will generate a lot of light on a number of very important issues of the day. Thank you so much.
Thank you, sir, for your welcoming remarks. Certainly, your inputs will help the policymakers in introducing further reforms. Ladies and gentlemen, may I now like to introduce our guest of honor, Shri Ravi Mittal. Shri Mittal took charge as Chairperson, Insolvency and Bankruptcy Board of India in February this year. He superannuated from the position of Secretary, Department of Sports, Ministry of Youth Affairs and Sports. He has also served in various ministries in his illustrious career. Sir is a 1986 batch Indian Administrative Officer. Sir, may I please request you to deliver the special address.
So good morning, everyone. Good morning, everyone. Honorable Minister Corporate Affairs, Deputy Governor RBI, Secretary MCA, other members on the dais. I see IBA Mehtaji, other members of my board, our whole-time member, researchers, officers from IBBI, from IIM Ahmedabad. So I welcome all of you to this international conference. I can see our 3 judges sitting here. It's an honor that they have also come here. So I welcome you all to this first international conference that we have organized with IIM Ahmedabad on insolvency issues. What we see is that we have had 6 years of IBC, and today we really need evidence-based research so as to take it forward. We need to understand as to where we have gone wrong and where we have gone right, and how to go ahead. And it is in this context that this conference should help us. The more than 50 research papers that are being presented today should help us in setting our policy directions, in helping us frame our regulations. I will give you 2 or 3 of my thoughts on the IBC process. I used to work in the banking ministry in mid 2015, and during those times NPAs were just rising, and we were really riddled with a big NPA problem. Banks were doing their own resolutions, but it was not working, and it is in this context that perhaps IBC came. And when I read IBC during that time, the first thing that struck me was that IBC prescribed timelines for everything. And I think that is the essence of IBC, that it prescribes as to what is to be done in how much time. Now, during the discussion in those days, we used to discuss as to why IBC is prescribing such tough timelines. I know that these timelines are very tough, and it is very difficult to resolve any asset in this timeline. But it was thought of, and I think it is still true, that value of assets go down very fast. There is a study which I saw 10-15 days back, which says that in the first year, the value goes down by about 30%. And then there is a 10 to 15% decline every year. Now, let us trace the journey of the project. when the promoter defaults on the payment, 90 days after that, the bank declares it a NPA. If you look at the RBI circular, it says that we have to wait for another 180 days. The RBI circular gives 180 days for the promoter and the bank to settle the issue. So 90 days plus 180 days plus 30 days, it is about 260, 270 days. So the project comes to NCLT or the project comes under IBC after 270 days. But this is the minimum. What we have seen is that projects are coming to IBC after 500 days, after 600 days. So what is happening is that 20–30% of the project value has already been lost when the project comes into the IBC process. And then the IBC process itself takes about a year or so, or more than a year. So when the project is finally bid out, it is about 2.5 to 3 years later than the first default. So naturally, what will happen is 40–50% of the project value has already been eroded. Now, we should not expect a bid which is the bank's debt, because 40–50% has already eroded. So I think the first thing that needs to be done is that projects have to come into the IBC process as early as possible. And my advice is, my thinking is that banks or financial creditors should send the projects just after NPA. And if the project can be resolved, then they can always withdraw, because there is a withdrawal clause now in the IBC system. But projects should come fast, should come earlier. And even in the resolution process, what we see is there are all kinds of issues that are raised during the resolution process. Issues relating to claims, issues relating to diversions, issues relating to frauds, and so on and so forth. Now, resolving these issues is a time-consuming work. Now, you can't expect issues involving crores to be resolved in days. It's very difficult. So we have to think whether we can separate these issues with the resolution process. Let us resolve the project. Let us hand it over to the new person. Let him, with less loss of value, let him start running the company so that it can be sold as a going concern, and let us settle these issues separately. The money that comes from the resolution process can be deposited in the NCLT court, or a fund could be created, and it can then be distributed as and when a decision is made. That way, we will be able to preserve the project. I mean, that I believe is of prime essence, that whatever we do it within the time. Because if the whole pie becomes less, the distribution pie becomes less, then all this fighting about claims and frauds and things, it I think becomes meaningless. So this is one point that I think should be researched, and I have seen there are some papers which talk about this, but this is one issue I feel which needs consideration in the Indian context. The second point that Director Saab said about resolution versus liquidation. I mean, I can see that it is a very important topic, and large number of our projects are going into liquidation. Large number of our projects, but why are they going into liquidation? They are going into liquidation because, again, projects come here very late. So when projects come into the IBC process, that project is already, that factory or whatever is already closed for 2–3 years. And then the committee of creditors finds it very difficult to revive it. So naturally, it goes into, or liquidation is preferred. Our regulations also are tilted towards liquidation, and we will examine it. In a month or two, we will examine it as to how to encourage resolution more than liquidation. Because the basic sense of IBC is to resolve a project as a going concern. That is the basic essence of IBC, and liquidation should really come as a last resort. Another issue on which there are 2-3 papers is interim finance. Now, if you want to preserve a company as a going concern, interim finance is a must. But when you talk to bankers, they say we have already wasted so much money, should we give interim finance for a project which eventually it will go into liquidation? So this is again an issue which needs to be examined as to how to deal with things such as interim finance. The last point that I want to make about IBC is, IBC has done more outside IBC than inside IBC. I remember several years back, I used to be with Mr. Mehta ji on his board, Punjab National Bank board. And he I think in the first or second meeting, he told me an instance where someone's account had gone NPA. So that person came to him and said, my account has become NPA, so now it is your problem. It is no longer my problem because it's become NPA, now you run after me, I don't run after you. So, this is something that the IBC has changed. IBC has changed the relationship between the creditor and the debtor. This is what it has changed. And let me tell you, IBC may have given 2.5 lakh crores through resolutions, but more money has come outside resolutions. And it is the correct thing to do. I'm not saying it should not come. More money should come outside resolutions, outside the process. And we should encourage that money should come outside resolutions. Cases should be admitted, and then it is then that the debtor will enter into a serious negotiation with the creditor. And if he is able to give his dues to the satisfaction of the creditors, we should encourage withdrawal of cases. Another thing that we need to encourage here is mediation. I had called on the President NCLT, and he showed me a case where there was 95 IAs filed. Now, how can any judge take a decision on 95 IAs and then come to resolution within the fixed time? Now, we have to find a way of dealing with these IAs. And large number of people, large number of interested people, large number of stakeholders have a habit of filing IAs. And filing IAs in this case, I think you have to file a fees of just 250 rupees or 1,000 rupees, I think. So filing IAs is the easiest thing to do in IBC. So we have to find ways, we have to jointly find ways sitting with NCLT as to how to deal with these IAs. If in India, if we do not find a way of dealing with these IAs, we will never be able to make IBC a success. So something has to be done about these IAs. Something, I don't know as of now what can be done, but something has to be done as to how to deal with these IAs. Similarly, lot of time is taken in settlement of claims. Something needs to be done in settlement of claims. Now, under IBC, an information utility was created, and I think it was thought of that if all the information would be available with the information utility, and the claims should get out from the should come out from the information utility, but people don't go to the information utility. People submit claims at all times before NCLT. Resolution plan has been submitted, now they file 5 claims. Now what do you expect the judge to do? He has to look at natural justice. Now someone is saying, this is my claim. Now he is faced with a problem. And we have to find solutions to these problems if we want to take IBC forward. So I think I've spoken enough, and I again welcome you all to this conference. I also thank the researchers who have written the papers. I promise them that in IBBI we will go through each paper and look at the recommendations. We will get back to you on several of your papers if we need more information, or if we as to how to implement them. I would again like to thank IIM Ahmedabad for helping us in organizing this conference. Thank you very much.
Thank you, sir, for your insightful thoughts. As you rightly said, the research papers are highlighting key issues, and the suggestions will certainly help us in policy making. Ladies and gentlemen, it is with immense pleasure that now I introduce our esteemed guest of honor, Shirim Rajeshwar Rao. Mr. Rao is currently serving as Deputy Governor of Reserve Bank of India, having a rich experience in regulation, risk monitoring, enforcement, and legal affairs. Sir has spent almost 4 decades at the Reserve Bank of India. Sir, may I please request you to deliver the keynote address?
Thank you. Good morning, everybody. Honorable Minister of State for Corporate Affairs, Shri Rao Inderjit Singh, Shri Rajesh Verma, Secretary, Ministry of Corporate Affairs, Shri Ravi Mittal, Chairman, IBBI, Professor Errol D'Souza, distinguished guests, panelists, researchers, ladies and gentlemen. At the outset, let me express my gratitude to IBBI for inviting me to deliver this address at this conference. This conference quite appropriately focuses on one of the most important facets of a robust financial system, that is resolution of stressed assets. It would not be an understatement if I were to say that India has been witnessing a paradigm shift in the regulatory architecture concerning the resolution of stressed assets over the past few years. The Insolvency and Bankruptcy Code has had a profound impact on the creditor-debtor relationship in India. It's been a bit more than 5 years since the provisions relating to the corporate insolvency resolution process under the code were notified and implemented. And quite appropriately, it provides a window at this point for a stocktake of the progress achieved so far and the expectations about the future. For any lender, the credit risk, that is the possibility of not receiving timely payment of the contracted amount or of the counterparty not honoring its obligation in respect of a credit contract, constitutes a significant risk which needs to be covered by maintaining adequate capital and risk provisions. In principle, a borrower defaults when he is either unable to pay his creditors because of inadequate cash flows from his business, or the market value of his assets falls below the value of his liabilities, which hinders his capability to liquidate his assets and pay off his creditors to ensure that no default takes place. In such a situation, the borrower is said to have become insolvent. Unfortunately, in real-world situations, it's not easy to ascertain whether a borrower has become insolvent till the time the default occurs. Mostly by then, the marketable value of the assets of the borrower would have already fallen below its liabilities. As the liabilities of the borrower are assets of the lender, the inability of the borrower to pay its liabilities would reduce the value of assets of the lender, thereby impacting in turn their ability to repay their creditors, which primarily includes depositors in the case of banks. This is the main reason why the Reserve Bank is interested in timely resolution of stressed assets by the regulated entities. Even where the lender is not a bank, the interconnectedness of the financial system would lead to second-order effects that would adversely impact the financial system. Once a borrower becomes insolvent, the natural instinct of the creditors is to cut their losses by rushing for the biggest possible piece of the remaining pie of marketable assets of the concerned borrower. However, we also need to bear in mind the fact that a state of insolvency does not mean that the future prospects of the borrower are non-existent. In many cases, a judicious rebalancing of debt would suffice to bring it back on track, unless the financial stress is extremely acute. Almost always, a going concern should be more valuable to a creditor than a liquidated company. It is in this context that a comprehensive insolvency resolution legislation assumes importance. An efficient insolvency legislation would be premised normally on 5 pillars. 1, it should prioritize going concern status over liquidation. 2, it should force the creditors to come together and work out a resolution plan that tries to preserve the value by looking at options to keep the company as a going concern. 3, it should ensure a time-bound resolution so that the value deterioration for the creditors of an insolvent exposure is arrested. 4th, it must provide clawback of questionable transactions that may have contributed to the financial stress of the borrower, defaulting borrower. Finally, an effective resolution regime should protect the majority from the minority by forcing a cram-down if the majority decision covers a predefined threshold of approval. In addition to these principles, the resolution framework should also distinguish between the various classes of financial creditors based on the quality of security available to them, since the initial pricing of the credit instrument may have factored in the availability of security, and the lender stands to lose if such security is not reckoned while assessing his share of the resolution value. In the absence of such an accommodation, creditors are likely to demand higher compensation for credit risks that they are taking, thereby increasing the overall credit costs to the economy. While any resolution framework should prioritize preserving the value of the firm at the same time, going concern over liquidation cannot be an absolute preference. In the absence of ease of exit, overall production capacity in an economy will be held hostage to inefficient business ventures and prevent the economy from reaching to its potential if that were so. Thus, an effective insolvency legislation should not shy away from liquidating ventures when they are perceived to be costlier to the society, and that it would be more beneficial to unlock the value for redeployment. Prior to the enactment of the IBC in 2016, India had a plethora of legislations, each having part jurisdiction over the insolvency resolution of a borrower. You had the Sikh Industries Companies Act, you had the debt resolution tribunals, you had the SARFAIC, just to cite a few. While these laws had a positive impact on the resolution of stressed assets in the initial period after the enactment, the improvements tapered off over time. Moreover, the focus of the pre-IBC resolution efforts was more towards preservation of companies and employment, sometimes even at the expense of credit discipline and production efficiency of the economy. As mentioned earlier, timely resolution of stressed assets, especially by deposit-taking institutions, is of key interest to the Reserve Bank. In the absence of a comprehensive insolvency law in place, Reserve Bank had to put in place a series of schemes that emulated desirable features of an insolvency legislation. Thus, the earlier regulations mandated formation of a joint lenders forum which had a similar role to play as the current Committee of Creditors under the IBC. The asset classification standstill was comparable to the moratorium pronounced under the IBC. The requirement of majority decision being binding on the dissenting creditors was the regulatory equivalent of a statutory cram-down under the IBC. However, the statutory powers available to the Reserve Bank for resolution of stressed assets in the financial system is limited to entities regulated by the Reserve Bank, whereas unraveling of the complex web of financial contracts and rewriting them in consonance with the income-generating capability of the insolvent borrower debtor requires a comprehensive statutory framework with sweeping powers over the various types of creditors. Though well-intentioned, the schemes designed by RBI sometimes became a channel for the lenders to delay recognition of financial stress in the borrowers by postponing the actual asset classification. This paradigm has shifted under the IBC. The enactment of IBC in 2016 resulted in a paradigm shift in the efforts towards resolution of stressed assets in the financial system. The code marked a radical departure from the prevalent approaches that embraced the creditor in control model as against the debtor in possession model that had failed to produce any tangible improvements in the credit discipline in the country. Thus, the code fundamentally resets the power balance between the debtors and creditors in face of a default by the debtor. This approach is economically sound since creditors only have the contractually agreed share of the economic surplus created by a borrower, with the rest of the surplus going to the equity holders without any limits till a default occurs. At that point, the equity holders are protected by limited liability while the creditors stand to lose up to the entirety of their exposure to the insolvent debtor. In a single stroke, the code removed the divine right of the promoters to continue in the saddle, as has been observed by the Honorable Supreme Court, restoring the interests of other stakeholders, especially the creditors. The insertion of Section 29A provided further fillip to the notion that an insolvent debtor has to be protected from its own management, if required for the maximization of value from the debtor to the society as a whole. Thus, for the first time, the promoters faced with the possibility of losing control of their respective companies if financial stress is not addressed in a timely and in a comprehensive manner. The code also establishes the Committee of Creditors as a public institution with the paramount responsibility of ensuring maximization of value for stakeholders during the resolution of the corporate debtor. That the Committee of Creditors, which consists only of financial creditors, has to treat the individual interests as subservient to the larger public interest is a unique feature of the code as compared to similar legislations elsewhere. The code also enhanced the negotiating power of the operational creditors by allowing them to make applications for initiating the CIRP in respect of operational debtors who are in default. Of the total CIRP cases as of December 31st, 2021, more than 51% of the cases have been filed by the operational creditors. Such cases had a higher proportion of withdrawals as well, at over 50%, constituting 71% of the total withdrawal cases, indicating that filing the insolvency proceedings as a negotiating tactic appears to be working for the operational creditors. There have been some concerns about the high levels of haircuts that the creditors have had to take in the resolutions that happened under IBC. In these discussions, we missed the fact that a public auction-based resolution model, the extent of haircut represents the discount the market demands in continuing to invest in an insolvent borrower. Since significant value deterioration may have happened to the assets of the insolvent borrower, comparison with the outstanding amount may not be a reasonable indicator to evaluate the effectiveness of the resolution. Rather, the resolution values must be compared with the next best alternative for the creditors, which in this case is liquidation. Of the CIRP cases that have yielded resolution, financial creditors have been able to realize 166% in comparison to the liquidation value of debtors, indicating that creditors have been better off than the next logical outcome. Another often ignored aspect relating to the impact of the code is the credible threat of insolvency. A key metric for assessing CIRP applications that are withdrawn before admission. Till December 21, 19,800 applications for initiation of CIRP have had a total underlying default of about Rs 6.1 lakh crores were resolved before admission. In the absence of the code, it's most likely that these defaults would have lingered on for much longer, resulting in value destruction. Coming to the role of RBI vis-a-vis the IBC, what I would like to say is that even though RBI does not have a direct role to play in the CIRP process under the code, the RBI regulated entities are an important stakeholder for an effective bankruptcy law. With the increased levels of credit disintermediation, IBC becomes the most preferred tool available for a comprehensive resolution of debtors. The fact that the code can be leveraged to give an impetus to resolution of long-standing stress was recognized almost immediately after the notification of the provisions relating to CIRP under the code. This culminated in the Banking Regulation Amendment Act 2017, which vested powers on the Reserve Bank to issue directions to banks for referring specific default cases for resolution under IBC. Under these powers, as it's now widely known, RBI issued directions in June 2017 to the banks to initiate insolvency proceedings under the IBC in respect of the 12 largest debtors in the financial system, which were classified as NPA. These were followed by another set of directions in August 2017, where the banks were directed to implement time-bound resolution plans in respect of another 29 corporate borrowers in default, failing which insolvency proceedings had to be initiated against them. The enactment of IBC and the default event being the trigger for initiating insolvency proceedings under the statute forced a rethink of the regulatory trigger for mandatory resolution as well. We replaced all the prevailing schemes for restructuring with a simple and harmonized prudential framework for resolution of stressed assets in June 2019, which enshrined the following fundamental principles. 1. Early recognition and reporting of default in respect of large borrowers by banks, FIs and NBFCs. Complete discretion to lenders with regard to design and implementation of a resolution plan, subject to specified timelines and independent credit evaluation. A system of disincentives in the form of additional provisioning for delay in implementation of resolution plan or initiation of insolvency proceedings. Withdrawal of asset classification dispensation on restructuring. Future upgrades to be contingent on a meaningful demonstration of satisfactory performance for a reasonable period. Then, for the purpose of restructuring, the definition of financial difficulty was aligned with the guidelines issued by the Basel Committee on Banking Supervision. Signing of intercreditor agreements by all lenders was made mandatory, which will provide for majority decision making in the process. The approach of the Reserve Bank towards resolution of stressed assets outside IBC has been to incentivize timely initiation of resolution efforts, proper recognition of increased credit risk to lenders on account of concessions granted to them in the form of debt recast, and the borrowers are required to demonstrate that concessions have improved their viability by performing satisfactorily on their debt obligations during a reasonable period subsequent to the debt recast. A modern insolvency law such as the IBC deserves support and patience from all stakeholders, and attitude towards the new piece of law should not be influenced merely by losses materialized in respect of resolution of assets that have been stressed for a long period of time. At the same time, it is necessary to continue improving the regulatory regime for out-of-court resolutions through suitable harmonization of the regimes across the various categories of regulated entities, as well as periodic review of the framework to keep pace with the changes in the economy and the financial system. In order to strengthen the code further, we need to work on the following 4 dimensions. 1. IBC should not be the first resort for resorting to litigation. A comprehensive law like IBC is often viewed as a last resort by lenders, should be viewed as a last resort, an avenue that needs to be explored after exhausting all alternatives. However, this view stems from a lack of comprehensive vision for the future of a beleaguered borrower. Various classes of lenders are governed by a disjoint set of out-of-court resolution frameworks that apply separately to each class of lenders. Without participation of all lenders, any effort towards resolution is likely to be incomplete and would be mere postponement of an inevitable reckoning. The time lost in pursuit of such incomplete resolutions is likely to compound the eventual losses to the creditors and increase the cost to the financial system. Perhaps this is an issue which the researchers could ponder on. What is the average time taken between default by a borrower and the eventual filing of application for the insolvency resolution by creditors? It should also be interesting to see the relationship between such filing delays and the value deterioration that the creditors are required to recognize subsequently. Another disconcerting aspect is the time taken between filing of an insolvency application and the eventual admission of the application. The code prescribes a period of 14 days. However, in reality, the admissions take much longer time than that. A consultation paper released by IBBI in April 22 notes that the average time taken for admission of an insolvency application has increased from 468 days in 2021 to 650 days in 21-22. This is much longer than the stipulated deadlines for completion of a CIRP under the code. Such delays are likely to reduce the efficiency of the IBC as a comprehensive bankruptcy law and may weaken the creditor rights and ease of exit for bankrupt borrowers. there should be an increase in the coverage of pre-pack resolutions. Like any piece of legislation, IBC also needs to evolve with the changing economic fundamentals. The present review architecture in the form of a standing committee on insolvency law has been doing an exemplary job of ensuring the same, guided by the regulatory capabilities of the IBBI. The new dimensions being introduced to the IBC, such as the new module of the pre-packed insolvency resolution process, the PPIRP, or the pre-packs, which combines the best of out-of-court resolution and the judicial finality of a resolution plan approved by an adjudicating authority, are welcome. Even though the pre-packs have been presently allowed only for the borrowers that are classified as micro, small, and medium enterprises, we could envision the pre-packs as a natural complement to the prudential framework of the RBI. It would be worthwhile to consider extending the pre-packs to all borrowers. Finally, another dimension which needs attention is group resolution, one in which the resolution of borrowers belonging to the same corporate group is undertaken together. We saw an example of this during the resolution of the Videocon group. However, the same was put in place through discretionary powers available to the adjudicating authority rather than through a feature of the code. Such a process is especially vital in an economy like India, where traditionally credit contracts have been embedded with cross obligations and credit mitigating covers provided by parent and group companies of a borrower. In such a system, the default by a borrower is likely to spur cross defaults by group companies, thereby increasing the overall credit risk to the financial system. Deepening the credit risk markets in India is a necessary condition to take the financial system to the next level of sophistication. Reserve Bank has been taking many steps towards this in the recent times. The guidelines covering transfer of loan exposures have been reviewed and harmonized across all lending institutions. The secondary market for stressed loans has been thrown open to transferees who are not regulated by the Reserve Bank. The recommendations on the Committee on Development of Housing Finance Securitization Market and the Task Force on Development of Secondary Market for Corporate Loans are being implemented in phases. One of the major recommendations of the latter, the Self-Regulatory Organization for Secondary Market for Corporate Loans, has been implemented with the setting up of the Secondary Loan Market Association. RBI is also exploring further avenues to deepen the credit risk markets by exploring the feasibility of allowing additional type of securitizations. At the same time, we would expect the lenders do not wait for a default by the borrower to initiate resolution processes. The lenders should combine prudent risk pricing of their exposure with ongoing monitoring of the exposure and maintenance of adequate capital and risk provisions. Additionally, since the point at which a counterparty has become insolvent cannot be pinpointed accurately, the risk management practices of the lenders have to be sophisticated enough to capture the changes in risk factors that may affect the safety of the said credit exposure. Lenders should also perform periodic stress tests to estimate possible trajectories that the credit exposure is likely to take and calibrate their responses accordingly. Ultimately, they are responsible for safeguarding their own interests and the interests of their stakeholders. To sum up, we have come a long way in improving the credit discipline in the country. However, as with any public policy, it's always a work in progress with scope for improvement at any point in time. RBI will continue to engage with the stakeholders to improve the resolution frameworks and adopt more sophisticated and updated risk management practices to take care of systemic concerns that arise from the activities of the various credit intermediaries. With this perspective in mind, I wish that this conference generates very insightful debates on the various issues which have been highlighted and will guide us in the times to come. Thank you.
Thank you, sir, for your insightful views highlighting the interplay of regulatory provisions by RBI and IBBI in resolving the financial stress. Ladies and gentlemen, may I now introduce our guest of honor, Shirim Rajeshwar Rao, Secretary, Ministry of Corporate Affairs. Shri Verma has held several key positions in his illustrious career as a civil servant. He is a 1987 batch Indian Administrative Service Officer. At the Secretary of Ministry of Corporate Affairs, he is leading the policy discourse for the effective and efficient implementation of the Insolvency and Bankruptcy Code. He has steered major amendments in the law to address various challenges arising during the implementation of the code. We extend a warm welcome to you, sir, and we request you to kindly address the audience.
Honorable Minister of State for Corporate Affairs, Shri Rao Inderjeet Singh Ji, Shri Rajeshwar Rao, Deputy Governor RBI, Shri Ravi Mittal, Chairperson of IBBI, Professor Errol D'Souza, Director IIM, Ahmedabad, members of the Governing Board of IBBI, members of NCLT, researchers, professionals, officials of IBBI and Ministry of Corporate Affairs, faculty of IIM, Ahmedabad, ladies and gentlemen. It gives me immense pleasure to be addressing this research conference on a very topical subject of insolvency and bankruptcy. An economy prospers when its limited resources are optimally utilized. This happens when businesses have maximum possible freedom to reshuffle resources among alternative uses continuously and seamlessly. Freedom unleashes and aids in realization of the full potential of every business and every resource in the economy. With this understanding, among the primary duties of the state, therefore, is to provide right institutional milieu that promotes and protects economic freedom and regulates such freedom only to address market failures. According to Nobel laureate Professor Joseph Stiglitz, anybody who knows about capitalism knows that bankruptcy is an essential part of capitalism. Hence, one of the important economic freedoms that is required for businesses to flourish and vacate the space when they are not doing well for reasons beyond their control is the freedom to exit businesses in a dignified manner. The journey of reforming the existing institutional structure to address this issue of providing freedom of exit to the firms started with the enactment of the Insolvency and Bankruptcy Code in 2016. Government has been proactively responding to further strengthen the insolvency framework and make the processes under the code more efficient and effective by resolving issues encountered during its implementation. As the former President of India, Dr. APJ Abdul Kalam put it, excellence is a continuous process and not an accident. The code has been amended 6 times till now. Major amendments included preventing undesirable persons from taking over the corporate debtor, Section 29A, which was alluded to. Recognizing home buyers as financial creditors, requiring completion of corporate insolvency process in a time-bound manner, which is a very important key feature of this whole law, ensuring going concern status of the corporate debtors by providing that the licenses and permits shall continue during the insolvency process, granting immunity to successful resolution applicants from previous misdeeds, Section 32A, and most recently, providing a simplified prepackaged insolvency resolution framework for the MSMEs. Now, of course, the demand is to extend it to other corporate debtors. The code is hailed as one of the most important economic reforms of recent times, which has been guided by government's vision of making doing business easy in the country. I am sure this august audience is well aware about the outcomes of the code. However, at the risk of sounding repetitive, I would still like to draw your attention to certain key takeaways from the implementation of this code. As a progressive economic legislation, the code has shifted the balance of power from the debtor to the creditors. It has inculcated a sense of financial discipline and brought about greater certainty of outcomes of the process of insolvency resolution. The law, being preventive in nature, is bringing about a cultural shift in the dynamics between lenders and borrowers, and promoters and creditors. the first signs of distress are now perceived as an early warning for management to take corrective action to avoid defaults. The code is emerging as a behavioral law, drawing various stakeholders of the entity in distress to work together in a non-adversarial manner towards the laid down objectives of the law. This is also proven by the fact, also mentioned by Mr. Rajeshwar Rao, that more than 20,000 applications for initiation of the CIRP under the code involving an amount of more than rupees 6 lakh crore have been withdrawn before admission. By providing a clean and dignified exit, the code is aiming to inculcate an entrepreneurial culture which recognizes failures rather than condemning it. Till March 22, 1,219 corporate debtors have opted to exit their business efforts voluntarily. So, code provides for voluntary liquidation. 317 of them have successfully exited, and till March 22, 5,253 applications which were admitted for CIRP, 731 applications were closed either on review or settlement, 586 applications were withdrawn under section 12A. One of the speakers was mentioning about that. 480 corporate debtors are on their way of revival with the approved resolution plans, while liquidation has been ordered for 1,608 entities after due process. Many of these cases, in fact the liquidation cases, were long pending in the erstwhile BIFR process or were defunct, so that the economic value had already immensely deteriorated before they came for the under the fold of IBC. The 480 CDs, corporate debtors which have revived, they owed about 7.5 lakh crore to the creditors. The assets of these debtors were valued at only 1.3 lakh crore when they came into the IBC. The realizable value for creditors through the resolution clause was 2.33 lakh crore. So, the liquidation value was 1.3 lakh crore, the realizable value was 2.3 lakh crore. So, it is almost 178% of the liquidation value. Though of the admitted claim, the realizable amount was 31% only. The creditors made a considered choice of reviving these companies, keeping in mind the long-term benefits in rescuing them rather than short-term recovery of the loans. With these numbers and quantitative outcomes at the back of our mind, I wish to dwell upon the course that the law can take in future, guided by research and analysis by the scholars and experts such as all of you present here. However, before I do that, let me recognize that research efforts that have been undertaken are ongoing in the area of insolvency law in India. Several initiatives have been taken by government and the IBBI for promoting research in the area of insolvency law, and these are leading to the policy discourse. The Ministry of Corporate Affairs has been releasing discussion papers proposing reforms in the insolvency law from time to time. We seek to steer the policy discourse in the area of insolvency and crowdsource ideas to make the reform inclusive, dynamic, and grounded. Most recently, the discussion papers on certain amendments to the code and introducing provisions relating to cross-border insolvency resolution were floated, eliciting comments from the general public. Since data is one of the essential ingredients to any research, IBBI has been collating a dynamic data set relating to processes and outcomes under the IBC to encourage evidence-based research in the insolvency space. It has also been promoting research and publication through insolvency professional agencies and academics. The IBBI has also been encouraging the submission of research papers and working papers on various issues and processes through its various research initiatives, such as the IBBI Research Initiative and Working Paper Series. The envisaged IBC 21 electronic platform would improve data management and data dissemination on insolvency. It would essentially support easier access and use of data that facilitates meaningful policy-oriented research. Legal research on the emerging jurisprudence from code is being undertaken by the stakeholders. There is now a growing body of literature that aims to address the gaps between theoretical aspects of insolvency law and its practice and impact on the ground. Evidence from the qualitative and quantitative research can be used by the experts for designing, improving, and testing government policy. Empirical research will aid policymakers in applying theory to practice and achieving real world outcomes. Let me now turn to what I think should be the direction of research and analysis in the area of insolvency law in India. The government and the regulator IBBI have been constantly course correcting and responding to any areas of gap in the code and associated rules and regulations to ensure that it works towards meeting the objectives enshrined in the preamble itself. While we are working with agility as regards implementation of the provisions of the code based on the stakeholder consultation with the subject experts, going forward, it is important that we have a rigorous and evidence-based research to public policy. Policies that are not backed by appropriate evidence, research analysis may not yield the desired outcomes. The IBC is one such economic legislation whose origins lay in the sound research and evidence as put together by the Bankruptcy Law Reforms Committee in its report. The IBC has since then evolved through various amendments that responded to the evidence from the ground. As I had mentioned earlier, Ministry of Corporate Affairs comes out with the discussion papers before taking a policy decision. Our experience shows that we get inputs mostly from law experts and practitioners in this area. We would like to encourage researchers, academicians, and economic experts to provide inputs for further policy directions to the code to make it more vibrant and inclusive. The first area which I feel requires in-depth research is to document and peer review the journey of IBC till now in terms of where we are as compared to where other jurisdictions were at this relatively early stage of the enactment of a modern insolvency law in their respective jurisdictions. It was not that in the early days the countries did not face difficulties and challenges and had not course corrected. Policy observers often end up comparing our 5-year-old regime with the regimes of mature economies where the modern insolvency laws have been in place for a very long time. Some critics have observed that the IBC has led to more liquidations than resolutions, and large haircuts are being taken by the creditors in a resolution process. It would be instructive to examine outcomes of Indian law with those of other jurisdictions at the early stages of implementation of reforms in those countries. There is presently no standard framework to track outcomes of insolvency and bankruptcy regimes in various jurisdictions other than the World Bank doing business report indicators, which too has been also discontinued recently. One of the IBBI working groups has dwelt precisely on this issue and is providing a starting point of a framework to evaluate the outcomes of IBC. I would encourage researchers to take this forward and publish work on the salient features and results of IBC so that the Indian regime becomes a model for other countries to learn from. Topics of relevance in this regard may be how the admission and disposal processes are handled by the courts, how are avoidance transactions dealt with in a time-bound manner, what should be the monitoring framework for insolvency and bankruptcy professionals assisting in the insolvency resolution and bankruptcy framework, how the whole process monitored, what kind of granular data is available to measure the outcomes of the processes. The list can be practically endless, as we can have learnings from each and every aspect of the process from other countries. It is crucial to continue to study the impact of insolvency framework created by the IBC and conduct a SWOT analysis, investigate its strengths, weaknesses, opportunities, and threats on a regular basis. Research can provide pointers on how the legislative framework may need to adapt to meet future goals and challenges. COVID-19 pandemic led countries around the globe to tweak their insolvency laws to save businesses from closing down due to fallout of the unprecedented crisis. Government of India too amended the code by suspending the initiation of the corporate insolvency resolution process for a period of 1 year to prevent viable companies from being pushed into insolvency proceeding for their failure to service debt obligations on account of pandemic-induced stress. The threshold of default for initiation of CIRP was also revised from rupees 1 lakh to 1 crore. A number of other measures were taken as a part of Atmanirbhar Bharat package to help businesses and individuals in distress due to a once-in-a-lifetime event of global pandemic. Preparing the ground now for the post-pandemic world requires focus on saving businesses which provide bread and butter to survive. This is also essential for long-term economic resilience and growth. How should the insolvency law respond to the new realities emerging in the post-COVID-19 economic environment? How can the law be further streamlined to ensure efficient and effective resolution of financial stress of the corporates? What more can be done for the MSMEs are some of the questions that research can help answer and provide policy guidance. Let me conclude by suggesting that there is a need to develop a research culture within the regulators such as IBBI with a critical mass of in-house research strengthened by establishing links with academic and research bodies such as IIM Ahmedabad. I am pleased to see these links here today at this conference and hope to see many more such collaborations. I am confident that this research conference spread over 2 days and with presentation of about 40 multidisciplinary research papers will ask the right questions and present answers, backed by evidence that will enhance our understanding of the IBC, its impact on the economy and society, and most importantly, the way forward for this law. I note that the papers being presented at this conference are on varied topics around the insolvency and bankruptcy framework in the country, such as the behavioral aspects of the law, application of mediation in corporate insolvency situations, cross-border insolvency law for the country, predicting bankruptcy for MSMEs, interim finance ecosystem of the country. These are all topics of interest and will help mold the future of the modern insolvency law. I wish the conference the very best. Thank you.
Thank you, sir, for your insightful views on the journey of the code, emerging jurisprudence, and the outcomes of the code, and also for highlighting the role that research plays in policymaking. Ladies and gentlemen, it is indeed my privilege to introduce our esteemed chief guest for the occasion, Shri Rao Inderjit Singh. Shri Singh is a Minister of State with independent charge of the Ministry of Statistics and Program Implementation, Minister of State independent charge of the Ministry of Planning, and Minister of State in the Ministry of Corporate Affairs. Shri Singh is a Member of Parliament in the 17th Lok Sabha and has been active in public service for over 4 decades. Shri Singh is the descendant of Shri Raja Rao Tularam, a freedom fighter of India's first war of independence in 1857. He is an international shooter and won various medals for our nation. He also holds national record twice at the National Shooting Championship. Sir, we are delighted to have you here and we request you to kindly address the audience.
Shri Rajesh Verma, Secretary, Corporate Affairs. Shri Ravi Mittal, Chairperson, IBBI. Professor Errol D'Souza, Director, IIM Ahmedabad. Mr. Rajeshwar Rao, Deputy Governor, RBI. Mr. Sudhakar Shukla, full-time member. Other members of the governing board of the IBBI, stakeholders who have joined online, ladies and gentlemen, please bear with me. I'm not as hands-on as some of the speakers before me, so I too would like to read out my speech. I shall attempt to be brief. To begin with, I would like to thank both IBBI and IIM Ahmedabad for having me here, and it is a great honor to be part of this prestigious conference. I am certain that this conference will bring new perspectives to the ever-evolving law of insolvency and bankruptcy and highlight the unparalleled progress that has been made so far. The Code has seen many challenges and has adapted to the realities of the Indian economy. Supporting the growing Indian economy in the early 2000s, the credit market also expanded at that time. An unintended consequence of credit expansion is the possibility of default. Against the backdrop of looming NPA crisis and the twin balance sheet problem of 2016, the government enacted the Insolvency and Bankruptcy Code. The journey of this landmark legislation has been marked by important policy and institutional developments, including 6 amendments to the code, validation and learnings, achieving institutional milestones, awareness building, and capacity building for all stakeholders. The code has established well-functioning institutions and regulations. Through efficient insolvency resolution procedures, the code has enabled banks to resolve their NPAs after having peaked at around 11.6% in March 2018. Due to the increased pace at which NPAs were recognized, the gross non-performing asset ratio across all scheduled commercial banks has come down to 6.9% in September 2021. As reported by the RBI, the IBC has continued to be one of the major modes of resolution of NPAs by banks since its enactment, vis-à-vis scrutinization and reconstruction of financial assets and enforcement of securities interest, debt recovery tribunals, lok adalats, etc. One of the most remarkable achievements of the code has been the significant behavioral change that has come about amongst the debtors and creditors alike. It has also been conducive to the budding entrepreneurs, stirring animal spirits, and opening up credit channels for investment. The startup ecosystem got a major boost from the IBC as the code has improved the business climate in the country by making it easier for enterprises to exit in case of difficulties. The IBC has provided the required market price discovery process, which gives greater confidence to the lenders. The code also assumed greater significance post-COVID-19 pandemic. Adapting to the new normal, swift actions by the government in response to the pandemic prevented many viable firms from being prematurely pushed into insolvency. This saved both lives and livelihoods. The IBC has, till now, evolved and attuned to every emerging market requirement. With the enactment of the code, India has witnessed the birth of 2 professions, namely insolvency profession and valuation profession. The code has opened unlimited possibilities of resolution, including merger, amalgamation, and restructuring of any kind, which often requires professional help. This has expanded the market of services of advocates, accountants, and other professionals. While the code has had a remarkable journey so far going forward, evolving with changing scenarios will be crucial. Cross-border insolvency is the buzzword in the insolvency and bankruptcy sphere in India since the government released a draft chapter on cross-border insolvency. The proposed cross-border framework will govern all applications seeking recognition of foreign insolvency proceedings as well as applications from foreign jurisdictions seeking cooperation in Indian jurisdiction. This landmark step is expected to redefine India's relations with the rest of the world, furthering the use of the recently introduced pre-packaged insolvency resolution process for corporate MSMEs will allow us to analyze the process and address emerging challenges, if any, in this sphere, as India experiments with the first of its kind pre-pack framework that is unique and tailor-made as per the defining needs of our country. Like everything else, this reform too should keep evolving. This means only one thing, that is embracing the future, such as group enterprise, insolvency, individual insolvency, etc. Resolution of the financial service providers under the code is a welcome development for the IBC. It needs careful evaluation going forward, given the subsequent impact it will have on the entire ecosystem, touching the economic, social, as well as the legal fabric of the country and going beyond just a few specified stakeholders. Streamlining the CIRP and liquidation process will further remain a key priority going forward to consolidate the progress already made and secure future gains to the economy. To ensure timely admission and key responsibilities of the Committee of Creditors, it is an appropriate time to adopt a code of conduct for them to further strengthen the institution. As IBC evolves further, it could become the most potent instrument in driving good credit behavior and ethical business practices amongst borrowers and proactive, responsible behavior among lenders, proving to be a boon for the economy and to the nation. We must learn from the outcomes and strengthen the code so that the law is robust over time. With a view to charter a credible way forward with effective participation of academicians, policymakers, researchers, and other stakeholders alike, the government has been making concerted efforts to build discourse around critical aspects and best practices webbed around the insolvency space in the country. The IIM Ahmedabad is one of the most prestigious institutions of India, and rightly so. They and IBBI have joined hands to hold this research conference. I would like to congratulate all the participants for being selected to be a part of this prestigious conference. The knowledge shared over the next 2 days will go on to stir many minds that will be fundamental in shaping the future trajectory of the IBC. My good wishes to all you participants.
Thank you, sir, for providing insights on how the code is future ready and how the code has embraced the economic reality so far. Ladies and gentlemen, may I now request Professor Errol D'Souza, IIM Ahmedabad, to present a small memento as a token of our gratitude to our esteemed guest on the dais. May I request Shri Rao Inderjit Singh, Minister of State Corporate Affairs, to kindly accept the memento. May I request Shri Rajeshwar Rao to kindly accept the memento. May I request Shri M. Rajeshwar Rao, Deputy Governor, RBI, to kindly accept the memento. May I request Shri Ravi Mittal, Chairperson, IBBI, to kindly accept the memento. May I request Shri Sudhakar Shukla, WTM IBBI, to kindly accept the memento. May I now request Professor M.P. Ram Mohan, IIM Ahmedabad, to present the memento to Professor Errol D'Souza. Thank you, dear dignitaries. Ladies and gentlemen, may I now introduce the whole-time member IBBI, Shri Sudhakar Shukla. Mr. Shukla has been with the IBBI as a whole-time member for more than 2 years. Sir is an Indian Economic Service Officer, having an illustrious career in various ministries. Sir has contributed in core policy matters. Sir, may I please request you to deliver the vote of thanks.
Ladies and gentlemen, I rise to podium to express my deep sense of gratitude, not only to the dignitaries present on the dais, but all of you who have made the journey of IBC so credible. Not only people and researchers present here in this hall, we have 2 more halls adjoining where some of our colleagues are listening to this live podcast, basically. So thanks to them also for joining us. And online we have around 1,000 plus people who have joined this event live. So there is a louder message that IBC has arrived and it's maturing with time. On behalf of IIM, Ahmedabad and IBBI, and esteemed partners of Mishra Center of Financial Markets and Economy, IIM, NSE, SBI, BSE Investor Protection Fund, and NISM, it is my proud privilege to express my sense of gratitude to Honorable Minister, who has taken his busy schedule some time out of it and came here to bless the conference, and he gave his thought-provoking message. And his message was very clear that this fascinating journey has just begun, and there is no scope for stagnating at the peak. We may think peak has arrived, but we have to work overnight to see that our goals are redefined every day, every moment. So thank you, sir, for being with us and giving the keynote address. My thanks are also due to Secretary MCA, and as famous Daniel Moran says that you can have data without information, but you cannot have information without data. So he rightly stressed that we need to have some kind of format, because the goalpost has shifted from output to outcomes. So measuring outcomes is not an easy task. You have to have a path-breaking standards to achieve the kind of glory which is attached with the outcome assessment. So that is a clear message that we have to work a lot. World Bank has discontinued its ease of doing business index, but surely under your leadership we would be trying to have some kind of outcome indexing being done as part of IBBI, also in partnership with IIM. We are sure we will be able to do and have a kind of parameters involved which are much beyond what the scope of World Bank Index was providing. So thank you, sir, for this message, and that is the work in progress. We have to do a lot on that part. I also thank Deputy Governor RBI for excellent exposure to what RBI and IBBI relationship is all about. We proudly remember the 12 big CDs, big industries which were basically transferred literally by RBI to be settled in under the IBC processes, and that kick-started the whole journey. Apart from that, Creditor Information Companies Act was basically amended to see that information utility gets all the information. And also our joint experimentation with FISP is showing some credible results on ground. So moving forward, we have noted your concerns and what we have to do in future, but in taking this partnership ahead, I thought we have to see that Sudarshan Sen committee report on ARCs is out, and we are waiting the clearance from RBI on that. And also we are waiting to have some credible and intense partnership on code of conduct for the COC members. So we have evolved, but we will be looking forward for some hand-holding, some support in moving forward. So that is a wish list. We will be working together with RBI all the time. I'm also thanks Professor D'Souza. It was welcome speech. I thought we have noted your concerns about shareholders' right, and sometimes we meet with SEBI also with similar kind of concerns that at least minority shareholders should be covered within the ambit of IBC so that they can get due reflection in the processes. So, but Section 53 and Section 29A are very clear what we intend to do, but definitely we can see that what kind of changes in times to come would be possible. We look forward, sir, for continued engagement as a knowledge partner. I am Ahmedabad being the knowledge partner with IBBI, sir. Chairperson IBBI was very candid in his assertion. I thought he is very clear that in what Edward Deming says, if you do not know the how to ask a right question, you will discover nothing. So at least when we come in the morning, some questions, right questions are ready to be deliberated whole day to see that how processes are to be reformed, because 5-6 years we were consolidating the reform processes, and now we are trying to see that these reform processes should be efficient in delivery. So this shift in paradigm we are witnessing right now under the new leadership. Thank you very much, sir, for your speech. And last, I just wanted to also thank my colleagues, researchers, basically, who have joined from 4 countries, sir. Basically, we have from UK and from US and Mauritius, Argentina. So 4 countries are represented here. We welcome them also, because that it makes a truly a recognition that this is an international conference, and also the 40 researchers which are presenting. We are seeing 40 today, but when we started in December, we got around 65 papers, and there was a rigorous scrutiny and third-party evaluation whether these papers graduate or worth for this kind of workshop to be presented. So out of 65, 40 were selected, and they are here, and we will be looking forward for the key messages. So thank you very much. I thought thanks to press also for being extensively covering this event, and we hope tomorrow's newspaper we will also see some of the reflection what key messages have come out of this opening session. I also thank the team who worked very tirelessly. I think Professor Ram Mohanji and Ritesh from IBBI, ED. That team entirely actually was pulling off, and last 15 days I have seen that struggling, that who is arriving, who is not arriving, who is the substitute. So lot of effort has gone into to see that this show begins with a grand opening. Thank you all for being here. Thank you.
Thank you, sir, for your kind address. Ladies and gentlemen, may I now request all to kindly join us for tea outside this auditorium. Thank you.
Unfortunately, that nobody is there from industry.
Hello.
Welcome back, everyone. Ladies and gentlemen, we will now proceed for the first panel discussion of the event on the theme Banking and Industry Perspective on IBC. For this, I would like to introduce the panelist of the day, Shri M.B. Gosavi, Honorable Member Judicial, National Company Law Tribunal, Ahmedabad Bench, Shri B. Sriram, former Managing Director and CEO, IDBI Bank, and part-time member of Governing Board of IBBI, Shri Shardul Shroff, Chairman, Shardul Amarchand Mangaldas and Company, Shri Sunil Mehta, Chief Executive, Indian Banks Association, Shri Partha De, Senior General Manager, ICICI Bank. So we look forward to hearing from you.
Thank you. Good morning, everyone. All scholars, my honorable panel members. We are speaking about banking and industry perspective on IBC. In fact, we were just speaking that someone should be from industrial field ought to have been here because it could have been more fruitful. With that as is may. In fact, I will give keynote address within 5 to 10 minutes, and then I will throw the subject for discussion, the points therein. I must confess that I am not good orator. Otherwise also, if we judges are paid for listening and not for speaking, as you know. Because in the court, professional and advocates speak, we hear. In a society, we give some orders and society speaks, media speaks. We have no role to speak there. And in home, it is our experience that we have very less role to speak even at home. So speaking is not my area. Still, I will give some few points for deliberation. In fact, this topic, I don't know why I have been chosen as a chairperson here, because topic is perspective, banker's perspective, industrialist's perspective about the insolvency and bankruptcy code. In fact, I being adjudicating authority under IBC, exactly I do the same job that banker's perspective before me, the industrialist or corporate debtor's perspective before me about entire material placed, and I have to decide whose perspective is correct. And so, as far as my speaking is concerned, that way may not be having much relevance, this matter is concerned. Insolvency and Bankruptcy Code 2016 is, that way it is very welfare legislation brought about, because it is basically meant to make stand the corporate debtor on its own feet. I will be giving, I wanted to impress that whether default committed by person can be said to that person is insolvent. Default can be for any reason, but thereby now we have taken away that. Formerly, when matters were being considered under the liquidation in winding up proceeding, there was a specific finding has to be given that now person is or industry is insolvent, not able to pay. But here, only one default, that too more than 1 crore, we have to declare that entire empire is insolvent. Whether some changes are required to this. Secondly, that 1 crore default amount is fixed 1 crore as per section 4 IBC. The industry worth more than 10,000 crore could not pay for 1 crore for number of reasons, and that to operational creditor, service provider. There are number of reasons. They could not have raised any dispute. Whether we should push that to insolvency, and we should suspend the board of directors who has set up that empire by burning the blood. That also we have to consider, because one of the objects of the insolvency is to promote the entrepreneurship. to enhance the credit rating, that too in time-bound manner. While doing so, we have to balance the interest of all stakeholders, and everything has to be done within maximum period of 330 days. When we speak about perspective of bankers is concerned, it is interesting to note that how implementation of IBC 2016 has impacted banking and finance business. Reserve Bank very recently, the apex body controlling banking, has advised time and again to the bankers, you don't wait for specific instructions, approach NCLT or adjudicating authority as early as possible, because it is our experience that time, the value of the assets get reduced because of lapse of time. RBI in a report has noted the trend and progress in banking industry and said that lenders should use IBC to maintain the quality of their books. It is the experience of banks that by taking route of IBC, Insolvency and Bankruptcy Code, it had helped them to clean up their balance sheet, at least to some extent. The practice of dragging lenders to the court to delay the payments of outstanding loan is slowly coming down. That change has been occurred now. That is, we could experience that. And now India has become more attractive an investment destination. The framework of IBC has instilled the credit culture in borrowers. The hundreds of industrialists and borrowers have come forward voluntarily for settling the outstanding loan extent of $40 billion in order to avoid danger of being dragged under the IBC. Now it must be said that it is a deterrent effect of this law as far as business houses are concerned. In this keynote address, I will give honorable panel members some points, whether they to deliberate upon, whether the Insolvency and Bankruptcy Code provide quick resolution of stressed assets because of corporate insolvency resolution process is a time-bound program for maximum 330 days. As against restructuring scheme provided by RBI in form of SDR, etc., was being used for avoiding downgrading rather than resolving the distress. What is what we should think about this? Second, whether the IBC acts as an instrument to drive the banks to refer specific cases for default or resolution, and what is the success rate as far as banks are concerned? Whether Insolvency and Bankruptcy Code brought about a change in equation that earlier recovery mechanism was a debtor-centric and now it has become a creditor-centric, which has been internationally accepted in insolvency process, whether we have succeeded in achieving this. Fourth, Insolvency and Bankruptcy Code provides both creditors and debtor power to initiate proceeding under IBC 2016. The formation of Insolvency and Bankruptcy Code 2016 demarcate judicial aspect and commercial aspect clearly. It has narrowed down the adjudicating authority's role to facilitate. Role of adjudicating authority is to only facilitate the due process of law. It has no role to decide controversies arising out of, because it is for the committee of creditors and other stakeholders to decide. Now, inclusion of non-banking financial institution in Insolvency and Bankruptcy Code has provided such a large creditors the route of insolvency resolution of stress assets, because earlier they have to take only route of liquidation or winding up. There was no other route. In fact, report of review committee of RBI of working assets of reconstructing the companies has made recommendation that assets reconstruction companies should be allowed to take part in IBC proceeding, either directly or providing some other ways. It has been revealed from the study data collected from ARC's performance that recovery rate is encouraging one. It is so because under SARFAESI Act, I suppose section 2 subsection 10 says that assets reconstruction company cannot do any other business, that is putting the plan, etc. That has to be corrected too. Insolvency and Bankruptcy Code 2016 has also impacted on stock prices of some of the banks, Indian banks. It has not just reduced their non-performing assets, but has improved their share prices considerably. It has instilled the better credit discipline, sense of urgency and seriousness amongst the defaulting borrowers. Nearly 2.2 lakh crores rupees of debt settled relating to 4,452 cases referred under IBC. Even prior to admission of the cases under IBC, number of borrowers settled the dues, resulting good recovery. Insolvency and Bankruptcy Code 2016 proved to be game changer in Indian banking and industrial sector. It has been established that the banks, financial institute, and other creditors could recover more than 1 lakh crore through IBC route at the end of year 2019. Now recovery rate has been somewhat reduced due to pandemic and other reasons. In fact, Parliamentary Committee, Standing Committee's report on finance implementation of Insolvency and Bankruptcy Code, pitfall and solution, that is 32nd report published on 3rd August 2020. It has been observed that the information furnished by Ministry of Corporate Affairs revealed that Indian resolving insolvency rank improved from 136 in the year 2017 to 52 in the year 2020. The average time taken for resolution has been reduced from 4.3 years in the year 2017 to 1.6 years in the year 2020. Indian rank in ease of doing business improved from 155 in the year 2017 to 63 in the year 2020. Getting credit rank improved from 151 in year 2017 to 136 in 2020. While taking into consideration impact of pandemic on the implementation of the code, the committee finds that low recovery rates with a haircut as much as 95% and delay in resolution process with more than 71% cases pending for more than 180 days before adjudicating authority clearly points out the deviation from original objective of the code intended by the Parliament. The committee therefore feels that design and implementation of code as it has evolved needs to be revisited, particularly in light of original aims and objectives. It has been also observed by the Parliamentary Standing Committee that power of Committee of Creditors is a question before the forum due to high quantum of haircuts and on the basis of commercial wisdom. It is expected that government in consultation with the banks may come up with some mechanism to discourage huge haircuts as it is seen as foregoing huge taxpayers' money. It has been suggested in the report that although commercial wisdom of COC is a supreme, but there needs some checks and balances to regulate the same. It has also been observed that COC replaces interim resolution professional. That is our experience, day-to-day experience while working as an adjudicating authority. That Committee of Creditor replaces interim resolution professional by appointing new professional as a resolution professional of their choice without any guidance. It is now need of the day that entire CRP has to be in more transparent manner. Honorable Supreme Court in very recent ruling in India Resurgence ARC Private Limited versus Amit Metallics Limited took a note of commercial wisdom of COC once again and said that NCLAT was therefore right in observing that such amendment to Section 4, which has been recently amended in 2021, of Section 30 only amplifies the consideration for Committee of Creditors while exercising its commercial wisdom so as to take an informed decision in regard to the viability and feasibility of the resolution plan with the fairness of distribution among similarly situated creditors, and business decision taken in exercise of commercial wisdom of COC does not call for interference unless creditor belonging a class being similarly situated of denied fair and equitable treatment. However, in regard of various resolution plan put for approval of the adjudicating authority, recently question regarding approving resolution plan with high haircut and value offered in a plan being less than liquidation value has again arisen. The most latest judgment of NCLAT given on 19 July 2021, NCLAT had stated the NCLT's proceeding, NCLT's judgment dated 8 June 2021, approving resolution plan submitted by Princeton Technologies in CIRP of Videocon Group. It was argued that haircut of 90 to 96% has been taken and amount of resolution plan is though very close to liquidation value. In this connection, fair value and as well as liquidation value of the corporate debtor assets plays a vital role. The valuation is carried out as on insolvency commencement date by two registered valuers helps the member of COC to decide on financial offers. However, in most of the cases, valuation of assets arrived at its low compared to the claim admitted. In my considered opinion, following may be reasons for haircuts in resolution plan. One, that large time taken in deciding to file application and then getting corporate debtor admitted in CIRP. Second, mismanagement including instance of preferential, undervalue, extortionate and fraudulent transactions. 3, information asymmetry that includes book of account, not complete and proper record. It is not available or it is missing oftenly. 3, market condition not conducive with limited demands. 4, financial market of states assets yet to be developed in India. Next, legal issues takes long time and hampers timely approval of and implementation of resolution plan. And following are the suggestion for this, which I put. Issue regarding haircut and resolution plan having wide ramification. Any adverse finding could lose the spirit of code. Necessary safeguards and transparency need to be built up, insisting so the objective of the code being achieved too. The present practice of that all resolution plan issued by RP are deliberated and negotiations are held by members of COC, but COC members do not disclose the reason for approval of the plan. So it is necessary to impress upon COC to disclose the justification as to why the particular plan was approved, though it is having higher haircut. In my considered opinion, it may not be in conflict with the principles of commercial wisdom of COC, which is said to be supreme. The expert panel may be drawn from professional, from industries, from valuation expert, from accounts and auditing field, and also from legal field, so as to provide their views on such matter. The market of stress assets need to be widened and necessary policy changes are required at the RBI's level. The operational efficiency at various levels needs to be emphasized. It has to be noted that recovery rate of financial creditor has fallen to 36% as of June 2021 from 45% as to March 2022. A classic case of Ghotaringa Minerals and Orchid Healthcare, which was having debt of 8,163 crore, though they have no assets when they were entered in process IBC 2016. In such situation, creditor have no option but to take 100% haircut. On the contrary, in a case which I dealt with while in Kolkata, Binani Cement and other cases relating to MBL infrastructure, they yield 0 haircut. Although there are a number of other factors which need consideration for effective implementation of IBC to achieve the object, they include timely appointments of members. We cannot stop parties raising number of legal points during CIRP, but the pleadings which now run in thousands of pages need to be curtailed so as to save time and energy. So these are my some of suggestions. I now throw this topic for discussion to my honorable panel members. Thank you very much.
So thank you very much for your keynote address. It is my pleasure, sir, to moderate the session in relation to some of the topics that are relevant and contemporaneous with 3 expert bankers who are on the panel. And I might fill in and add some of the industry perspectives if need be. So let me first start with Mr. Mehta. So how do you see the introduction of the IBC in terms of the change in the behavior of debtors when the SARFAESI was the law which was relied upon for recovery and the old Sikh Industrial Companies Act was also in place? It was debtor in control and the process was not yielding recovery, and one of the reasons to bring in the IBC was to overcome the increasing NBAs. So how do you see the IBC working in relation to the behavioral change of the debtors?
Thank you, Shardul. And in fact, IBBI chairman in his opening remarks, he commented about the story, and I'd like to little bit elaborate on that. I think IBC is the most landmark reform in the financial sector after SARFAESI, which has really transformed the relationship between the debtor and the creditor and has culminated into a greater financial discipline, which is reflected into the present levels of NPA, which has gone down substantially after the introduction of the IBC. Gross level of NPA and net NPA levels are going down, because it's not only that the cases which are admitted, as rightly said by the chair of this panel, Gosaiji, that in fact, a lot of cases, just because of the deterrent effect of the IBC, got resolved even before referring to the IBC, or even because there is a psychological impact that earlier there was a predetermined notion among the industry that they have a legal mechanism available. They may not lose their asset, like BIFR was providing them that window under the SICA. So they can continue with the asset, they can continue to manage till last, and even at the last resort, we will be able to strip out the assets and then nothing can be transferred. But this IBC brought this psychological change in the mindset of the corporate that yes, with the introduction of 29A, now the assets can transfer, and some of the largest first all cases referred by RBI. If you see the fate, the value that the banking system has realized was much more which was on the table. Without quoting the name, my few of the banker friends are there. Like before going to the IBC, we were getting some restructuring proposal, which was half of the value of the outstanding loan, or we were getting a compromise proposal, which was half of the lending value. And some of these cases, we could realize 86% or 90% or 100%. So that has shown two things. One thing, a financial discipline. Another thing, a greater value realization. And the third important thing is creating an ecosystem where alternative management options are available for running of the unit. So some of the resolution professional has done exceedingly well. Even during the period of resolution, the EBITDA contribution by those companies were more than what they was in the hands of the original promoter. So many of the groups like whatsoever was run by the original promoter, so whatsoever sales and earnings they were making during their time, some of the projects got a better earning when they were managed by the single principal proposition with the help of the advisors. So it's a definite, very important legislation which has changed the landscape of banking and brought a lot of financial discipline to the financial sector. Having said so, as rightly said, every sector needs a reform, and when there is something new and any new law, one thing I must appreciate is IBC is a very dynamic law which has got within a short span of 6 years, it got 5 or 6 amendments. I think that is something very rare, and every amendment has brought a greater clarity into the interpretation, a greater clarity into the financial ecosystem, right from waterfall mechanism to the authority of the committee of creditors to the 29A role of the existing promoter. So all these things have really given a new dimension to the IBC. But now a time has come. I think we need to review some of the loopholes, and I must appreciate that this initiative of IBBI and Chairman IBBI recently held a meeting with the bankers, and this was thought that yes, there are delays in admission, how do we address them? Why can't we have a standardized documented for template? And Mittal Saab took a personal initiative and interacted with the bankers themselves. What are the problems you face? What are the common questions you face before admission? And so they said, we have to establish the debt, but can it be done by the information utility? Can it be done by some information provided by the debtor? So all these issues clearly indicate the positive and contributing role of the IBBI in redefining the rules, regulation, as well as necessary amendments that will take it to the next level. And the pre-pack, once although it's an infant stage in MSME, and if it is also introduced to the, main course, all type of corporate debtors, this will be a game changer. This will reduce the burden of NCLTs because capacity is needed. Another thing is the speed. As rightly said, the value goes down with the passage of time, so that will get reduced because the resolutions will be worked out and the time frame is only 120 days, out of which 30 days only there with the NCLT to approve that, and 90 days is available for the committee of the creditors to take a final call on the plan. And there, especially post-pandemic cases where there are genuine default in the sense that reasons beyond the control of the promoter, because the hospitality industry, suppose 2 years they were in the lockdown, the cash flows were impacted and they could not service, then at least such type of people can get relief in case there's a pre-pack is implemented. So overall, as a representing banking body, I can say this is the most important legislative reform which the government and IBBI has very aptly managed it. And today's conference is an indication that we are all ready and accepting the changes which we need to bring to make it more efficient for the entire ecosystem, including all these stakeholders. And thank you for this support.
Thank you. So I would like to ask Mr. Shirim a question in the context of Section 29A of the IBC. So would you be aware of the reasons why this was introduced at the time when the SR case was under consideration, and what was the moral dilemma that was being faced by the bankers, and was the intervention really pushed by the resolution in the matter of SR, or do you feel it was a amendment which was waiting to happen?
Yeah, thank you, Mr. Shroff. It's that is the problem when you have people like Mr. Shroff as moderator. They will ask you uncomfortable questions at the right time. And on top of it, we have a chair as educating authority. So we can't, as bankers, we have a problem with that as well. But being a former banker, I can only request his indulgence on contempt of court and continue with whatever I have to say. To add to what Mr. Mehta said, if you give me some indulgence, I'd like to ask, put in perspective a little more on the behavioral issue from the perspective, not from the perspective of the promoters and so on, but from the perspective of bankers. There are 4 basic areas that were not there earlier, and which the IBC has actually turned around for banks. The first, as all of you know, is the creditors in control. Now, creditors in control doesn't mean, as many of us feel, that creditors are in power. I would like to make a little bit of a sort of a distinction there, that it is creditors are accountable and responsible to get a resolution in the interest of all stakeholders. So it is not that creditors in power and they will go everything to liquidation. So that is one thing, and that is something that has been a clear change in behavior from what it was prior to IBC to what it is today. The second one is that the creditors had always been looking to the promoters for any resolution. So looking beyond promoters was something that IBC gave, and I think one of the clear-cut cases was the SR case, which Mr. Shroff is pointing out. So looking beyond promoters for a solution in terms of demand supply of the asset of the corporate debtor or the corporate debt that is there and so on was something that was not available, and the behavioral change started to happen on the creditor's side. The third important aspect was haircut. Many of us have spoken about haircut since the early morning today. The problem with if you go back in time and talk about the CDR process and so on, the CDR process actually was a resolution process with no haircut. Everything was recompense. Everything was usurious rates of interest and so on. So it made ab initio a resolution possible, viable in the short term, but impossible, uncomfortable in the longer term, because everything was coming back to the creditors as part of recompense or whatever you may call it. So in that sense, this was, there were a few other things, resolutions, regulations that came from RBI by way of various schemes, but a holistic redressal of this issue with the comfort of the adjudicating authority was available only through the IBC process, and that was a high behavioral change that I don't mind if there are demand supply issues or the market feels that the asset is not worth a certain thing, but I will find a resolution to protect employment, to protect capital, to protect credit, and to make sure that and as the IAM director was saying, to finally, if there is a good resolution, the equity holders who stand behind it will tend to gain. And that several examples you have seen, actually it has come reverse in the sense that why equity holders are getting more benefit today when there is a resolution process, whereas the creditors have actually got a haircut. So there is a problem there. I would imagine that there needs to be. And the last one is a very landmark decision, I think very landmark behavioral change, is that as bankers, as creditors, we always felt that we do all the work, all the dirty work you can say, and at the end of it, the income tax or the sales tax people will come and take away everything. So a landmark decision that government and state dues will be at the bottom of the pyramid, and they will not take in anything, even if it's under liquidation waterfall or a resolution waterfall. And that is something that is a huge behavioral change a huge plus for us. Now coming to 29A, I would imagine, I think there is enough written about 29A in the public domain. There are various pros and cons in many ways, but the basic issue of a 29A to my mind, and I'm speaking for myself here, is that if there is a proven issue in respect of a certain management to run the company along profitable commercial lines, taking the interests of all the stakeholders into account, I think that promoter should step down and give a chance to somebody else who would be able to take care better. That is the crux of the matter. There have been various other issues which could be involved with the 29A decision making. But clearly the SR matter, I think Mr. Mehta also referred to it, in the sense that the restructuring where it is only a one-party bilateral negotiation that goes on between a promoter and I did mention about behavioral changes, that we don't go outside the canvas, we don't go outside the circle to find out what is the nature of interest for such debt, which will give you more value, and find a possible solution outside of it. I think that power or responsibility, as I say, was given to us, and that is why the creditors, it came in as a big bonus to the creditors. And the fact of the matter again is, if you can go back and read these statements, that as soon as there was a good offer for 100% or close to that, the existing promoter also came out to that. So you can see the benefit of going through with a certain resolution, which was very well thought out.
I think I'll just like to supplement, sir, for a small addition, that Section 29 came in the midst of the SR matter, and the government was conscious of the fact that an asset which may be valued at over 50,000 crores was attempted to be taken off at the sum of 7,500 crores. And the parliamentary debate around 29A was clear. It came in the amendment to the section came in the midst of the matter, and the debates between Arun Jaitley, the law minister at that time, and the finance minister, and Mr. Chidambaram as the opposition leader, shows that the consciousness of the parliament was that you should not allow promoters to take the benefit of their own wrongdoing, especially when several of the bankers are in the public sector field. And the monies which are in the public sector are taxpayers' monies, and therefore the concept of really intervening and disqualifying promoters who have led to the insolvency situation came about. This was also one of the critical cases where backdoor means were attempted by SR by putting up another company effectively to bid in the process, and the early decision of the tribunal resulted and the COC resulted in disengaging the put up bidder and disqualifying that bidder. So 29A is demonstrative of the fact that it is the cause for the behavioral change, that you lose your management, you lose your ability to manage elsewhere in the situation where insolvency is attracted. You are unable to bid for any of the further insolvency situations where you feel that you will have an opportunity to participate. So it's a serious disability which has been visited upon the industrial community, and that is what is causing the behavioral change. If you see the conduct before the amendment of Section 29A, there was no fear as was introduced by 29A because of these three disqualifications that were visited upon them. The disqualification was not only to the owners but also to the managers who were responsible for the insolvency circumstances which came into being. So after dealing with the inception, I think one particular question which I'd like to ask all three of you is that how do you see the delay in terms of admission processes because there is a current paper on this very current paper from IBBI on this question of resolving delays in admissions. If it is a recognized statement that valuations fall during the course of delay and there is a deterioration or decay in the assets and their utilization in future for a new incumbent is not as much as the person in control of the enterprise. Having said that, why should there not be a better process of admissions, and what do you think would be such a better process? Mr. Mehta. It's not on. Excuse me. I think no, they shut them all. Can you just check it?
So I think it's a very relevant point, and as it was deliberated in the opening session, and when Chairman IBBI raised this issue, that inordinate delays, like more than the resolution period time is spent in admission, that is up to 700 days, it's a cause of concern, because this was also deliberated that if it is delayed in admission, during the course of time, there can be asset stripping, there can be further deterioration in value, and there can be loss of interest by all the stakeholders, because beyond a particular point, if the company deteriorates, there are no resolution applicants available in the market to take over those assets. So it directly or indirectly impact all the stakeholders, because ultimately it's the employees whose interests are also protected if it is taken over in time when it's a running unit, or it is an interest of the government also, because if it's a running unit, it is producing something, government is getting some taxes on it, maybe on the sales, that is also protected. And the financial creditors, definitely their interest, because early resolution will bring. So one good initiative that has been taken by IBBI is how to plug these loopholes. And one of the questions that was raised in the meeting by IBBI chairman to the banker is, can we standardize the document for filing a application? And if that can be done, can we create a checklist where all necessary documents which are necessary for admission can be put up right at the time of filing itself, so that the judicial process of validating the debt is done through the documents available on him. And there are information utility level, like NESL is available, whose the data can be relied upon, because that's an information utility created by the IBBI. And there can be acknowledgement of debts, there can be other important documents which can say that yes, the borrower himself has acknowledged the debt, so there is no need of fresh validation of the same. So similar type of checklist if can be created, and documents can be improved, and I think that's a very good suggestion which can reduce the substantial time for admission of the cases. And the other factors is sometimes as a banker also we miss out in the process of filing a case in hurry. We do not provide the substantial documents, and then we say the cases are not admitted. So somewhere the checklist and the material will say that if you have to file an application, it has to be with a certain checklist completed, and then only it will be treated as a proper application filed, and then only the 14 days period will start for admission. Automatically this will resolve some of the issues. I think it's a work in progress and need of the hour, and rightly being deliberated, and today researchers are there, so if they have some better suggestions to offer, I think the banking system will be too happy to do that.
Can I come in here, Mr. Shroff? So, Mr. Shroff, the question that you asked had two parts. One is the protracted nature of the admission process. The other is attrition of business value. Honorable panelist has already spoken about the first part, the protracted nature. I would like to dwell a little about the attrition of business value. Now, the attrition of business value indeed happens if the admission process gets protracted, but we all know that businesses operate in a dynamic environment. It's not that when a case is referred to NCLT for its admission, that is the point in time when the attrition of value starts. Actually, attrition of value starts much ahead, much before that, because we are all aware of the volatile nature in which businesses operate. So I think this is one aspect which RBI Deputy Governor in his speech also alluded to, that See, the efficacy of IBC actually works outside the CIRP process. I would like to bring in a distinction between IBC code, a subtle distinction, a nuanced distinction between the IBC code and its influence and the CIRP process itself. Now, there is no gainsaying the fact that the CIRP process by itself has had a tremendous and enormous beneficial impact on the credit market in India. And the best way to, I think, assess that is to look back into the period when we didn't have the IBC code. And we know how it has been successful, the CIRP process. But I would say that the IBC code has a much overarching influence on the credit markets in India. Just by its sheer existence, it drives many aspects of the borrower-creditor relationship. And also, I would say, many aspects of keeping a business viable and sustainable. It's not just, I would say, the borrower-creditor relationship. It has got profound influence on maintaining a business as a sustainable and viable business, which is the objective of all stakeholders, not just the creditors, even the shareholders. So to that extent, I think I would say that I am seeing a more readiness, a more fleet-footedness, if I may use that word, between the borrower and the creditors to take and resolve issues upfront, issues facing business. Ideally, when does a business starts, making defaults? I think it starts, defaults can be, of course, first of all, of various types. Not all defaults are because the business has, lost its significance, or there's something wrong with the strategy or the operating model. Sometimes default could be because of a simple working capital issue, which is a temporary, one-quarter issue. I'm not referring to that. I'm referring to defaults which emanate out of much deep-rooted issues in the business model, I would say, or the business affairs of the company. In those situations, because of the existence of the IBC code, because we all know as market participants that here is a code which will ultimately dispose of this issue, I think all the participants, it's a great platform for all the participants to come together and treat those issues, tackle those issues head on, which might require reorganization, restructuring, because all defaults are not because of problems in the balance sheet. Here again, we have to distinguish between problems in the balance sheet and problems in the P&L. When I say problems in the balance sheet, I'm actually referring to the capital structure. And when I'm talking about problems in the P&L, I'm referring to the operating part of the business, the EBITDA generation.
May I intervene? Our question was limited to the issue of what should be done for faster admission. Yours is a more long-term perspective on how insolvency or incipient problems in relation to the functioning of companies which are sort of struggling to keep up in terms of their credit worthiness and in terms of their continued employment, all those questions. So my question was on the limited issue as to whether, with the knowledge that there is a declining value, with the knowledge that the errant promoter is in control, till such time as you admit the petition and till such time as an interim resolution professional is appointed, what should be the urgency or what should be the method of change in the IBC? Is this a more mechanical process? Should it be done on a templatized basis? Should there be just a verification bound factor? Should it be like a computerized system rather than a application by judges, NCLT? Because if you look at it from the perspective, and if IBBI's view is correct, that it is a templatized process and it requires essential filings, this can be done by artificial intelligence. This can be done by proper, system management, machine learning. There could be so many other ways. But the real problem is not that. The real problem is that because of the judgments of the Supreme Court, natural justice has been welded into the admission process. Natural justice would mean a hearing before admission. And I have known of cases where 6 months have been taken in just admission, which is unpardonable. You have 6 months to close the CIRP, and instead you're taking 6 months to just admit a petition, because you raise issues of counterclaim, you raise issues of documents are barred. I think the remedy lies in specifying the kind of natural justice that you are eligible to at the commencement of the process. It is natural justice does not mean everything to everybody. Natural justice can be molded to the specific circumstances of the case, and it need not, just because the status of a company is affected and the status of promoters is affected, you don't need to give a 6 months hearing in relation to admission. The issue to be tackled is not process bound. The issue to be tackled is how do you save judicial time in relation to all these other issues which are raised in defense by the corporate debt. So this is the question that we pose to the presenters. This is the question that the research papers should really address. And my own feeling is that while artificial intelligence and machine processes can really come up with the answer that yes, the petition is admissible, this issue of natural justice is the cause of delay and must be addressed on a war footing as to limiting the right of natural justice. Because if you start getting into a civil suit process in a summary proceeding where admission has to be done in 14 days effectively, this is a never-ending process. We spent 180 days. I am aware, I was in that case in the Punjab Chandigarh tribunal, and merrily it went on for 6 months. I have given the details to IBBI that there are instances where this is happening. Either it doesn't get listed because of the pressures of time in the NCLT, or upon admission, I mean, if it's brought up on board, it is dragged incredibly on the grounds that there are counterclaims and this is not correct. The behavior of parties, bankers has resulted in my loss, and all sorts of defenses which are untenable.
May I defend myself to some extent? Because it is directly retained. No. No, not blame. This is not a blame game. It's all right. Artificial intelligence, everything is very appreciable. But my point is something different.
Yes.
We sit in an adjudicating authority. Section 5 of IBC defines what does the adjudicating authority means. It is a NCLT established under 408 of IBC. When we speak about optimum use of infrastructure, and chairperson is here, IBBI chairperson, we must put our suggestion to him also. Why they require 2 judges to decide admission? Section 7, nothing is there. Where there is a default and whether it matter is within limitation, claim is within limitation. These are only 2 issues. In section 9, we decide whether there is a debt, whether there is a default, whether there is a pre-existing dispute and limitation. So it is very easy. But problem is that we engage 2 brains to decide this simple fact. Let us make a suggestion to the government. Adjudicating authority definition should be amended to extend that it is not NCLT. Adjudicating authority appointed under Insolvency and Bankruptcy Code. Let some arrangement should be made. We are 100 judges. We sit in 2, so we get 100 judges at the same time, maximizing the infrastructure utility. That can be done also.
Mr. Shroff, sorry for cutting in. May I complete my point?
I'll bring it up in sequence.
Okay.
I'll bring it up in sequence because otherwise we have got maybe half an hour to finish. That's the mandate given to me to finish by 1. Whilst your suggestion, sir, is very welcome, there are parallel processes which I may just touch upon. That the Honorable Supreme Court has this kind of process where a single judge or the registrar has been given processes of adjudication, where admissions which are of a miscellaneous nature need not go to a division bench unless there are serious questions of law. So you can clearly bring this suggestion within the framework of the IBC, because to admit and take 6 months process of valuable judicial time is criminal. Yes, sir.
No, one of the things that I've written down is feedback from Educating Authority for Natural Justice. There are two things. One, as he said, if there can be a shortened, or rather a shortened bench of one adjudicating authority to decide on that. I would also suggest, I don't know whether it is still happening, a dedicated time during a week for admissions, for these particular cases, so that they can go on fast track, so that the admission goes on, and then of course the other things take the 330 days issue there, and also the question of I don't know whether how the natural justice pans out for operational creditors. I think that is something that we are talking about financial creditors generally. For operational creditors, what is it that the adjudicating authorities look at, and that sort of feedback can be built into a sort of a
So that
process
is also
that is
pretty
there.
well known for the reason that it is subject to creation of a template. I don't think the process for admission of operational creditors is significantly different
No.
from
I'm not talking about the template for application.
Yeah.
I'm talking about the feedback that can come from the adjudicating authority. That could be done by way of a template as well.
So just advancing the process, there is a thought which has been conveyed to me by the IBBI that there could be some issues which, as a part of like an advanced ruling authority, could be referred to the IBBI, where instead of, and of course that would mean that IBBI will be given powers of adjudication and conferring judgment, just like the advanced ruling authority has in relation to Income Tax Act. And some of the questions which are not requiring judicial time, as in the sense of the NCLT time, but which are part of the thinking and the research which has already been undergone, and for which there is sufficient background material which is currently being used in long drawn arguments in the tribunal. Can that be a process introduced? That is a suggestion which is there. I'm just leaving it for the thought of the bench. The next issue which I'll really like to take up is that in the process of conducting a CIRP, firstly, this whole theory that it is limited to professionals as in individuals and not professionals in terms of organization, and there are circulars in relation to that, is unrealistic for the simple reason that for a single man to accumulate all the assets, to run all those assets, to follow up on an information memorandum, to cause the to receive all the claims, to arrive at a complete statement of claim which is presented both in relation to secured, unsecured, and operational creditors. You're putting an insurmountable burden, and therefore leading to practices where the backup is really the accounting firm. Why would you not recognize this fact? Because most of the bankers who are involved in the larger disputes are clearly resorting to individuals backed up by an organization. So is this not a reality which should be recognized by IBBI? And I would seek your suggestions, Partha, on this.
Clearly say yes. In fact, I would say that, considering the size of assets that have gone through the IPC process, I think it does not give enough an adequate time, and it doesn't give adequate time for a prospective investor to do the due diligence and come to the real enterprise value that he or she would like to bid. So in fact, not only that, the RP should be supported with a larger team, I would also recommend something akin to vendor DD that is done in typical M&A and private equity kind of transaction, to go all the way and support, because this will be a big support for the value discovery process. And this is obviously serving all the stakeholders, the corporate debtor, the creditor, and if there is a value for the equity holders in that bid, and the outgoing equity holders as well. So I would definitely recommend that, and even include vendor DD to be considered in the purview of this
So in fact, a suggestion was given to the IBBI and a suggestion was given to the Ministry of Corporate Affairs that one should look at a shadow prospectus which is updated every 6 months or every quarter, and which has the responsibilities of a prospectus, because that scheme is now carried through under Section 77A for the purposes of enforcement and punishment. So it is impossible to sit and collect evidence and data and to make a data room within the time frames prescribed for an RP to really present this information and to come up with a PIM or an information memorandum. So the suggestion which Partha gives, that there is a need to have better due diligence, can only be met if there is a prior process put in place where the company is not even in an insolvent process, but at a process where it has got the wherewithals to keep updated the preliminary information memorandum, which can then be updated in the short time that is available to the RP once he is IRP once he is appointed. So, and the reason is that if you speak to any of the merchant bankers, they have always come forth with the theory that unless there is full disclosure, you will not get proper value. This is a constant theme anywhere you go, whether we've traveled with IBBI to Singapore, to US, and this has been the constant refrain that you give too little information, too less accurate information, and therefore you cannot achieve maximization of value. Now, contrast this, sir, with a situation of what the learned member mentioned in relation to Binani cement, or for that matter, any company where there is natural resource which is of limited quantity and where there is a great deal of competition to acquire those assets, even if the company is not a going concern. So the realization of 100% of the value of the creditors or the operational creditors was as a result of open competition in the court. It was not an open competition through the system of CIRP. It was a Swiss auction actually happening without the features of a Swiss auction in the court. And it violated many principles, for example, that can you, for after the closure of the bidding, can you introduce a new bidder? Can you permit changes in a bid which has already been made? So there were many issues, but I think the main issue which sort of prevailed on the court was that I am realizing 100%, I am achieving my goal, which is part of my preamble, maximization of value, and therefore they overturned the decision of the COC. The winner was actually one who had lost, and the lost bidder really became the winner in the process. So there are several aspects in the Binani case which will never repeat themselves, for the simple reason that the law has progressed and the law has covered each of these issues. There are Supreme Court judgments now on each of these points. And one needs to only point out that this is not permissible under the CRP. Early days it happened, but it will repeatedly happen when there is, it may be oil and gas, it may be limestone, or wherever the resources are few and there is a great competition among the large players in the industry to take this, because I think they also believe the fact that the Competition Commission does not go into the aspects of full competition, the way a full competition process is undertaken. They are under mandate to give the approval under 30 days. So the Form 2 kind of analysis that takes place if you have to go voluntarily does not take place because of the timeline mismatch between the IBC processes and the process which is required under the Competition Commission. So it is an advantage for them, the larger players, to go through BIFR because there is less scrutiny under the Competition Commission. So let me now take up one of the hot issues which has come up from the parliamentary committee. So this pertains to the Code of Conduct, and you have now a IBBI paper also describing the Code of Conduct. And Mr. Shirim, you have written in relation to the Code of Conduct. I have 3 observations and then I would like your reply. The code of conduct has ramifications in relation to public sector banks. It has impact in relation to private banking, where there is no element of state. The judgment in Escorts Limited still holds the field that in a contractual matter, I have the right to act as a private citizen, and I am not bound by the rigors of Article 14 in a contractual matter on a pre-contractual stage. How would you equate the principles between private bankers and public sector by a single code of conduct when they may have commercial reasons to decide in one way or the other? They may not, for example, trust the promoter. They feel that he is not a clean and honest promoter, and therefore they want to get on with the task and find a buyer at a higher haircut. Per se is 95% bad, because there are several cases in which, it's not just the Videocon case, there are several cases where there are more than, about 95, 96% haircut. So is the principle only going to be decided on the basis of the extent of the haircut? Or are there other rules in relation to the code of conduct? Would you, for example, introduce aspects of how the Committee of Creditors plays a role of a constructive trustee with reference to other stakeholders? How does it look after the interests of operational creditors? How does it respect the inter se priority between creditors? It's not one class. I think several judgments of the tribunals and the NCLAT proceed on the footing that all secured creditors are one class with equal rights, which is completely wrong, because there are priorities which have been fixed under the register of charges, and it has to be distinguished as to who is going to get first or not. You may have a single priority with reference to entry into the Committee of Creditors, but when it comes to distribution under 53, each one has his or her own priority. How are you going to weld all this into a code of conduct? Because there are dissimilar elements. It's not like writing a code for an RP or for that matter, any of the intermediaries which are regulated by IBBI. A Committee of Creditors is actually within the domain of the RBI. And you are asking the IBC to really prepare a code of conduct in relation to creditors who are mainly creditors dealt with by the RBI. Of course, the unsecured financial creditors could be anyone, need not be regulated by the RBI. So there are very complex questions in relation to code of conduct of creditors. And sir, because you've written a paper, I would like to hear your view.
No, thank you. I was sort of expecting this question, because having written something, I would imagine that you will find holes in it and try and... thank you for that. So you see, the fact of the matter is between private and public banking and so on, what I see is that the Committee of Creditors is only one. There is no distinction between what type of creditors sit in the Committee of Creditors. They are all financial creditors who have given space, and all the representation from everybody who has given debt or financial debt is represented in the Committee of Creditors. So obviously the alignment of all the Committee of Creditors is upmost. And in many cases we have said majority, some cases 2/3, 3/4. And at section 12A says 90% and so on. So alignment of interests have to be there with every stakeholder within the Committee of Creditors, irrespective of whether they are regulated or they are outside the regulation thing. I've sort of mentioned it as also in the article that there are many jurisdictions which don't have this Committee of Creditors, but work in a similar way, like for example a judicial manager or an administrator or so on, but that is more a judicial function rather than a Committee of Creditors structure here, where, as I said and I repeat myself, that the Committee of Creditors should not be powerful, but should be highly responsible and accountable to what decisions that they are saying. There are 5 principles that I feel very strongly in terms of what the Committee of Creditors should do as part of the Code of Conduct. There's a list that I've suggested. There can be a list that anybody else can suggest what are there. But largely the point remains that it has to be voluntary, that voluntary code of conduct adopted by the Committee of Creditors. It cannot be mandated. Once you have mandated code of conduct, then then people will approach the adjudicating authority for everything and everything. So that is very clear there that there is a discipline that needs to evolve, a sort of a code of conduct that needs to be voluntarily adopted by the Committee of Creditors. And in what way? And it's not going to come overnight. This is an indicative list of things that people can do, and over time, maybe 5 years, 10 years, it can evolve. First is the suitability to drive the resolution process without conflict of interest. Now, that is very clear that if there is any conflict of interest between people sitting on the Committee of Creditors and outside in terms of becoming a resolution applicant and so on, that is something very, very, very critical. And that is a very, even if the code of conduct is not there, I think it's expected of anybody and everybody who sits in the committee to be aware of that. Second, and as I said, coming from the responsibility point of view, act in the best interests of all stakeholders. Now, there have been cases where we have protected financial creditors, we have not protected operational creditors. There have been various other things that have happened where the interests of some stakeholders are perceived that they have not been adequately taken care of. And this is again going to be driven by outcomes in terms of how these pan out and how you want to change yourself on that. Third is, of course, to act in, this is a very generous statement that we have, act in good faith, fairly and honorably, and be seen as independent and impartial. So the Committee of Creditors being independent and impartial has to be very clearly driven. The fourth point is very important, and this comes to the commercial judgment that Mr. Shroff was talking about. We must make sure that we exercise good commercial judgment. And for that, if you need external support, you need external validation of what commercial judgment you have taken, and maybe recording those commercial judgments in black and white to make sure that at that particular, because any commercial judgment is applicable only as on that particular day and time. 5 years hence, you can always come back and say this was wrong. But clearly there is, so the recording of what sort of commercial judgment and what side and how you have done and aligning with the all stakeholders is very important. And finally, it has to be feasible, it has to be compliant with laws and fair and equitable. I think these are the broad guidelines in which a committee, a code can be driven. And you can put in various, points on the code of conduct depending on what you want to do or not. You can even make it stage-wise, that these are the first 5 points that we want to do as a code of conduct within, say, 6 months. Then take it along as we go ahead in that. But these are my thoughts on the code of conduct.
I think there are very critical points. Thank you, sir. The code as presently presented in the discussion paper has a lot of repetition and needs to be carefully scrutinized, with these as the guiding principles, as Mr. Sriram has correctly said, because these are the overriding principles. I have just exercised one area of caution, considering how we are a major litigious society, that if you start recording reasons in a judgment, then those reasons will become justiciable. And instead of actually getting yourself into the resolution of companies, you will get into the questions of justifying that reason on principles of equality and all sorts of constitutional principles. So the rule in escorts is a rule which you should follow. As long as reasons exist on the file, they need not be reasons stated in the decision order. The judiciary can always see the reasons, but the judiciary cannot get into causing a dispute in relation to the reason and causing an adjudication thereof, because that is an enormously time-consuming process and brings in all the issues of private banks don't need to give reasons. So why would you tag the reason given? And that was exactly the rule in escorts. The argument was that it is state. LIC is state, and therefore it has to give reasons. But that was rejected by a bench of 5 judges. I have a lot of points, but let me restrict myself, sir. There's a last point which I'd like to raise, and that is in connection with the preferential transactions or transactions which need to be avoided, and the consequences of the 2 Delhi judgments wherein the court has held that upon the completion of a CIRP process, there is no right to continue those avoidance, the applications for avoidance of those transactions because the way the law has been. I have a serious concern in relation to that because the law necessitates that you track the wrongdoer. To say that just because a CRP has closed, now there is no jurisdiction in the NCLT and everything is over, and the RP is bidding on the principles that there is no recovery or there is no need to adjudicate on the avoidance and the preferential transactions, in my view, is giving up a very major aspect of punishing the wrongdoer. So if the judgment as is presented by Justice Pratibha Singh is considered, I think it is important to really carve out this rule, and for 2-3 reasons. If you see the Companies Act, there is a power under the Companies Act, independent of the IBC, to prosecute a person who is a wrongdoer. There are enough processes, both under the scheme of reconstruction, reorganization, or arrangement, where the rules and the act itself contemplate that the procedures in liquidation can be brought into the CRP, and you can therefore proceed against a wrongdoer, which is a continuing process. Ultimately, what must be looked at is that malfeasance, misfeasance, omission to do are public injuries, are public wrongs. They are wrongs against the state. And therefore, to say that the RP does not have jurisdiction or that the NCLT has no jurisdiction is wrong. These are crimes. These are matters which fall within the special jurisdiction of the NCLT and must be carried through, irrespective of the fact that the CRP has. It's only a question of deciding who will get the benefit of it. Should it go to the state? Should it go to the creditors? Should it go to the company? Some of these principles are well known in law, but to let off the wrongdoers is I think, really wrong, and I would recommend that this be relooked at.
I suppose there is a section 26 in Insolvency and Bankruptcy Code, which was not brought before notice of Honorable High Court. It has been discussed. But then how it is interpreted, I don't know. Because 26 is very clear. Irrespective of CIRP is closed, these applications for preferential extraordinary transaction can go now. But on what ground, I don't know. I don't know. But there is a provision in IBC.
So with that, I've got another 10 minutes. So despite the chit that I must finish, what is it? I would like to ask some of the questions from the audience, if there are, because we've been only asking questions on the panel. If there are any questions from the audience, I would most happily. Can you just?
All right.
Okay, the other way.
Right.
I think he's. Okay, you ask.
All right. My name is Dushyant Dave. I'm IP from Mumbai. Similar to the question about admission, can there be a mechanical process about the assets which are attached by the ED when the CRP takes place? And we find that thousands of crores of assets get attached and then just they get rotten and nothing happens. And there is no provision. So it has always said the IBC precedes over this, but in PML Act itself, there is no provision. As a result, there's always a, and whenever we approach the bench, I think there is a gross delay. So can there be either an amendment in the Act or an automatic, the moment the CRP starts, the assets then belong to the creditors? The criminal process can continue with the ED or CBI. Thank you.
I think you wanted to read.
I am Jaidev from IIM Bangalore. In spite of constitutional validity of the IBC, there are some cases where borrowers have approached the high courts and obtained the stay. In the case of one of the Reliance Anil Ambani group companies, Bombay High Court has given the stay. Similarly, in Telangana High Court also has given some stay regarding 2 or 3 borrowers not approaching the bank to take the appropriate action. So, is there any way that these High Court judgments can be overcome and bank can proceed with the CARP processes?
I think the question of the High Court interfering when there is an appellate remedy, part of the IBC has a natural appellate tribunal, and the courts have consistently held that when there is a tribunal which is to look at appealing issues, the High Court in its special writ jurisdiction should not interfere. But ultimately the judges are judges, so they sometimes feel, oh, there's a growth. Yeah, absolutely. No, I'm not meaning, so you're taking it personally. That being said, so yes, you could go up in appeal that the order of admission is wrong and set out the principles where the courts have itself held that you should not interfere in the continuing process of CRP. And I think in the Supreme Court, you'll get a reversal, but except that you'll have to follow the procedure prescribed by law. Mr. Swaminathan, if you wanted to.
There's one, the public commentary as well as the many speakers today was on the haircut. So I have a couple of thoughts and I would like to hear the panel's view on that. Number one, see, the alternate forms of recovery can be a civil money suit or a SARFAESI DRT-led proceedings. I may have a recovery certificate or a decree for the total debt that is due. But however, when an execution stage is entered and recovery has to occur, recovery is going to be equivalent to that of the underlying asset or the enterprise value. And I may end up recovering maybe 20 cents or 30 cents per dollar. But then there has never been a criticism of holding a recovery certificate which is 100 rupees but in recovery of 20 rupees. We were not much worried about that. The second aspect is that also was alluded to by the Honorable Member NCLT in his keynote before the panel, is that should we examine the commercial wisdom of COC, should NCLT take on record whether it has been properly assessed, appraised, whether the resolution plan presented that is correct or not. Do we want NCLT to get into a judgmental opinion on the commercial wisdom of NCLT? In case if that happens, will it probably result in resolution plans getting rejected, and which obviously will lead into only liquidation, nothing else. And the third and the foremost is the principal objective of IBC. Are we transgressing on that in terms of the principal objective being a resolution? Recovery is incidental. We would like to have an orderly closure to a corporate which is in stress. That is how the IBC started. But in the last couple of years, even NCLT is making remark like, this is not a haircut, it is a tonsure or a total shave kind of observations coming from the benches. Is it likely to impact the ability of COC in taking certain bold decisions of accepting resolution plans? Is that something that IBBI or the government can build a narrative that the objective of IBC is the resolution and recovery is incidental? Well, of course, it may be a difficult pill to swallow, but in case we don't build a counter narrative, the narrative on haircut is likely to impact is the fear of the lenders.
So if I may answer from the last question backwards, the basic premise of resolution is that there must be viability, sustainability, in the sense that you will not accept a plan which does not result in a continuous ability to keep the organization running. If as a banker, as a process of evaluation, you evaluate the application for resolution plan which is presented to you as a COC, you come to the conclusion that this is unviable, then it is not for the court to substitute its decision because you are the expert. And that is exactly why it has been held that the commercial judgment of the creditors is the paramount principle. Because it's not, I don't like your face kind of argument, but it's based upon the principle that a resolution needs to have commercial viability. It must be able to sustain itself in the future. And for aiding it to sustain itself in the future, you can give haircuts, you can give all sorts of reliefs which are permissible when a resolution plan is made. So the fundamental rule of what has been held by the Supreme Court of India is not going to change. Because the Supreme Court in several cases has held that in a domain of an expert, the court has no business to enter. Because it's not their science. It is a science of the banking industry to determine what is viable or what is not, because nobody's going to put good money after bad money. That is one. The second principle which you raised, sir, was this whole aspect of reasons. Now, in my perspective, and I may be wrong, putting reasons only creates the opportunity for adjudicating the reasons, whether the reason is right or the reason is wrong. And that will bring its own protracted delays, which unfortunately the NCLT will have to decide. They cannot say that now that this issue has arisen and there's a serious question of law on the constitutionality of the COC's action, and this is majority owned and majority managed by public sector banks, so I want to go into the reason. It will be an endless process. And this whole 330-day time limit is just non-existent then. One might as well forget the principle that there are timelines in the IBC. If we open the Pandora's box of reason and the whole principle of equality, it will be a disaster in many ways. So the recommendation is that you must have a reason on file, but that is not the reason which you need to communicate, because the fact that you have not acted arbitrarily will be provable by your document on file. This is exactly what happened in escorts. In escorts, Mr. D.N. Davar, then the chairman of IFCI, had put a reason and tendered it at the board, which was a hostile board. 9 directors of that board were replaced by LIC through a requisition. But he recorded the reasons in a slip that he gave at the time of the meeting. That was never referred to as a part of the reason, and they attacked it on the ground that this is unreasonable, that this thing. When the matter went to the Supreme Court, on the basis of the affidavit of IFCI, said that yes, there were reasons given on file, there was a reason given by the chairman of IFCI, and that reason is good enough. We will not interfere. This is not as if they have acted arbitrarily. They had a good reason which he recorded in the meeting. And that's all. That reason was not the basis of the decision to throw out 9 directors. So I think that is good law, because that's why I said the contours of natural justice, which is what is plaguing the NCLT, must be either judicially decided or legislatively decided by the IBBI. That this is the contour, because natural justice is an unruly horse. It means many things in many times. So it is for them to prescribe what natural justice is, so that it could be documentary, it could be post-decisional hearing. There are so many judgments on natural justice that you could have a view that this is the kind of natural justice that will be looked into. It may be without a hearing. Why oral hearing for natural justice? There is no necessity in law as a part of the natural justice rule that you must be heard. So there has to be a management of this aspect, because the delay effectively at the stage of admission especially is because of this whole, the courts are duty bound to give a good hearing. And that's what's taking time. Yes, please. So, Mr. Onikrishnan.
I have a layman's
Just
question.
1 minute. I think he will. Give him one.
See, you were talking about that one informal set of decisions without the matter going to NCLT and then getting decided. Are you talking about a decision by IBBI? Because IBBI has is already having an informal mechanism for giving opinions on certain issues which are raised before it.
Yeah.
So IBBI regulation making rules or regulation making regulations.
Yeah.
The method of making regulations, it is brought in the form of a regulation. And that provides an informal mechanism for giving opinions on certain things. And it goes with a caveat that this is not a rather adjudication of law. So is it that...
no, sir. I'll put the question which came to me from a IBBI person. The question reads like this. Can the working of the IBBI be expanded to reduce the burden of the NCLT? The advance ruling option in case of transfer pricing issues under the Income Tax Act is an example. Can a similar model be used for the IBBI to handle certain identified issues under the code?
there is a separate question also. The NCAR recently concluded an independent evaluation of the IBBI. As a regulator, how has the IBBI fared? What are the strengths and where lie the weaknesses which need further improvement or regulation? So the person who's formulated this question is aware that the power of regulation exists, but he wants to extend the principle of IBBI being an adjudicator of certain advance ruling issues which bind the parties, just like in an income tax advance ruling, and therefore don't spend the time of the tribunal effectively in raising those questions. It's a good suggestion, but it will require significant change in the IBC, and it will probably have to be deliberated upon by the Insolvency Law Committee. I think the gentleman here.
Sir, I have a layman's question. If the lenders are agreeable to taking 96% haircut, why would they not take 100% haircut?
Because they will be accountable to the CAG as to why they why did they give a complete write-off of debt. No, it's not just 4%. It is employment, it is continuity, it's payment of taxes. There are lots of issues which go into the making of a decision. It's just not the fact that the lenders retained 4%. If the unit is closed, take a situation where the unit is closed, then effectively your money is lost unless you recover. Unless you go to the recovery tribunals, what are you going to recover from a unit which has no workmen, no licenses, just merely the assets, which are also depreciated? So there are justifications as to why. Yes, sir, please.
You see, haircut is not clear haircut in the sense that you take out 96% and take and throw it away or something like that. There are various ways in which a structure has happened for a company that is under resolution. For example, the lender can convert it into equity, right? If the company is getting resolved, clearly there will be a benefit in terms of equity value when the company recovers and does better. There is something called taking debt which has got no interest. You're just protecting the capital. You're not putting interest, but I'm not doing away with 95% of my principal. I'm saying that this one will continue without interest. And one of the things that I said earlier was the CDR mechanism which says recompense and all of that. But here we are not talking about interest rate at all. Here we are saying after 5 years or 8 years or something, if the company recovers, then they can pay back just the principal at no interest. So these are all things that are built in to see whether a company can be saved, right? And if a company is saved, as Mr. Shroff says, there are various other people, stakeholders who benefit, including minority shareholders, including employees. If you see the Section 53 liquidation waterfall, the first person who's protected is the workman, and after that only the secured creditors come. So all of that needs to be taken into account for the benefit of the economy in such, I hope I have cleared something.
I just forgot to answer a question which he had raised. Just let me address that question. So the issue, one is that the law was amended to clarify that the ED and the PMLA effectively is subject to orders under the IBC. The IBC has paramountcy. But on a certain legal question as to whether it relates back, it's not retrospective, the matters are pending in the Supreme Court. The Supreme Court has heard this issue and will come out with the judgment. Depending on what judgment is received, the way, the technique which has been followed by the MCA and the IBBI is to amend the law so as to treat it as a clarification since inception. Yes, sir, please.
What happens is the day a person stops, so the day a person stops his installment, 90 days after that, the account becomes NPA. 90 days after that. When an account, I'm replying it from the banker side and not from IBBI side. Let me first clarify, okay? So 90 days after that, the account becomes NPA. Then what happens? The penal interest starts. Okay, a penal interest starts and a penalty starts. Now this goes on for about a year or so, and then the account is placed before the NCLT. So what happens if the principal is 100 rupees, and when the account goes to NCLT, when it is about to go to NCLT, what every banker does is to take this to the maximum so that when the claims are settled, I get more money. Okay, so this 100 rupees becomes, let's say, 250 rupees or 225 rupees. 100 rupees principal or whatever was there at the time when that promoter had stopped paying his installment, and the day it goes to NCLT, it is always more than 2 times and sometimes 2.5 times. That is so. Then what happens? The value of the asset is deteriorating every day. Now, when the registered valuer who's appointed by the COC does the valuation comes at, let's say, 40 rupees. Okay. When the bidding is done, by that time the value is not even 40 rupees. It is because one more year may have elapsed. So the value will not be 40 rupees. Maybe it is 30 rupees. Maybe it is something else. So now, how do you calculate the haircut? Should the haircut be calculated which should be the denominator? Should the principal be the denominator? Should the day the bank went to NCLT, should that be the denominator? Should the value arrived by the COC as a part of the valuation process, should that be used for haircut, and so on and so forth? So what is commonly done is, just to create a sensation, is to take the maximum value, which even the banker knows that it is not correct. I mean, I know that I have been part of them for several years, and I have sat in their boards. I know what. So even the banker knows that is not correct. So what is done? We take that value, and from that value, we take the lowest value which we get in a bid. So naturally it will be 95-96%. In a few cases naturally it will be that. But अगर आप principal पर देखिए, केवल principal outstanding, if you see the value at the time it goes to NCLT, and so on and so forth, you will get a much different figure. And what we have seen is the value that the valuer has given. This figure is always about 1.5 times that value. It is not that they are taking that kind of a haircut. One more thing, even if the banker takes the full haircut, let us take the worst case, that the banker is taking the full haircut, but the company, someone buys that company. If someone buys that company, then over the next 5-10 years, he will create more value for the economy than the haircut taken by the banks. So I think it is more important for that company to be revived. That company will pay more taxes. The company will create more employment. The company will add more to the GDP. And yes, the banker has taken a haircut. And even if you had not gone to IBC, the banker would have taken the haircut. As the MD SBI rightly said, DRTs mein ya usme we get a certificate stating it is 100 rupees, but do we really get 100 rupees? The main problem with DRTs is court order is okay, but the recovery, actual recovery is an entirely different thing. I hope I have addressed.
Thank you for your intervention. May I, sir, now request Mr. Gosavi to sum up the discussions of today, and sort of after he finishes, we'll close the session, and we will reconvene in the seminar halls at 2:15.
In fact, there is nothing remains for concluding, but some behavioral changes, Mr. Mehta rightly said that it has come because most of the cases settled even prior to admission. Then Section 29A issue was discussed when Mr. Shirim very good suggestion that what about employment? My this thing will be, in fact, problem is interpretation of Section 29A. All right, promoter proven misappropriation, promoters should be barred because backdoor entry. What about their relatives? What about their distant relatives? Why they were brought in? That should be considered properly. Then delay in admission, we have spoken a lot about this. I may not this thing. Borrower, the next was discussed that dedicated time, as Mr. Parth has suggested, it should be done, and we have moved to our precedent that we'll deal IBC cases Monday, Tuesday, and Wednesday, and NCA that company cases Thursday, Friday. Model will be come out very soon. Then advanced tax ruling, of course, deliberation is required because it has to be adjudicated upon by properly. There are a number of issues, but due to paucity of time, I conclude, but I feel that we have very fruitful discussion on the subject, and I declare that it is concluded now.
We thank our esteemed panel members for sharing their insightful thoughts and having an enriching discussion, bringing forth different perspectives on various issues in the insolvency landscape, which will certainly act as an input for policy changes. Ladies and gentlemen, may I now request Mr. Santosh Kumar Shukla, Executive Director IBBI, to present mementos to our esteemed panel members as a token of our gratitude and appreciation. May I request Shri M.B. Gosavi to kindly accept the memento. May I request Shri Sunil Mehta to kindly accept the memento. May I request Shri B. Shri Ram to kindly accept the memento. May I request Shri Shardul Shroff to kindly accept the memento. May I request Shri Partha De to kindly accept the memento. Thank you so much, sirs. Ladies and gentlemen, before we break for lunch, there is an important announcement. So after the lunch break, we will have presentation sessions, which will be held in 3 separate auditoriums. So one is this PP Gupta auditorium, second one is the seminar hall 1, and third is the seminar hall 2. So the list of presentations has been provided in the presentation kit, and you may join the hall as per the topic of your interest. And we have the copy of the newsletter published by the IBBI available at the registration desk. So you may kindly collect a copy for your records. And the presentation session will continue from 2:15 p.m. to 6 p.m. And from 6 p.m. we will have another workshop which is on data-driven insolvency research. So may I now request you to kindly join us for lunch at the IMDC dining hall on the ground floor and join us back at 2:15 p.m. Thank you.
So I'll just tell you brief, and then we'll begin with the paper presentations. Each paper presentation would last for 20 minutes. There are a total of 4 paper presentations in this session. After all the paper presentations get over, which is after all the 4 paper presentations get over, the dais can be open to questions. So you can ask your questions for 15 minutes after the paper presentations get over. At the end of the paper presentation, I would be ringing a bell so that you would be kept aware of the time passing by. So to introduce our judges, we have Shri Santosh Shukla, who is the Executive Director of the Insolvency and Bankruptcy Board of India. And we have Professor M.P. Ram Mohan. He's the Associate Professor in the Business Policy area at IIM Ahmedabad. The first paper looks at assessing behavioral change of creditors under IBC. This would be presented by Dr. Neeti Shikha and her team consisting of Dr. Shambhavi Singh and Dr. Rishabh Ahuja. So we will begin shortly. We'll just set.
We are still students.
Okay. Okay, we were given doctors with apologies. I hope that's fine. I'll just begin the timer so you have the slider.
Thank you. All right then. So good afternoon, everyone. Esteemed panelists, researchers, scholars. I hope everyone is refreshed after the lunch that we had. Today we are gathered here at the International Research Conference on Insolvency and Bankruptcy, and the paper that we are here presenting is titled Assessing Behavior Change of Creditors under IBC. This paper has been written by Dr. Neeti Shikha, who is the Associate Dean at the Indian School of Public Policy, along with Shambhavi Singh and I, who are current students at ISB, at the aforementioned institute. The objective of this paper is to argue that the Insolvency and Bankruptcy Code should be analyzed through broader frameworks such as behavioral economics. The point was also earlier made in the inaugural session by Mr. Rajesh Verma, Secretary of Ministry of Corporate Affairs. Now, I want to establish some context at the start of the presentation. Everyone here would know what it was like before IBC was introduced. Former Chief Economist Dr. K. Subramaniam had said that before IBC, there used to be a feudalism where the corporate debtor took it to be his or her divine right to be in control. This was because of several ineffective laws that were not able to provide a dignified exit to businesses, and promoters being in control of their assets indefinitely, much like feudal laws of the 17th century. The resulting debtor in possession framework eventually led to a large increase of non-performing assets, harming the banking system and the wider national economy. With productive assets not being appropriately utilized. These inefficient outcomes reflected the skewed behavior dynamics between the creditors and the debtors. And the IBC was introduced to remedy that, making it a behavioral policy as well. This brings us to the discussion on behavioral economics in the policy world. Behavioral economics incorporates insights from psychology to economics in order to understand how humans behave rather than how they should behave. David Friedman, in his book Law's Order, What Economists Have to Do with the Law and Why It Matters, had said that legal rules are to be judged by the structure of incentives they establish and the consequences of people altering their behavior in response to those incentives. That is, registration, when designed appropriately and enforced efficiently, can adequately incentivize self-interested economic actors to choose the most desirable or the most efficient outcome. This means that for a policy to be successful, there has to be a confluence between the self-interest of the economic agents and the desired outcome. IBC has sort of achieved this with thousands of debtors resolving their financial distress at the early stages of the process. One reason for this is loss aversion. In behavioral science, it has been found that losses loom larger than gains. That is, the psychological pain of losing is twice as powerful as gaining something. Therefore, when the promoters of a firm are divested of their rights as soon as the corporate insolvency resolution process begins, they try to resolve it as soon as possible. Another thing that the code has done is to provide a choice architecture. A choice architecture is a term coined by Richard Thaler and Cass Sunstein in their famous book Nudge. It refers to the practice of influencing choice by organizing the context in which people make decisions. For starters, the IBC gives businesses an automatic choice of resolution while also giving them an option to depart via a withdrawal application. Now, Shambhavi, my co-author, will continue with this presentation.
Thank you so much, Rishabh. Good afternoon, everyone. I'm now going to be explaining how the change in default threshold led to a significant change in the behavior of creditors and further led to reduction in filing of petty claims. So with the onset of the unprecedented COVID-19 pandemic, the Ministry of Home Affairs, in tandem with state governments on March 24, 2020, declared a complete nationwide lockdown in its effort to contain the spread of the pandemic. Thereby, all economic operations were brought to a complete halt. So at this stage, the government had permitted only certain essential activities to be carried out. Due to which the central government was well aware of the fact that there would be financial repercussions and distress in this extraordinary circumstance, and therefore the MCA, in order to provide protection to the industry as a whole, used its inherent powers under Section 4 to raise the threshold to the maximum limit of 1 crore rupees on March 24th, 2020. The sustainability of the cash flow and the generation of profits was rendered extremely difficult and the cause of tremendous worry as a result of the lockdown. Adding constant salt to this injury was the fact that the duration till when the pandemic would last was not foreseeable, which further created an immeasurable sense of helplessness within the stakeholders. In the prevailing circumstances, it was conceivable that the businesses might not be able to discharge debt expediently, and as a result, the defaults were attracting the invocations of the provisions of IBC, which would inevitably lead to a rise of massive proportions, which would push many businesses to insolvency. It has to be remembered here that the objective of IBC was never to liquidate or close companies, but in fact, to find an effective and balanced resolution where a stressed company would be able to discharge the debts owed to its creditors and eventually overcome adverse situations to realize its economic potential. Therefore, in order to aid the distressed businesses in the extraordinary circumstances, the President of India on June 5th, 2020, promulgated the Insolvency and Bankruptcy Code Amendment Ordinance 2020, which inserted Section 10A in the IBC, by operation of which the rights of creditors to initiate CIRP against corporate debtors under Section 7, 9 and 10 of the IBC with respect to defaults arising on or after 25th March 2020 was suspended for a period of 6 months or such further notice, not exceeding 1 year from 25th March 2020. Section 10A of the IBC was only operative in relation to defaults of debt payments that have occurred after 25th March 2020, and it did not provide for the protection of debtors who have defaulted in their payments of liability that arose prior to the said cutoff date. The induction of IBC also led to an exploitation of the lower threshold limit set by the Act, and the parties started initiating the CIRP even for petty claims. And however, this attitude was changed once the threshold limit was increased from 1 lakh to 1 crore rupees on March 24, 2020. We have sourced some data from the IBC newsletter which establishes the same. For example, if you look at this graph, we can see that the withdrawals under Section 12A of the IBC, as well as the appeals, reviews, and settlement together, they account for almost 53% of the closed CIRP. So this clearly represents the fact that most parties prefer to settle their claims instead of going ahead with the liquidation of a company or accepting the insolvency resolution plan. A behavioral change can also be clearly observed in the above data in the operational creditors. Next slide. So in this figure, we can witness the fact that 54% of the CIRP were withdrawn by the parties involved, and those cases amounted to a default of less than or equal to 1 crore rupees. It verifies a definite behavior change brought about in such situations wherein defaults by companies that were not in an actual insolvency state were settled once the CIRP was started, and the debtor could potentially lose control of their firms. Next slide. So in this figure, there are various reasons that are listed for the withdrawal of CIRP under IBC. It states that the major reason for such withdrawals can be amounted to the settlement of claims amongst the parties involved. These figures indicate the fact that with a lower default threshold, creditors, especially operational creditors, settle their claims, indicating the fact that the borrower had the capacity to settle and initiate CIRP, and this acted as a nudge for them. The company was not exactly in a true state of insolvency. Now, Dr. Neeti Shikha would continue further from here.
Thank you, Shambhavi. Let me share with all of you that how this inspiration for the work came. I had written a piece for Bloomberg Quint, and we went to and fro because I had made some suggestions which the editor-in-chief, very, very known and well-read editor, she was not agreeing with me. My claim was that, especially when the standing committee said we should bring a code of conduct for creditors, the question that I asked myself is this the right way to incentivize insolvency, regime? So, from that questions and interaction with the Bloomberg editor, I involved my students because that's what I do. I'm a teacher, so also encouraging the next generation to research with me. We said that, okay, we talk about IBC bringing a behavioral change. How do we measure that? So and what kind of behavioral tools have we used it? So everybody has spoken about it. Mr. K.V. Subramaniam has spoken about it, but nobody has given us evidence or data. So what we did was we tried to see where do you see the effervescence of behavioral change and tools? So one was that lower default threshold incentivized people to, it sort of nudged creditors to take a case and also sort of nudged the debtors to settle their claim. And the data sort of showed that. We reached out to IBBI to ask for two types of data, because if you see in the whole process of CRP, the two stages where the settlement is happening. One is happening at the stage before the admissions, when the cases are filed but withdrawn. And the second is under 12A. So we got the data for 12A, and this is a work in progress. We're looking at the different sectors, bench-wise also, and seeing where the settlement have sort of happened most. And we are still reaching out to various sources to get the data for the settlement before the admission. But while we were doing this exercise, we found IBBI newsletter, which clearly showed that more than 50% of these cases are being settled. So the question that we have to ask ourselves now is that the fact that we raised the default threshold to 1 crore, is it a right policy approach? Because data shows that lower threshold was nudging people to settle their claim. I may not be able to answer with certainty right now because IBC was suspended, and we still have to get data for the period post, the default threshold was increased. I also went to read a lot of literature. Now, if you see, the American literature is full of behavioral economics tools being used for insolvency. And one of the study we found was by Daniel Moken and Nina Hager. And what they did was they tried to lower the default, credit card default, by using behavioral tool. And what they did was in the IVR menu, they just put it up certain ways. For example, the bank would make a call and say, what is the likelihood of default? So in their work, they identify two types of delinquents. One is who will not pay the credit card bill. The other group of people were who may have forgotten to pay or who may have tendency to forget to pay the credit card bill. So in the menu, they would ask questions like, will you be paying in next 3 days? They came back and they tweaked the IVR. And they asked question like, are you committed to pay in 24 days as you had said? And it's a very thoroughly researched paper, and they found that the overall default on credit card decreased by 2.6% by simply changing the way IVR was designed. So taking cues from there, I'll not take much long because it's work in progress, and I hope Shukla sir will allow me maybe next year when the paper is complete. We looked at what are the tools of behavior change, what are the tools of behavioral economics that could be used. So of course, one was aligning incentive. Now, we had to look at various stakeholders and see where the gaps are. Now, a lot of brouhaha about Committee of Creditors, COC pushing towards liquidation. I've written very vigorously about it in various newspapers, and I still maintain that liquidation rate is not the way you look at an insolvency regime. Germany has the most sophisticated insolvency regime. It has 90% of the cases under their insolvency goes for liquidation. So even if you say one company, you have done your job. So I really applaud IBC on that point. So, however, how do you incentivize? One way I thought could be, and I think that is where my discussion with the Bloomberg editor started, was that if you understand what is happening in the current situation is that when the borrower has defaulted, they go to negotiate their settlement. Now, if you look from psychological and from science, behavioral science perspective, they already lost the game. They lost skin in the game. So the bargaining power of borrower is lower as compared to the creditors. So my suggestion was in the inter-creditors agreement, can we give as a matter of right to the borrower to have OTC, which anyways RBI allows, OTS, one-time settlement. Now, when they go for one-time settlement as a matter of right under the ICA, creditors will not push for higher haircut. Also, we are incentivizing the borrowers to announce predictability of default, which may have not occurred yet. Why? Because there is no pains for announcing that they have probability of default occurring. So under an ICA, if a clause could be inserted, and I've reached out to my JIP students to discuss what are your thoughts on that. Of course, some of the students who are working with banks discouraged me and asked me, don't write about it. But I thought it's an academic place, we must talk about this. The other is choice architecture. The choice architecture suggests that we have to give choices to the borrowers and creditors. Now here, even under PPIRP, the pre-pack regime, we are making it so code cumbersome. So can we find a way where we give choices to people to restructure outside court as well as inside? And I'm really happy to see that mediation is now coming as a precursor. That is strengthening the choice architecture. What we need to be careful about is, with all respect to the NCLT, NCLAT, if one stakeholder which is failing IBC is the courts, with all, and I understand their problem also. There's a problem with them. They have a lot of structural limitations, but they're failing. I did a study for IBBI, and we found that maximum delay is at the stage of admissions. So anyways, coming back to the point is that you give choices which is not involving courts so that the finality is reached. In the morning, we were mentioned about giving right to shareholders. That's a discussion for another day. But evidence shows that DIP model has not worked for India. BLRC itself says 4.2 years was average time taken by cases to settle. So I don't think we have to change the DIP model. We just have to align the incentives right. So choice architecture, aligning incentives right, and looking at the ICA and addressing the problem of probability of default within the intercreditors agreement. So these are the three aspects we have taught, and this is a work in progress. We are happy to have any comments that you have on this. I think, yes. Time is up. So, if I am within the time, then I hope that the panel will applaud us for being well within the time. Yes. Yes.
What the IBC has changed or action, legal action from NPA date to default date. So almost 90 days preceding the NPA date. But if you go into the question of, as you said, why a borrower will default, we should go into that question also. You have partly gone into that. As a banker's view, I'm sharing with you. See, it is kind of an option when a bank gives a loan to a borrower. Basically, it is selling an option to the borrower to default or not to default. As simple as that. If I have taken money from the bank has taken some collateral from me, or maybe a clean loan, like a personal loan. So now it is up to me, should I pay or should I default? That's an option available with me. Right. Now, every option has a strike point, strike rate. What is the strike rate here? Strike rate is the collateral available with the bank, which may be in the form of my reputation. Like earlier in my previous generation, people never used to default because it was a clan and they feel that in the society they'll lose face. But in my generation, today's generation, that kind of clan culture has gone. We are into nuclear families. Even if I default, my neighbor doesn't know I have defaulted to the bank. I'll get some mail in the mailbox that you're defaulted and I'll take action. Nobody in the society knows. So how to create incentive in this situation? Because sometimes what happens when I give the loan, I take some margin. So my loan is 100 rupees. My worth of collateral is normally 125. That is what we do in bank. Over a period of time, the value of loan goes up. Like I give some increments, enhancements. It may be due to non-payment, some interest accumulates. It becomes 125, whereas the value of the asset goes down. Valuation can go up and go down in a dynamic market anytime. So the problem comes when this borrower thinks that today the value of my collateral with the bank is lower than what I owe to the bank. I have seen that in the last few years when the property market was down. A lot of collaterals given in the form of real estate, the value went down considerably. Due to that, many borrowers came to us, sir, we cannot pay. You enforce my asset and take away, because he was not able to sell that in the market. So how to create incentive in this situation where borrower is in the money. If he defaults, he is in the money. He has the option to default and he is inclined to default. Whereas banker, ultimately, he takes him to the court. And then second point, you said the ICA or the agreement. Second point is how to enforce the agreement in a situation in India where enforcement of agreement is a
big task. Totally. So thank you sir, to answer your first question. One way we suggest in our paper is creating echo chambers. That's one tool that we use in behavioral science. So so we suggesting ways how echo chambers could be created for the borrowers as well as creditors to reinstate and reduce the probability of default. Coming from an academic side and understanding the philosophy of contractual bargains very well, I strongly believe that banks should not be staved at the, with all respect to all the bankers here, at the point, courts are not bound to save you out of a bad bargain. That's a fundamental settled law across the globe, that courts are only interpreters of contract, not makers of contract, and they'll not save you out of a bad bargain. So banks have you bargained wrongly. So one way banks could have done is, at least what they do outside India, is that they'll diversify the portfolio. They'll keep they'll be active participant. Like in long infrastructure contracts, you'll have one of the members sitting on the board being actively involved in that. So one of the papers I submitted to IBBI last year in the annual report was that can you think about a way that corporate governance is strengthened before the default rises? Because everybody's talking about insolvency when the default has happened. The conversation should happen when the contract is sort of entered into, so that there's no default happening. But I understand the problem is because banks are also under a lot of pressure to lend in a especially priority sector. So I think this kind of freedom banks also don't have to choose who they want to lend and all that sort. So we are working on our suggestions on how to create echo chambers, one of the tools used in behavioral science, and we'll be very happy to share with few of you volunteered, and you tell us what is the workable solution for those, because we are coming from very, very theoretical standpoint. We're not sure about its workability in the court. So that is all that we have to say, and we'll rest the presentation here. Thank you so much for your patience.
Thank you, Dr. Shikha and her team. I'd like to inform that they were well within time limits. The presentation was well within time limits, and the question answer session took about 3 minutes. So just in order to be fair, I think henceforth, after each presenter, there should be allocated a time of nearly 5 minutes for answering questions. The next presentation is on interim finance in creditor-oriented bankruptcy courts, a study in the context of IBC India. It would be presented by Mr. Amol Bakshi.
This is for power digital battery.
Yes. Should I do it over here?
Okay, that is very nice of you.
I would just, this is the
Okay. Good afternoon, respected panelists, distinguished members of the audience. I am presenting a paper on topic on interim finance and credit-oriented bankruptcy codes, a study in the context of IBC India. I thank IMA and IBBI for giving me this opportunity. My name is Amol Bakshi. I am presently doing my PhD at Indian Institute of Foreign Trade. Apart from my PhD, I also possess work experience in the NBFC sector in the areas of structured finance and stressed asset management. Just to briefly describe how I've organized the presentation. In the first few slides, I will briefly discuss the motivations for research, objectives, methodology. I'll briefly outline interim finance under both IBC as well as the DIP model. I'll present the first finding, which are the distinct dimensions of interim finance, both in DIP and credit-oriented codes. I'll then discuss the results of the qualitative methodology which I've used, which are basically interviews to identify the issues and challenges of interim finance market in India. And I will integrate this to present the discussions and conclusion. Now, just coming to the motivation for research, what motivated me to pick up this topic and examine it further is that interim finance is extremely important to the bankruptcy process, and lack of interim finance can significantly delay the process and also threaten the going concern status of a corporate debtor. This is well established. Even in the morning session, there were references made to interim finance and its importance. Enabling legislation allowing interim finance and according repayment priority to interim finance lenders is recognized as a good insolvency practice. And even in the World Bank Doing Business report, they used to measure strength of insolvency framework. One of the indicators was the ability to raise interim finance. Now, the World Bank DBR has been discontinued, but this was one of the, it is an established indicator for strength. There's also a lot of debate ongoing on the efficiency and effectiveness of bankruptcy codes. So the subject of interim finance becomes even more relevant as an important input to the bankruptcy process. While there is significant literature on DIP finance and the debtor-friendly codes, we find there is less known about interim finance in creditor-oriented codes. So when we talk of debtor-friendly codes, we are essentially talking of a insolvency regime where the debtor remains in possession. This is against creditor-oriented regimes where the existing management is suspended and a court-appointed professional or a resolution professional is appointed. So this paper essentially tries to examine whether there are distinct dimensions between the two forms of financing and the two different insolvency regimes. And also the one last motivation or significant motivation is that the segment remains challenging despite enabling provisions, with many insolvency professionals struggling to raise interim finance for the CIRP cases. The objectives of the methodology are twofold. One is to answer the research question whether interim finance has distinct dimensions as compared to interim finance in the West under DIP model, to analyze the practical issues and challenges in raising interim finance in India. For both, qualitative methodology has been employed. For the first objective, it has been primarily through the theoretical lens. In the second objective, I engaged with interviews with a group of insolvency professionals on an individual basis, and also some select lenders. This methodology was adopted to finally identify practical challenges in this sector. Please. In the next 3 slides, I'll very briefly touch upon the requirement in interim finance, which all of you would be, I'm sure, well abreast of. Interim finance is known by many names. It is also called post-commencement finance, post-petition financing. It refers to finance raised by insolvent corporate debtors during the bankruptcy process. This can be either raised at the commencement of bankruptcy process, or it can be raised during the CIRP process. The main objectives of interim finance are to meet various costs during bankruptcy. It so happens that during the CIRP process, bankruptcy process is called the CIRP process in India, so I'm using the terminology. The corporate debtor may not have any cash flows or any bank balances, which is often the case. But there are routine expenses to be run to maintain the company as a going concern. Apart from that, there are CIRP costs also to be met. So interim finance from an external entity becomes very important to ensure continued operations of a corporate debtor, to protect and maintain value of assets of corporate debtor, and support survival of a firm through reorganization or going concern sale and liquidation. This has been recognized as an objective of interim finance. Now, the IBC has enabling provisions to allow RPs to raise interim finance, subject to monetary limits prescribed by the Committee of Creditors. Of course, if security has to be provided, the insolvency professional needs the approval of the Committee of the Creditors. Any interim finance raised is recognized as part of CIRP cost, and so priority status is given to take out of this interim finance in the waterfall mechanism. This is also a very important aspect of interim finance recognized internationally, that if you want to motivate lenders to lend interim finance, you have to accord them priority. Otherwise, nobody will lend an insolvent corporate debtor. There was also an amendment in 2018, where in the event of liquidation now, interest for 12 months post liquidation commencement date is allowed as liquidation cost, and that is also accorded priority. I'll briefly touch upon DIP financing. Now debtor in possession financing is a form of interim finance in debtor-friendly creditor bankruptcy codes, and it has been very popular. As per research, over half of the corporations in America, in the US, have raised debtor in finance, those corporates that have filed for bankruptcy. It is defined as a special type of court-approved financing extended to firms filing for reorganization under Chapter 11 of the US Bankruptcy Code. Now, the US Bankruptcy Code has distinct chapters, one for reorganization and one for liquidation. And companies that are normally referred to under Chapter 11 are normally do so with a prior financing plan in mind. DIP lenders are allowed super priority as well as security status. And on analysis of literature, it was found that the literature around DIP is quite extensive, and it is quite legal in nature, given the topic, but it has been around three major points. One is the importance of DIP financing to the process. So literature has found that DIP financing is very important to efficiencies of bankruptcy outcome. It reduces signaling. In fact, when companies which have listed companies which have announced that they are raising DIP finance, they have found the stock prices to significantly increase upon announcement, because it indicates the reorganization prospects of such corporate debtors. There have been discussion on limitations, that it induces overinvestment because corporate debtors have funds, insolvent debtors have otherwise access to fund. It also induces security top-up by existing lenders, which is called roll-up, where existing lenders use DIP finance as a means to augment their security. The second type of category of analysis has been done on type of firms that receive DIP financing. Some research has said large firms are better off receiving DIP financing because they have greater information availability. Of course, small firms also get DIP financing, and it largely depends on the motivation of lenders. For example, hedge funds and private investors which seek control of a firm may prefer to select small firms from an ownership point of view. And the most important aspect of DIP financing has been control governance implications. In fact, it has been described as the most important lever by which lenders exercise control and governance on an insolvent debtor. They do it for two reasons: to balance the debtor-oriented friendliness of the code, and also for control motivation. So these are the dimensions of DIP financing. Now I come to the analysis of the distinct dimensions of interim finance in DIP versus creditor-friendly codes. While both forms of interim finance are important, it is very essential to understand the differences in order to better appreciate the nature of interim finance under creditor-friendly codes such as IBC India. If we talk of the conceptual basis, as Chapter 11 companies typically get DIP financing at the outset is for reorganization. Whereas when we talk of IBC in India, at the outset there is no clarity whether a company will be reorganized or a company will be liquidated. This is something that gets decided during the CRP process. So the funding is typically raised during the CRP process, and the uncertainty element is a little higher, one can say, or one can in the CRP regime in creditor-friendly codes. When we talk of timing of raising DIP financing, research literature has shown that majority of the companies raise DIP financing very early in the process, sometimes even prior to admission of bankruptcy by the pre-petition lender, or at least within 30 days upon admission to bankruptcy courts. Now, when we talk of approval process, in DIP is a court-approved process. The court has significant powers. They can even take away they can even allow security sharing with existing pre-petition lenders. This is unlike the case of India, where it is creditor-driven and controlled by the Committee of Creditors. And the most important is motivation to lend. This analysis has found that relationship lending and control and governance are two major motivations for DIP lenders, because the debtor continues in possession. So lenders typically continue the relationship motive angle and lend money to the company because they know the debtor, if it is reorganized, will continue in its existing form to control possession of the debtor. And in terms of control and governance, that is also a motive which we have discussed. But in the case of creditor-friendly codes, such as IPs, this paper argues that since the RP is in control, there is no question of control and governance motivations of lenders. Control and governance rests with the RP who is managing the affairs of the company. And relationship lending is significantly diminished in creditor-friendly codes, is the argument of this paper. Now, for the second findings relate to the results of the discussions held with resolution professionals to find out the practical challenges they have faced in mobilizing interim finance. I'll briefly run you through before discussing from a larger perspective. From an importance perspective, majority of the respondents perceived interim finance to be very important to the CRP process. And some people even mentioned that, some RPs even mentioned that certain expenses are so critical and funds are lacking, the lack of funds, they have to meet the funds through their personal corpus. In the question of ease or difficulty in mobilization, majority expressed that interim finance is very difficult to mobilize, and it has been divided into two categories. We have divided this, we asked them the question whether it is for lack of willingness of external lender or is it from the COC side? Where are the practical difficulties which lie, which I'll discuss subsequently. They also mentioned that apart from participation, it is very difficult to get NOCs from existing COC lenders to raise external finance from outside lenders. The other practical difficulties, finance is often at a very high interest rate, and even where it is available, the DD time is so much DD time is taken because the insolvent debtor is being lent to, that it defeats the very nature of interim finance. Some respondents said it's easier to raise finance for firms having hard assets, but some differing expenses were provided on ease of raising for running companies. Some respondents felt running companies get easier interim finance. Some felt that it is more difficult because prior to, it's more difficult because it is not the lender's responsibility to fund salaries and other going concern expenses. Now, I also checked up on the specific issues from the perception of the respondents on the issues from the external lenders and issues from the COC. From the external lenders, the main problem that has emerged from the study is lack of takeout visibility. Now, takeout visibility is divided into two aspects. One is the quantum of takeout visibility, and the second is the timing of takeout visibility. In terms of quantum, there is uncertainty on liquidation or reorganization outcome. There is a perception that the CRP costs are very high compared to the recovery proceeds. In terms of timeline, which is most respondents said they do not know when the CRP process will get over, and there are judicial delays. Not only, it is not the question of saying it is the fault of the judicial, not like that. There are delays in the CRP process. Lenders cannot extend perennial financing. There has to be some limit of repayment, etc. There is lack, and second, they mentioned lack of participation from COC. They feel that the external lenders are unwilling to participate where there is a, if existing lenders are not participating, they do not get comfort on the reorganization prospects of the corporate debtor. And third is the lack of incremental security. Now, from the existing COC side, as somebody mentioned, I think in the presentation earlier, unwillingness to throw good money after bad. That is the primarily demotivating or rather a hurdle why existing COC lenders are reluctant to lend interim finance. Takeout visibility, of course. COC perception of interim finance as a stopgap arrangement or just for recovery. So there is a lack of holistic view of interim finance and how interim finance translates into protection of value of debtors' assets, and from there it translates into recovery. If it is just being viewed currently from a perspective of a going concern expense to meet normal CRP expenses without looking at the larger picture. And composition specific nature of COC lenders, there was some feedback received that this is also an important aspect. For example, if the COC lenders comprise ARCs, or they may have specific mandate where they are not able to lend to interim finance, that is also a major roadblock. One disconnect which emerged was the definition of interim finance. I have looked at the interim finance to mean external as well as existing COC members. However, some respondents said that interim finance raised from lenders cannot be construed as interim finance technically, because existing lenders typically provide an advance and they don't charge an interest rate. But then this was clarified at the outset that it is more of a technical in nature, and the interim finance refers to all forms of finance or funds raised during the CRP process. Some lenders were engaged. The feedback were more or less the same. Only two perspectives emerged. The lenders are very cost conscious, obviously, having lost money already, and they therefore believe that the CRP costs are stretched compared to the recovery prospects. There is some inherent tension between the RP and COC. One lender felt that allowing interim finance early will not provide the RP any incentive to squeeze one can say stretch the assets of an insolvent debtor and extract as much cash flows which are available. Now, in terms of normative suggestions received from respondent, they have broadly been on the COC side and regulation side. COC side, definitely most respondents said that the COC has to contribute, it has to be made compulsory. There were some alternate perspectives received that we cannot force commercial decisions on COC lenders. They are governed by RBI and their banks, etc. And it is not prudent. From a regulatory perspective, some suggestions were offered that allow IPs to raise without COC approval once the budget is finalized. Allow some corpus support from regulator. Let IBBI provide some corpus. And market is NBFC oriented. There should be policy impetus provided to banks for provision of interim finance. Now, putting this all together, I'll come to the discussion and conclusion, just ending right now. This paper finds that the barriers of high interest rate and security demands of lenders of interim finance are essentially symptoms linked to larger structural issues facing the interim finance market. At the outset, regulatory clarity may be provided on technical inclusion of the COC funding towards the interim finance definition. Whether COC funding can technically be incorporated as interim finance, but this is more technical in nature, but it will provide more homogeneity in the community. As far as the lack of visibility on takeout and timing of takeout is concerned, this can be said largely to be linked to the efficiency of the bankruptcy code, sir. And once the other issues of the efficiency of the bankruptcy code, such as the timelines, etc., are sorted out, the author feels in this paper that certain structural issues can get resolved, and this will give lenders more confidence to lend. Support of COC is very critical. The narrow perception of interim finance just being a stopgap arrangement dealing to asset value protection and ultimate recoveries remains a bottleneck. So greater stakeholder engagement can broaden perspectives. Coming to the tensions between this RP and the COC, the RP is guided by resolution, as many esteemed panelists speakers have earlier spoken, that the primary objectives of IBC are resolution. Lenders are guided by recovery. Now, this is an inherent conflict in the code. It cannot be altered. In fact, one research paper, I remember reading, I forget the author, he said nowhere is the conflict among creditor classes the greatest as during a bankruptcy, as in a bankruptcy process. Now, but however, this paper recommends that a greater ex-ante consideration by lenders or broader objectives of IBC and associated dimensions, such as interim finance, is necessary, preferably prior to triggering of the code to reduce ex-post conflict. So lenders, when they trigger a bankruptcy code, they should understand the dimensions of interim finance and its requirement, and taking a leaf out of DIP, more upfront planning for interim finance along with identification of suitable type of lenders will save time during the bankruptcy process. DIP, as I mentioned earlier, is tied up very early in the bankruptcy process, sometimes even prior to triggering. For borrowing best practices from that, this can be thought of as more of a normative suggestion for lenders who trigger the bankruptcy process. As noted by a well-known researcher, triggering bankruptcy without thought of funding is recipe for trouble. Now, interim finance makes sense for supporting reorganization of viable firms or enabling sale as a going concern and liquidation. Now, more research is required on the role of CIRP, firm profile. Differing firm profiles will meet with different success in terms of raising CIRP. And heterogeneity of COC, how does it impact the success or ease or difficulty in raising interim finance? These are suitable research areas for IBC and the creditor-oriented codes. These have been significantly debated under DIP model. Coming to conclusion, there's little doubt interim finance is important. Interim finance and the creditor codes have inherent limitations and need to be viewed in perspective, distinct lens. Takeout visibility, uncertainty, lack of holistic view of interim finance, and differences in objectives of RPs are some of the important bottlenecks which we have discussed. Can be improved with better functioning for IBC efficiency and greater stakeholder engagement for aligning objectives. The greater ex-ante consideration by lenders of objectives of IBC and its associated dimensions while triggering code and more early consideration can reduce exposed conflicts. Analyzing borrowers' health and reorganization prospects will contribute to systematic approach to mobilization because different lenders can be approached for different types of insolvent debtors. It is not that only one type of, so a more systematic approach is required while solving the insolvency process. Now, many normative suggestions were received on forcing COC lenders to participate in the corpus funding or interim finance. It is recommended to find a more balanced view with larger universe of IPs and lenders. This study's limitations, like all studies have limitations. This study limitations was it could not access a very large universe of lenders and IPs. Lender community is largely very heterogeneous. You have to look at NBFCs, you have to look at banks, and you have to look at different types of investors, and each will have the differing objectives. So one cannot paint with the same brush while selecting the sample. And lastly, a monitoring metric is suggested, where maybe one can look at some database of debtors, corporate debtors, which have been successful in raising interim finance and what their outcomes have been. I tried to get this data from published sources. I was unsuccessful. I requested IBBI, but I think if we can, thank you very much. No, I am okay. Any questions, please let me know.
But as I understand, because interim finance get a super priority over all other types of, it's a CRP cost, part of CRP cost. So security is a non-concern. Because in any case, whether you have a security or no security, you are paid upfront. So security is non-issue here. Second question is where to sanction? Because which particular CRP should we sanction this interim finance, where not? Because bank, when it's taking a new exposure, it has to be very careful. We cannot just throw, as you said, good money after bad money. So there are many cases which it's clearly visible that they are going into liquidation.
Yeah.
So I may not be getting, or maybe getting 10% of my existing exposure. So why should I give further? So the consideration for the bank is that it should at least be a going concern, or maybe a unit which can convert it into a going concern through infusing some interim finance. Unless that is there, I don't think bankers will be convinced to put money here.
Yes.
As regard your CRP cost, that can be funded through some other alternative, like now there is a provision or regulation for liquidation cost.
Yes.
Similar provision can be brought in for CRP cost also, but that may not be interim finance. Can we put like some upfront money banks have to give to run the company during?
Yes, sir.
Third will be assessment, how to assess the requirement. Because RP will say, may require 5 crore, may say, I want 50 crore.
Yes.
So how to assess that? So that is the third problem with the bankers.
Yeah.
So we have come out with a solution here, like the RP has to give me some visibility about the cash flows during the CRP process. He knows, because he has the handle, he has the visibility, he gets the payments, makes payments. So he has to give me a cash flow of at least 6 months to 9 months or maybe 1 year from the date of applying for interim finance. That cash flow, and then he'll have to give me some rolling cash flow also every month. As I get stock statement from a borrower every month to get a visibility of where I am in terms of my exposure and my security. So this is very important. He should give me a cash flow for next 1 year. Sir, fifth thing is like how to cover this. Because if I am giving interim finance for a liquidation, I am putting more good money into bad money. So what he can convince the COC that he give me a enterprise value in case this concern, which is a running concern, if we take it and sell it as a going concern, you get an enterprise value. If we take it to liquidation without interim finance, you get a liquidation value. There's major loss of value. Then banks has an incentive to seek giving some, say, good, small percentage, maybe 5% of the exposure, and taking the enterprise value as a recovery will be much better than taking the liquidation value at the end. So that is a critical part, how the RP is able to convince the COC his capability of running the unit as a going concern first, getting a resolution plan at the end of it, and then the resolution plan above the liquidation value. It should be above. So that is the one. And lastly, as you rightly said, the clawback or the recovery, because banks are bound by RBI guidelines. Yes, if I don't get my interest for 90 days, my account becomes NPA. So I give some good funds, and 90 days I don't get any interest, my interim finance is declared NPA. So how to find a solution to that? What I suggest is that in this kind of account, there should be monthly payment of interest also during CRP.
Yes.
For other claims, we don't pay interest during CRP, any other claim. All interest installment recovery is stalled. But for interim finance, there should not be any prohibition. So the RP should arrange payment of interest also at least once in 3 months so that account doesn't become NPA. Lastly, COC, it will be very difficult for the RP to take interim finance from all the members. Some may be non-financial institutions who may not be interested. So it's better that you go to one member, maybe largest member, you request him, because he has super priority in any case. He doesn't have to share it with others. Let him charge the higher rate. That should be the incentive. So don't criticize the hard rate. Higher rate is an incentive for sanctioning interim finance. Only thing is you let one bank take it entirely and then recover at the end of the CRP or liquidation upfront.
Right.
Thank you. We have already come out with a product here from SBI, and the circular is already out. If you apply to SBI today, I think in a going concern, chances are you'll get.
Look up that, sir. Anything, sir? Thank you.
In the CRP, under the IBC. But you said that in the DIP, in the Section 11 proceedings, the LTL and LTO is working well.
But, working well in the sense, it is there.
There are good sort of response, at least you are writing in the paper.
Yes.
What is your take that LTO in the creditor in control model also can be workable? Like the problem is that the firm is already in a situation where it cannot raise funds. Cost of borrowing and cost of equity both are going to be very, very high. So like the private equity, hedge funds, venture capitalists, they can perhaps take some sort of the LTO conditions or the veto powers, allowing the successful resolution applicant with the consent of the RP. Something of that sort could also be worked out. I think the LTO could be worked out in the credit control model too.
Because certain companies which are very stretched, like there's a distinction between insolvent companies and companies facing liquidity issues, as it has been pointed out. So certain LTO lenders typically have control motivations. In DIP, what I have read is that they come in with the entire objective of participating in the final resolution and taking control of the firm. So LTO lenders typically are hedge funds or those kind of investors with high risk appetite, and they don't mind targeting small firms because they see some value either in the assets or overall firm. So that kind of model can also work here, but that also has a disadvantage because that may not be workable in the sense that they take a lot of, they want control and governance, through governance. They stipulate so many things. Under a RP control regime, you may not be able to stipulate such things at the outset. This can form part of when the company is reorganized and when there is a new buyer. Maybe a LTO lender type of lender can come in at that point of time, sir. Is my humble view.
I have seen cases where they are not taking really total the management control.
Yeah.
They are taking some veto rights on some policy decisions.
Yes, sir.
To some sort of secure their equity investments or the preference investment. I'm not sure whether it can be working. But there could be good cases where their resolution is possible.
Yes, sir.
The hedge funds, venture capitals are
But,
the private equity could perhaps bail out the
yes,
company.
yes. In fact, that's why if there is an early consideration on the type of financial profile of the company, then the type of lenders also is very important. So there's a more systematic requirement of approaching this issue early in the CRP process. That is what this paper recommends. Thank you.
Can you make it last question?
Yes, sir.
Raising the interim finance from the company's point of view.
From the
companies, the company which is
RP
going under the
perspective.
CIRP
Yes,
or the
yes,
liquidation
yes,
from
yes.
that point of view. It would be worthwhile seeing it from the perspective of the lenders.
Yes, sir.
Because they would have a lot of apprehensions in lending the money to them because of their past track record and other things, and because the money may not be get through. Like in US, UK and other countries, there is a big market which is being developed for this kind of interim finance. Those bankers or the non-banking finance companies, those who are willing to give this interim finance to these ailing companies. So have you done any research in perspective of the India that such market is being developed, and what are the apprehensions from the lender's point of view to raise this interim finance?
Yes, sir. As I mentioned, this paper also covered some lenders' views. And in fact, in the limitations, it is mentioned that because of the lending community is very heterogeneous, you have various types of investors, various types of lenders. This needs to be a topic of a separate paper as far as lenders' views are concerned. But you're absolutely right. All stakeholders' views need to be taken. But the RP, this is from the RP's perspective and a few select lenders in this paper. But the RP has a view on the ground level challenges. This paper focuses on the ground level challenges. So I won't take much of more of your time. Thank you very much.
Thank you. We have the third paper presentation. The topic is Section 32A of IBC, Conundrum or Protection. It would be presented by Mr. Mayur Juktawat and Mr. Vishal Dave. I request the questioners to stick to a 5-minute time limit because we slightly exceeded it in the past presentation.
A very good afternoon. So after lunch it is very difficult, I know. So today I have a very burning issue. So I think it will help all of us to be more attentive. So section 32A. So as we all know that IBC is the most innovative and piece of legislation. We all know the benefits of IBC. Everyone knows maximization, revival of a company, promoting entrepreneurship. But the most challenge is once the law takes in motion, once the CIRP starts, RP, or if you go into liquidation, the liquidator is the most important person who has to do the job. By taking everyone along in a single boat, together all the stakeholders, right? So one issue came suddenly because we all know that Enforcement Directorate, ED, is the most aggressive, active enforcement agency in India after CBI. I mean Central Bureau of Investigation, not Central Bank of India. So it is the most active. Now whenever a enforcement agency comes into picture, it scatters everything. And in the implementation of any process, it becomes very difficult. So from a lawyer perspective, when ED comes up and sits on the assets of the corporate debtor, RP can't do anything. As in one of the precedent, it has been held in SR judgment that RP or the liquidator is appointed by a forum or tribunal, is a public servant. And even any officials of ED are also public servant. So whenever ED comes up in picture, sit over the assets, then everything stalls. And the main objective of this code is a time-bound manner. Because earlier, whatever the recovery laws were there, for years and years together, we lawyers used to enjoy and interpret and go from one forum to another, and recovery was stalled. So it is a time-bound law. But since the new challenge came up, whenever the enforcement agency lodges prosecution, attach the asset, these stalls. So this issue first came up in one of the judgment of JSW, wherein the resolution plan was approved. And as soon as it was about to implement, a Pandora box came up. AD says, now you stop. So that is why it was need of an hour that ordinance has to brought into when Parliament was not in session. So it's good that the legislature from the IBC perspective is the most alert that every time a new issue comes up, it brings an ordinance or the amendment in the law so that the entire implementation process is smooth and nature. So now we talk of 32A, which has brought into the picture. Now what is the object of 32A? Is to protect the corporate debtor and his assets from being prosecuted for any offense prior to CIRP. This is the object. But we need to understand, basically, law is very clear, but at what stage this section will trigger? So this is the most important thing we need to understand. As per the section, it says, when a plan is approved by NCLT, this section will trigger, or when there is a sale of the liquidation assets. So the object is that whosoever comes with a new management will get a clean slate and can start afresh their business. So this is the prime object. So the new management must not be attached with the prior office bearers, directors, promoters, or whosoever who has committed any offense under the Act. Now, though the law is very clear, but still the enforcement agency is like, there is a clash of the titans, that who is the heavyweight, whether it is the IBC or the PML Act. Because normally what happens, whenever there is a statutory powers conferred under any act to anyone, for example, RP having a statutory powers, ED has their statutory powers. So there has been a history in the legislation that when there is a clash of the powers, statutory powers, either one will overpower it and other will not surrender it. And in that case, who is the mediator? It is the judiciary. So a lot of people, it is very easy to criticize courts, but whenever a law comes and there is a constant practice in our system, the law always goes for the constitutional validity. So all the maybe any litigant challenge the law under the writ jurisdiction to test the validity, whether the law is settled or not. Some say it is challenging a law is waste of time. But from my perspective, if you say, it's a very good thing. Because whenever new amendment comes and when the constitutional validity is challenged before the highest court of law, and when the law is upheld by the highest court, that means there is no further interpretation. There is no further confusion. There is no ambiguity in law. So this makes the implementation of that section very easy. That is the reason constitutional validity is very important. It gives the clarity that what is the purpose of the act. And whenever the highest court of law, either they read down the law or they struck down the law. And the intent of the legislature is always defined in the constitutional validity. So again, whenever 32A comes, still it was challenged with the Supreme Court. It was challenged with the Madras High Court. and the court has upheld the law that no, there is no ambiguity, and the corporate debtor has to remove from the rigors and its asset so that the object of the IBC could be fulfilled. So this is the constitutional validity which I talked about. Now that comes the interplay. Still, the litigation in here will never end because ED will not going to surrender very easily. So when there are two central acts, two statutory powers, even under section 238 of IBC, we have a overriding effect. Even the law says that the later law will prevail over the earlier law. So these are settled precedent, but then also the ED says no, that it is from the proceeds of crime. So we have the right and we will attach it. You can't do it. There can't be any resolution. So the conflict still exists. Now, I'll come to one practical situation. As I said, that once the plan is approved by NCLT, 32A will automatically trigger. So attachment or anything, maybe confiscation or anything done by the ED has to be removed, or under the sale of asset under the liquidation process. But what will happen, suppose prior to CARP, there is an attachment. And once the company goes under CARP, admission order, very enthusiastically IP is appointed, he goes with an order and takes the possession of the secured assets. And at the gate only he is stopped by the persons, who are you? He says, well, yeah, I'm a court appointed officer. No, we don't recognize you. You go from here. And if the RP try to mess up, very easy, issue summons, call for the record under section 91 CRPC, you come, give you statement. So this is the practical difficulties the RP faces. And if RP goes to the NCLT, sir, I am doing my job. I went there, wanted to take possession. There is an attachment, kindly help me to direct the ED to release the attach so that I can start the process at least. NCLT says, I'm sorry, I can't help you. Because I don't have any jurisdiction. Because unless the plan is approved, this section could be invoked under my jurisdiction. So where should I go? The NCLT said, you do one thing, I'll give you one suggestion. You go to PML tribunal or authority. So the RP has to again go to file an application before the authority under the PML Act and has to request, sir, this is a law, this is for revival of a company, tell your ED to release it. No, we'll still, let me examine it. So you imagine when a time-bound law is shattered, RP or any other stakeholders is not able to do anything, then what is the issue out of it? And same thing is happening if a company goes into liquidation or during CIRP or during liquidation stage, a provisional attachment comes. So this is a practical difficulty. So now this issue at large is still pending before the Honorable Supreme Court. That if you see the literal interpretation of section 32 says that any offense prior to CIRP, and then in the subclause there is a trigger for at the time of approval plan. Now this practical situation only comes when the law is implemented, and this is the practical difficulty. That is the reason now whether, because RP is an appointee officer under the IB code, obviously my adjudicating authority is the only jurisdiction where I will go if any face problem. If I go to some other forum for taking possession or for lifting the attachment, then the time-bound period of law has make no sense. And even the liquidation process where there is a time-bound period, there is no extension of time is given by the authority based on the litigation pending. Because when the assets are not there, what will I do? So in this scenario, the RP or the liquidator, what the case may be, when the assets are attached, he has to go to NCLT also, and he simultaneously to file an application before the PML authority also. And at both the stages, he has to go for the litigation. Still, this issue will not be settled by any of the precedent unless the Supreme Court will decide, or if the legislature deem fit, then they have to amend the law and has to clear this ambiguity. And otherwise, the object of the IBC for the revival in a time-bound manner will not be achieved. And there are other case laws which my learned colleague will take up the case laws, that how practically when the attachment comes, this happens. In many cases, the liquidator and the RP is called by the ED to give summons, to record their statements. In one of the cases, my learned friend will point out that how they have to face such difficulties. So these are the practical things, and that is where the court will come up and will interpret the law and may read down the law and make suggestion to the legislature. See, this is the practical problem. We are reading down the law and you amend it by way of any way, ordinance or the amendment. So this is the thing, and I'll hand over my learned friend to explain the case laws which are evolved in the present scenario. Thank you.
Thank you, sir. So we know that IBC was actually created to make the process easier. But nowadays, an amendment is making the things very difficult for various stakeholders. In one of the such amendment is Section 32A. Now, the object of Section 32A, why it was brought in first place, was to safeguard the properties of the corporate debtor from prosecution. Now, if we draw this provisions corollary from other statutory authorities law, there are various judgments given by various tribunals in which a charge created by a state tax authority or a GST authority has been vacated or removed by the way of NCLT's order. Now, in such situation, NCLT has observed that Section 238 will prevail over any other enactment. In present scenario, there are two special legislations. First is PMLA and second is IBC. Now, both the statutes have non-obstant clause, which is an overriding effect clause under Section 71 of PMLA Act and Section 238 of IBC Act. In such scenario, which is already, the law is well established by Honorable Supreme Court, that the later enactment will always prevail. And on the basis of same, various tribunals have given their decisions. Now, in the present scenario, the situation is such that a successful bidder or a resolution applicant, when purchases a company, he needs the company from the scratch. He needs that all the past wrongdoings which has been committed by the ex-management needs to be vanished. And therefore, Section 32A came into the place. Now, the problem which arises here is the trigger point when Section 32A can come into the force. Now, as we read the provision of Section 32A, it states that Section 32A will come into force when the resolution plan is approved or the liquidation of assets has been done under the code. Now here, if the CIRP of a corporate debtor is initiated and the attachment order is passed by PMLA, RP will have to continue such proceedings before PMLA. Now, in such scenario, RP will not be able to get possession of such properties because there is already an attachment of PMLA, and therefore those assets will not get those assets will not attract any investors because there is already an attachment, which will further create difficulties for RP. Other than such difficulties, there are also difficulties faced by RPs. In Bhushan Power and Steel case, which my senior colleague had already mentioned, it happened that after the plan was approved, ED had made an attachment. Along with the attachment, they also made an allegation against the RP that RP colluded with the ex-management and the finished goods were worth 700 crores were sold. So therefore, RP was summoned by ED. And in the similar cases, my friends are aware that there is a case of PSL Limited, which is a Gujarat case only. The RP was burdened with questions and interrogations by the ED department, Enforcement Directorate, and therefore RB had to approach Delhi High Court seeking protection under Section 32A. Now, PSL Limited case was dealt in detail by Delhi High Court. Delhi High Court made an harmonious construction between the two laws and defined the objectives of the two acts, PMLA Act and IBC Code. The purpose of PMLA acts to prosecute the criminals and not the assets of the corporate debtor, while the purpose of IBC is to revive the corporate debtor and to make it stand on its own leg again. And therefore, the Section 32A was introduced. Now, even after the assets are sold under liquidation, successful bidder is required to approach honorable tribunals in terms of reliefs and concessions. Now, why these reliefs and concessions are required to be given when there is already a protection which is given under Section 32A? There need not be any separate application filed or a separate protection that needs to be required to be taken from NCLT when there is a protection given under Section 32A itself. Now, what is the role of NCLT in such scenario? It has been already decided by Supreme Court in various cases like Gisuram Patel and Gujarat Vikas Nigam that NCLT is only having a supervisory role. NCLT is only having a limited jurisdiction with respect to insolvency only. And therefore, NCLTs and tribunals hesitate or resist themselves to interfere with other laws because they are already a statutory body and there are agencies which are established to deal with such laws. Now, when we file an application before NCLT and like a Sci-Info system case where there was a fraud of thousands of crores, that matter went up to NCLAT as well. But now there are two contrary views of NCLAT as well. The matter is pending before Supreme Court that my learned senior has also already mentioned, but there are two contrary views of NCLAT, where in one matter NCLAT has stated that PMLA the trigger point of 32A will only come when the resolution plan and liquidation of the assets are sold under liquidation. While in another scenario, the NCLAT has also held that IBC will prevail over PMLA and therefore no action can be taken against by the ED. In such scenario, there is a requirement of an harmonious construction between the two laws, because if we see the PMLA Act, and if we remove such confiscation of properties or attachment of properties, the whole purpose of PMLA Act will also fail. And there will only remain the prosecution of the individuals, which has been allowed by Section 32A only. Thank you. Okay. So I'll just conclude it, or you want to conclude it?
Now there is another issue in MSME also. Since there is a relaxation, MSME now under 29A, there is a relaxation that they can give a plan. Now suppose the promoters of MSME are prosecuted under the PML Act. So now since they are 29A, they can give the plan and take back their own company. So whether they will get a benefit of 32A down, there is another interesting interpretation has come up. So if you see the 29A, unless they are convicted, once they are convicted, they becomes ineligible or disqualified under 29A. So unless the trial is pending and they are convicted, here even if they file an appeal and they get a stay on the conviction, again becomes eligible. So again under the MSME there is again issue. So unless the 32A is not settled, this will be an issue. Yes. We are always short of time. Thank you. So any questions, please? Either my presentation was good or I'm not able to make you understand. Yes, but then also we can discuss academically. Thank you.
We would love that. If you are having another idea, you can mail to us.
Certainly. So this MSME issue, unless I am convicted, I am eligible and under 29A.
It seems you have other ideas too, and then
yes,
love to have them.
certainly.
Mail to us and
One small clarification. How
Please.
many cases you come across on the issue of 32A?
So
many?
Lots of issues. Day in, day out, NCLT is burdened with such applications because during CRP, there is an provisional attachment. As soon as the assets, they go and take the assets. During liquidation also. Now what is happening is that since this is a time-bound law, litigation is pending. On one side, NCLT says we will not extend the time period. And if we plead that, sir, this litigation is pending, unless the asset comes, what I will do? Then they will pose a question to us that what you are doing. So this is the practical difficulty. So we have faced rigor by the pressure from the court, from the stakeholders and everything. So this is an issue which has to be normalized. Otherwise, the object of the code of time-bound manner will not be achieved actually. And the litigation will be dragged for years and years to come. Thank you very much.
Next up, we have the final presentation for this session. The title of the paper is Streamlining CIRP, a Multifaceted Challenge. It would be presented by Mr. Ishan Jaipuriar and Ms. Rishika Raj.
A very good afternoon, respectable dignitaries, esteemed member of the panel, fellow researchers, ladies and gentlemen. I am Ishan Jaipuriar.
Good afternoon, everyone. I'm Rishika Raj. Our topic is streamlining of CIRP, a multifaceted challenge. Through this research paper, we have basically identified 3 problem statements and we are trying to address them. One is at the stage of admission stage and the other 2 being at the time of approval of the resolution plan. So the objective of our paper is that we are trying to streamline the systematic gaps which we have identified and try to come up with possible outcomes which will ultimately help the court to achieve its maximum potential. So Ishan will take.
So I would now like to introduce our first problem statement, which deals with the issue of misappropriation and plundering of assets of the corporate debtor right before the insolvency commencement. This 16th century quote from the Shakespearean play Merchant of Venice assumes some significance in this regard, and I quote, "This bond doth give thee here no jot of blood, the words expressly are a pound of flesh." The Merchant of Venice, Act 4, Scene 1. So this formidable argument was put forth by Portia in order to rescue Antonio from the Jewish moneylender Shylock. This argument signifies the sanctity of the asset that needs to be maintained, and no extra ounce could be misappropriated or plundered. This, under the Indian insolvency framework, is ensured by way of Section 14 of the Insolvency and Bankruptcy Code. The essence of imposition of moratorium under Section 14 is to preserve and protect the assets of the corporate debtor, to ensure a comprehensive resolution which would effectuate better value realization. However, no such moratorium is available to the corporate debtor before the insolvency commencement date. This gives rise to opportunistic and at times predatory behavior by the creditors who rush to appropriate the assets right before the insolvency commencement date, and therefore the hot pursuit of the holy grail, that is the assets of the corporate debtor, begins. It is also interesting here to note what the UNCITRAL Legislative Guide on Insolvency Law has to say in this regard. The UNCITRAL Legislative Guide on Insolvency Law states that the parties from whom the estate of the corporate debtor needs the greatest protection are the debtor and its creditors. This statement emphatically underlines the gravity of the issue at hand. It is now pertinent to draw your attention to a few data points which should set the context for the issue. So on the strength of the data sourced from IBBI, it is observed that the average time taken by the adjudicating authority to admit a corporate debtor into insolvency is more than 270 days. That is more than 9 months as against the stipulated time frame of 14 days. This itself shows the gravity of the issue at hand. Now, this time duration, which is the interregnum between the filing of the application and the admission of the admission of the CD into CIRP, this time frame, when it becomes longer, let's say 6 months or 9 months, it gives rise to a lot of opportunistic behavior on the part of both the promoters as well as the creditors alike. This could be seen in the case of Mohanlal Pillai versus Virgo Marine Shipyard, wherein the prime asset of the corporate debtor, which was a hopper barge in this case, which was worth around 150 crores, was sold by the creditor, and the adjudicating authority was eventually moved by the promoters for the reversal of the sale, as this was the only asset the corporate debtor had. This throws open a question that when the prime asset of the corporate debtor is in a way misappropriated right before the CD goes into insolvency, what remains of the CD to be resolved? This matter, Mohanlal Pillai versus Virgo Marine Shipyard, eventually went up to the Honorable NCLAT, wherein an interim order was passed. It is interesting to note what the NCLAT had to say in this regard. The NCLAT, by way of the interim order, mentioned as follows. The respondent is directed to maintain status quo in regard to the VM hopper barge until further orders. Respondents shall not move the vessel beyond the territorial jurisdiction of this tribunal. This essentially underlines the need for interim moratorium and the significance of preservation of assets of the corporate debtor. Similarly, I would like to place on record another case law which was by NCLT Bench Court 4. The case's name is DHFL versus Nayati Healthcare. In this case, the Honorable Bench made scathing remarks on the conduct of the creditor, as one of the financial creditors moved under SARFACI without even allowing the 60 days statutory period to pass in order to quickly catch hold of the assets of the corporate debtor right before the CIRP commencement. The bench in this regard made the following remarks. Thus, the above said hurried up acts and omissions on the part of the bank and the corporate debtor indicates that there might be some collusion between them in order to help the corporate debtor redeem the property. Thus, the purpose and the object of this tribunal while passing the previous order was only to protect the property in question and to secure rights of all the creditors and also of the corporate debtor. This underlines the fact that how the creditors engage in opportunistic behavior by appropriating prime assets of the CD before the application is admitted, and this in turn throws up situations where either the corporate debtor might enter into insolvency without any prime assets or would inevitably run the risk of going into liquidation, as all the assets that the CD has been appropriated before the insolvency commencement itself. In this regard, what is also very interesting to note is that the Insolvency Law Committee, being mindful of this anomaly in its report dated 20th February 2020, recommended the introduction of interim moratorium, stating that the adjudicating authority should be empowered to grant an interim moratorium on a case-to-case basis. Discretion should be granted to the adjudicating authority to determine the need and scope of interim moratorium. However, by way of this paper, the authors beg to slightly differ from the recommendations made by the Insolvency Law Committee. This is done because of the following reasons. We believe that if the adjudicating authority is given right to sort of adjudicate on a case-to-case basis, this would essentially add to the already long-drawn process of admissions. This will essentially add an extra layer of litigation which would take away the prime issue at hand, that is the issue of admitting the case within a stipulated time frame, and this would give rise to sort of peripheral litigation which would eventually not help the case but only delay the processes further. Therefore, we propose an automatic interim moratorium which needs to be introduced by way of a code amendment. Therefore, the paper proposes the introduction of section 13A by way of a code amendment which would read as follows. Save as provided in section 14, where an application is filed under section 7, 9 or 10. An interim moratorium shall commence on and from the date of filing of the application and shall cease to have effect on the date of either admission or rejection of such application. And during the interim moratorium period, the creditors of the corporate debtor shall not initiate any legal proceedings or legal actions in respect of any debt. This would therefore ensure that any SARFACI actions or adverse actions taken by the promoters are curtailed, and the admissions are, the time taken in admissions are also sort of streamlined. Thus, the introduction of interim moratorium would add as an added shield for protection and preservation of the assets of the CD, and would ensure the collectivity of the process is not undermined by individual opportunistic behaviors. With this, I would conclude the first problem statement of our presentation. We now move to the second problem statement, which is the need for standardization of concessions and waivers. Concessions and waivers, as we all know, form an essential part of any resolution plan. And the resolution applicants try to get the most of it by putting together all sorts of exemptions and concessions sought from the adjudicating authority. Some of these are also in the nature of conditions precedent, which make the whole plan contingent. It is often observed that the adjudication of such waivers occupy a lot of judicial time, and frankly speaking, most of these concessions and waivers are outside the remit and the scope of the adjudication of the adjudicating authority. This proposition is further underlined and strengthened from the Honorable Supreme Court's judgment in Gujarat Urja Vikas Nigam Limited, Amit Gupta versus Gujarat Urja Vikas Nigam Limited, wherein the Honorable Supreme Court made the following remarks with regard to the jurisdiction that the adjudicating authority has while they are dealing with such issues, and the jurisdiction that the adjudicating authority has with regard to section subclause 5 of the Insolvency and Bankruptcy Code, which is like the fountainhead of litigation when it comes to litigations pertaining to IBC. The Honorable Supreme Court has said that if section 60 subclause 5 is given a broad interpretation to include contractual disputes, it would disrupt the streamlined and time-bound processes under the code. Further, the Honorable Supreme Court goes on to observe, and I quote, for the adjudication of disputes that arises dehorse the insolvency of the corporate debtor, the RP or the SRA must approach the relevant competent authorities and not the adjudicating authorities. Therefore, it is best that the SRA approaches the concerned authorities and not eat up into the time of the adjudicating authority by way of IAs, by way of multiple IAs, which should be specifically kept only for approval of the resolution plan. So based on the above, we conducted a short survey of around 105 stakeholders, wherein we tried to identify the most common reliefs and concessions sought in the by way of a resolution plan. And what is interesting to note here is that the most commonly sought reliefs and concessions are the ones which are most commonly not granted by the honorable adjudicating authority. These include seeking blanket approvals and deemed approvals by way of approval of a resolution plan. The resolution plan also acts as a mechanism to surpass the jurisdiction of other authorities, and it acts as like a blanket approval which could be given to the resolution applicant without approaching the relevant authorities, which definitely the observations of the NCLAT, of the NCLT and Honorable NCLAT in this regard are very scathing. They generally say that that we do not have adequate jurisdiction, and therefore you need to approach the relevant authorities. Now, what the paper therefore aims to do is to put in place a standardized negative list of concessions and waivers. This negative list, because a positive list would have been very difficult for us to collate, so we came out with rather a negative list which could act as a guiding light for the prospective resolution applicants to draft better resolution plans and also save the time of the honorable adjudicating authority. Now, my co-author, Ms. Rishika Raj, would speak more on this issue.
So as mentioned by Ishan, the rationale for us is that it preserves the judicial time. So we are proposing a formulation of indicative list of waivers and concessions. So the rationale behind is that it will standardize the process and it will act as a benchmark, and should be on this lines or similar lines of information memorandum which IBBI has come up. So reason we have proposed this indicative list of concessions and waivers is that we have seen many times what the successful resolution applicants try is they try their luck and populate the resolution plan with ample number of exemptions and demand, which are generally the adjudicating authority does not have the appropriate jurisdiction to grant, and is not the relevant platform to hear such demands and exemptions. So therefore, we have come up with such a indicative list of concessions and waivers. Now, if we come to the slide, there are options such as waiver of stamp duty, taxes, fees, transfers, etc., and which are usually not granted by the adjudicating authority. For example, if a real estate sector is there and you have to seek a renewal of RERA license, then you have to go to appropriate authority. So similarly, this is actually a frivolous litigation and will act as the reason why we propose is that it will save precious judicial time. And for this purpose, we actually reached out to several stakeholders in the insolvency ecosystem, and we saw that about 67% of the stakeholders are of the view that this kind of standardization will definitely help the process. And lastly, to conclude, that this will help us to avoid frivolous litigation and save judicial time, and hopefully better quality of resolution plans would be put forward. So now coming to the other issue, the third problem statement that we have identified is in our research paper is that what happens when a resolution plan becomes commercially unviable and unfit for the implementation, and yet there is an absolute imposition of that resolution plan. So this question arose in the due to the landmark judgment of Ibc Singapore Private Limited versus the Committee of Creditors of EDCOM. Now, if I come up to the CRP model timeline, the CRP regulations, which clearly mention that ideally within 15 days, the adjudicating authority is supposed to hear and approve the resolution plan. However, if we look at the data that we sought from IBBI, we can clearly see in more than 30% of the cases, in vast majority of the cases, it takes more than 30 days. So ideally, the 15 days is not followed. And similarly, we also conducted a survey data in which we saw that majority of the stakeholders were also of the view that it takes at least more than 90 days to approval of the resolution plan. And if we analyze the figure 1 from the data which we received from IBI, if we analyze it, we also came to our notice that it takes an average of 200 days and 200 days an average of 7 months for approval of a resolution plan. So coming to the next slide, if we speak about elbow room for RA resolution applicant for experimentation and economic legislation. So in this, basically, we try to conduct a survey to understand whether the dynamics of a resolution plan change in due course of time. So in this, again, we saw that the majority of the stakeholders were of the view that it does severely affect the time value money, and also severely affects the viability and the feasibility of the resolution plan. Therefore, the 3 reasons why we believe that there should be an elbow room for resolution applicants for experimentation in an economic legislation. The first being judicial hands-off for an economic legislation. So the landmark judgment of Swiss Revens paved the way for an economic experimentation and set out a clear example why there has to be a scope for economic experimentation in economic legislation and commercial laws, and rather they should not be confined to a straitjacket formula. The objective of any economic law or a commercial law is basically to accelerate the economy. And also in the case of Uttam Galva Steel versus Deutsche Bank, it was again reiterated by the adjudicating authority that the current code is in the creditor in control model, and if we give more scope of experimentation, it will definitely help the creditors also to come up with better outcomes in future. And similarly, in today's inauguration session as well, how our IBBI chairman suggested that we need to come up it's better, the time is the essence of the code and we need to follow the same. The second aspect of our argument is the lack of party autonomy. So just as we know that the preamble clearly emphasizes that there should be balance of stakeholders, so and the current framework does not is not in uniformity with the same. So now coming to the case of Kundan Care Appeal, in which is the only exception in this particular case where the adjudicating authority allowed to modify the resolution plan only when the COC allowed the same. So this is the only exception, and this clearly proves the point and the argument and submission here that the COC, if the COC keeps the larger goal in the mind, which is to resolve the corporate debtor, then it will then such unique options then definitely be explored. At the same time, if you look at the orders like Ibc, it definitely takes a back step in helping us achieve the objective of the code and also the jurisprudence of the code. Even though in that particular case law, the premise of the argument of the resolution applicant was there are very many material changes which has come up with time to be made in the resolution plan, and also the financial projections and assumptions based on which the resolution plan was made. Therefore, it has, in due course of time, it cannot be implemented and it has become completely unworkable. Yet, the sole focus only remains on implementation of the plan, which has completely now become unworkable and unviable. So if I just quote Unicitral, it's completely silent on that, and the only aspect, it says about its public policy. It speaks about public policy, and our Indian economy, we have seen there's a shift towards marketism. Therefore, there should be enough elbow room for evolution of the jurisprudence and economic experimentation. And just to lastly quote that even the Asian markets such as Singapore have come up with has the option. I'll just conclude in 2 minutes. This has come up with has the option to review the resolution plan, and even though the insolvency can be completed within the stipulated time, which is an average of 8 months. Lastly, I'll keep it brief, the scope of distressed market. As again today mentioned in the morning session, that every aspect on all the stakeholders are interconnected. So similarly, if we see there is already a dearth of capital in the corporate debtor. Therefore, what happens is even the investors are looking, to lucrative options to invest their capital and amount. So if we keep on disincentivizing these resolution applications, there will be definitely lesser, and due to which it will lead to lesser options of better resolution plans. Lastly, what we're trying to achieve with this is the recommendation. So just the two aspects of it. If the adjudicating authority takes more than 6 months of time to approve a resolution plan, then the successful resolution applicant should have an option to modify the plan if the COC allows the same. And the another aspect which we have tried to add through proviso in the subclause 1 of section 31 is that if it takes more than 1 year to approve the resolution plan, then for the adjudicating authority, then the successful SRA should have the right to withdraw the resolution plan if it passes the litmus test of absolute unviability, which is that only if this committee of creditors allow the same. Lastly, I would like to conclude this presentation by saying code is on the voyage of a discovery, and therefore there is a constant need to scope for experimentation so that we achieve the maximum, achieve its maximum potential, and we reach closer to the preamble which have been enshrined in various case laws. Therefore, lastly, I'll just quote as Rohington Fali Mariam quoted in Swiss Ribbons, to stay in experimentation and things economic is a grave irresponsibility, and right to experiment is a fraud with serious consequences to the nation. Thank you.
Dais is open to questions. Yeah.
Here, like approval of resolution plan and delays. So of course, any resolution plan is basically a revival proposal or rescue proposal, which is based on certain assumptions at the time it is prepared. And of course, the IM given by the RP. So these assumptions, as in case of any proposal, loan proposal, it is also kind of a loan proposal, some brownfield project proposal. So these assumptions are valid only up to certain time, maybe 3 months, maximum say 6 months. So if you delay for more than 6 months, 1 year, so these assumptions go awry, the valuation are disturbed, and ultimately why the resolution plan fails. But have you also gone into the aspect of section 30 bracket 2, where the provision is for the approval of resolution plan by the adjudicating authority? So what exactly the adjudicating authority has to look into the plan? Supreme Court has made very clear that the adjudicating authority doesn't have to peep into the commercial aspect of the plan. So now only thing remains for the adjudicating authority to look at is section 30 bracket 2, which are 3-4 things which are, you can tick box kind of a thing. You can look at the treatment of OCs, the treatment of dissenting financial creditors, and few other things like implementation committee and all that. So I think that should also be covered. Why there is a delay? The reason of delay has not really come up here. Why NCLTs are sitting on the plan for 6 months. I have seen some of my plans are sitting for 2 years, where the NCLT has to see just 4 things under section 30 bracket 2. These can be looked at by registrar, not even the judge is not required. Registrar can sign and send it before the adjudicating authority. Yes, sir, this is okay, you can approve. So that I think is not examined here. One part, yeah.
Yeah, so essentially what 30 subclause 2 does is it provides a checklist to the adjudicating authority to put a tick mark and at whatever requirements are there, and if those requirements are fulfilled, the resolution plan needs to be approved. However, we have not gone into the broader question of why exactly these resolution plans are not getting approved on time, because as we go by the stipulated model time frame, it is not anywhere stipulated, but it says that on the 165th day the CIRP is approved by the COC, and on the 180th day the plan approval has to be made by the adjudicating authority, which is to say that around 15 to 30 days time se zyada nahi lagna chahiye plan approval mein. But however, we are still seeing कि जैसे admissions में है, similarly it is for resolution plan approvals. Multiple RAs, I have multiple IAs come before the plan approval. Some of the IAs come at the last moment and then they say my claim was not accepted on time. Therefore, when the adjudicating authority gets into the merits of these IAs, it is natural that only after the adjudication of these IAs are done, then only the RA, then only the resolution plan will pass. Because once the plan is approved, it becomes binding on all stakeholders, and therefore no other remedy remains. Which is why the equity, NCLT doesn't have an equity jurisdiction, but the principles of natural justice and all the things which we spoke about in the morning definitely comes into play, which definitely adds to a lot.
I think then your suggestion to IBBI based on your research should be that till what stage any dispute against claims can come.
Right, sir, right.
It cannot be like 180th day or 330th day.
So like a limited window of 30 days.
So maybe 30 days or 60 days or 90 days. Similarly, for plan also, any objection of the plan is approved by COC should come within 30 days of the approval of the plan by COC. Because I think Supreme Court in SR Steel has also made it clear that any unsuccessful resolution applicant has no stake in the process. He cannot object to the plan unless the plan is approved. Again, some of the adjudicating authorities are entertaining such. I think those things you may cover.
May I ask one thing, if you permit? Here, you said that interim moratorium should be made mandatory.
Right.
But there is other side of the coin, because section 10 filed by the corporate debtor to get the only for the stall the proceedings under the surface, and there are many cases where section 10 has been opposed by the financial creditors because they are at the advanced stage under the surface to sell the assets, and just to get the benefit of moratorium, section 10 applications are filed by the CD. And there has been many cases, if you may go through, where in section 65, where for malicious and fraudulent initiation cost has been imposed. Therefore, interim moratorium cannot be made mandatory. It has to be on case-to-case basis. Second, you said the time taken by the NCLT, because there is a principle of natural justice has to be followed. If you don't give ample opportunity to any litigant, they will go to the appellate forum and say that we have not been heard. And many cases matter have been remanded back. So that is the reason the time always directory cannot be mandatory. Second, for the approval of plan, there is another issue there is an amendment under Section 79 of the Income Tax Act that if you want a relief of carry forward losses, then income tax has to be mandatory heard. So when you notice to the income tax, because the law says you have to notice to the principal commissioner, but the bench says that you notice to the assessing officer, and then they will come and file an objection. So there they take an adjournment. So without hearing them, they will not approve the plan. So this is a practical difficulty. So you can't blame a judicial process that it takes time, because everyone has to be heard. Because before approval of plan, there are many clauses which the bench has to be examined.
Can I intervene?
Yeah.
We can take this out for a conversation.
Please.
No,
I'm just suggesting the practical, because as a lawyer,
no, thank you for that.
These are the things. Thank you.
Thank you. Good suggestion. Only thing, just a suggestion, what will happen if plan is withdrawn? Plan is withdrawn, but what will happen to CIRP?
So once the plan is, so if the plan is withdrawn, either it goes into compulsory liquidation. That is the only option. So, but what I would just quote one more case law wherein it was.
You can put in your paper.
हाँ.
Just suggestion.
So उसमें ये कहा था कि endless resolution से बेहतर है कि liquidation should be all.
You have to go another session.
Thank you so much.
That was the last paper for this session. We are breaking for tea right now. So, yeah, thank you.
Just before breaking, there is an important announcement. We are organizing the dinner at 8 p.m. at the lawn just opposite to the auditorium. So please have dinner with us and enjoy your day. And before concluding, I also want to thank to our panel members, Professor M.P. Ram Mohan and Sri Santosh Shukla. Thank you, and thank you for the presenters also by taking the pen, making the paper, and finally coming here and presenting and accepting the observations from the audience as well as the members. So as the research team from IBBI, I would like to request kindly incorporate all the suggestions and submit your final paper and give your consent so that we can publish it well within time before we have a deadline to publish a paper, actually journal of these papers. So kindly give your consent. Thank you all. Please have tea.
The evening session. For this session, we have our panelist, Mr. Debajyoti Roy. He's the Managing Director of NESL. And Shri Sandeep Garg. He's the Executive Director of IBBI. Just to inform you of the structure of what will happen, we have 20-minute paper presentations followed by 5 minutes for taking questions. Our first paper presentation for the day is Does Insolvency and Bankruptcy Code Improve Credit Channels for Firms in the Indian Manufacturing Sector? It would be presented by Dr. Rajdeep Singh, Mr. Kanwaljit Singh, and Mr. Yadvinder Singh.
Good evening, everyone. So the topic of our research is, does Insolvency and Bankruptcy Code improve credit channels for Indian manufacturing sector? Although a lot of research has been done on this viewpoint that whether the credit channels or access to credit has increased for firms after the introduction of IBC or not. But we did not come across any paper which was very sector specific. In this research, we have tried to evaluate this, to examine this problem in the manufacturing sector of India. We have covered both listed and unlisted firms. So basically, as we all know that an effective credit ecosystem is very vital for a country's economic growth because it will help in the development of debt market as well, and it will increase investors' confidence. As we in the morning, sir was mentioning that because of IBC, there was improvement in ease of doing business index that was given by World Bank. Although now it has been discontinued, the sir was saying that they'll be trying to bring that new index that will be developed by IBBI and IMA. So we look forward to that. But now, since it has been discontinued, we need to understand whether in reality the access to credit for Indian manufacturing firms has improved or not, and if it has been improved, whether there was a transmission effect towards performance of these firms or not. So a sound bankruptcy process, it aims at balancing the rights of debtors and creditors. Now, earlier also we had various laws which were, protecting the creditors, but IBC has shifted the focus towards creditor in control model. Post the application of IBC, the recovery rates have reached 42.5%, which was earlier only 14.5%. Even now, there's also a need to improve this recovery rate further. And there's a huge decline in the time period which is taken for insolvency. Earlier, it was around average 4.3 years. In many countries, it's still 7 to 8 years. And now the focus is to finish this off in 180 days. But still, we are taking 340 days. The average days we are taking is 340 days. And a lot of delays due to litigation are the reasons for this delay. Then insolvency reforms strengthen creditors' rights and result in greater issuance of long-term debt. Many studies have even said that it also has a positive impact on short-term debt. Earlier in the previous session, there was a research that was examining whether it also has an impact on trade credit, which is one of the forms of financing for the firms. But our focus, the focus of this research, is on access to total credit. So the objective of the studies, our first objective is to examine the causal impact of IBC on demand and access to credit by distressed and non-distressed firms in the Indian manufacturing sector. Now, what are the distressed firms? As per our model, distressed firms are the ones in which average net worth for the company for the previous 4 years was less than 50%. The losses were more. Then to study the impact of IBC on the performance of the firms in the manufacturing sector, basically in this objective, we'll try to see if credit channels have improved for the firms in the Indian manufacturing sector, then whether it is translating to enhanced performance or not. Because objective of IBBI and IBC, it is not just to go for recoveries and insolvency. The first and foremost objective of IBBI is to identify such distressed firms and try to revive them and save values for that firm, save the value of that firm. Now, what is the relevance of this study? It is important for policymakers to evaluate the effectiveness of the reforms brought over by the IBC law. And based on this examination of effectiveness, further amendments can be introduced and we can improve this law further. Then in light of the COVID-19 pandemic, when many of the firms have moved from non-distressed to distressed side, we want to, there's a need to see how these firms have survived. Then since firms closer to the point of distress are most likely to be influenced by the bankruptcy procedures, this research examines IBC's impact on financially distressed firms vis-a-vis non-distressed firms. Now, why we have chosen manufacturing sector? This is very important. More than 40%, about 40% of the admissions that were made in this IBC law, these firms are from manufacturing sector. This has been taken from the quarterly newsletter of IBBI itself, December 2021. And if you see the right-hand side pie chart, it shows that the number of resolutions that has been given, out of the total resolutions, 50% of the resolutions were of the firms which were from manufacturing sector. So half of the resolution processes are for manufacturing sector firms. So it itself speaks the need to conduct a detailed analysis, a detailed sectoral analysis of its impact on credit channels. Now, the research methodology which we have used, this data for this study is a panel data set. It is an unbalanced panel data set of manufacturing firms in India from the year 2011 to 21. It covers both listed and unlisted firms. This data has been taken from Capital Line database. For our initial analysis, there were 16,984 manufacturing firms. But we have only taken firms which were there in existence in our study period, that is 2011 to 21. That means if any firm which has been incorporated post 2011, that was excluded from the sample. Plus, if for any firms which has been wound up during this period, that was excluded. And the firms which had missing values, which had more than 20-30% of missing values, those firms have been excluded for better analysis. Then this description of variables. So this is a brief summary of the operationalization of our variables. So for credit channels, we have taken, two proxies for this. The first one is the total credit to total assets, which measures the assets to credit or the leverage level. Then we have cost of debt, which is total interest expense by total debt. For performance measures, like we are also measuring the transmission effect of IBC, of enhanced credit assets on the performance itself. So the measure for performance is return on assets. We can even improvise our study by taking different proxies for all these variables. So IBC is a dummy variable. Distressed firms, it is also a dummy variable. So it takes value 1 if a firm in a year has accumulated losses equal to or exceeding 50% of its average net worth in the immediately preceding 4 financial years and 0 otherwise. Then we have some control variables which are firm specific variables. We have size, liquidity, age, collateral. The literature review says that all these variables, they have an important influence on the access to credit for the firms. Now, empirical model. The methodology that we have used is differences in differences approach, also called DID methodology. Now, the first equation, it is for impact of IBC on credit channels of firms. So, for the first equation, my dependent variable is total debt to total assets. And here my main coefficient of interest is alpha 1, which is the coefficient for the interaction term. Similarly, for second equation, the dependent variable is changing and the right hand side of the equation is the same. Then, in order to analyze or examine if IBC has an impact on performance of firms, like the firms who have enhanced their credit assets, is it also translating to enhanced performance for them or not? So return on assets is the dependent variable in this case, and our coefficient of interest is alpha 1, the coefficient of triple interaction term. So this is the brief file for our data analysis. So this first table, table 2, it shows the impact of IBC on credit channels, and as I told you, our main variable of interest was the first one. The main coefficient of interest is distress underscore IBC. And for our first equation also it was significant, and for second equation also it has come out to be significant. The second equation has an inverse relationship. That means with IBC, the cost of debt has come down for these distressed firms vis-a-vis non-distressed firms. That means the distressed firms have more access to finance now and are taking more loans. The prospective reason for this can be that now the creditors are feeling more safe to lend to them. But we also have to see whether this is translating to enhanced performance as well, because the loans which they are taking, the funds which they are taking, they ultimately have to repay that also. And this model was taken, like we have taken firm fixed effects and time fixed effect here. Then impact of IBC on performance through credit channels. Here, our main coefficient of interest is the first one, which is the triple interaction term. That means how distressed firms have enhanced performance in comparison to non-distressed firms post the introduction of IBC and with increased credit assets. So this also comes out to be significant at 5% level. For our control variables, I'm sorry, I forgot to tell that we have taken the first lag of these variables in order to address the simultaneity problem. Then table 3, in table 3, that was for equation 3, where we had return on assets as the dependent variable, but with our credit channel was total debt to total asset. This table 4, in this table 4, we have credit channel as the cost of borrowing. Then in order to validate our results, in order to test the robustness of the results, we have undertaken placebo test. That is, we assumed that instead of 2016, the IBC has been introduced in 2013. So for the same data set, for the same number of firms, earlier the period was 2011 to 20 and IBC was introduced in 2016. Now we are assuming that IBC has been introduced in 2013. Why we do so is to check whether our results are robust or not. And if the coefficient of these, in the double interaction term and the triple interaction term, it comes out to be insignificant, then it supports our results that IBC has had a positive influence on increased credit assets and has led to decreased cost of borrowing for the firms, for the non-distressed firms vis-a-vis, for distressed firms vis-a-vis non-distressed firms. So this table 5, 6, 7, this is for results for placebo test, and the coefficients in these three tables, they were insignificant, which supports that IBC has had a positive impact on increased credit channels, and these results are not due to any other changes in the economy. So the findings of the study highlight that IBC has improved investor confidence, and now the creditors feel more safe to even lend to distressed firms. And if distressed firms get this enhanced access to finance on time, they can be saved from going into bankruptcy, and they can be saved, their value can be saved, and the firms which are not able to do well, they need to be punished. So this IBC is a framework for constructive destruction. In order to free the resources which have been committed to these distressed firms, the firms which do not have any chance of revival, they have to be wiped out from the market so as to enhance efficiencies. Then IBC has brought in the necessary behavioral change required in the promoters as well, but there still needs to be there still needs to be more streamlining in the admission process. As the latest statement made by Minister of State for Corporate Affairs in the Parliament was that in NCLT, more than 13,000 firms, the cases for admission are pending in NCLT for more than 13,000 firms. Then there is an urgent need to create a remote litigation structure to expedite this process of constructive destruction. What do we mean by remote litigation is that we need to differentiate between, some policies should be introduced which differentiate between major litigations and minor litigations, so that the courts, the working of the courts can be streamlined and they can focus more on major litigations rather than minor litigations. Then central repository of information can also be introduced so as to address the issue of non-cooperation by the promoters. So there is a plan to bring out a central repository of information which will have all the information of which promoter has taken how much loan and from which source, and whether they have repaid the earlier loans on time or not. Then if we also introduce mediation and conciliation mechanisms under the code, then a lot of legal work can be, that time wasted in legal formalities can be reduced, and the firms will settle outside IBC only. Then corporate debt market may be developed to reduce reliance on bank loans. And with IBC, as the credit channels are improving, the creditors are more lending to these distressed firms. There's also a need to develop the debt market like it's in the developed world also. Then the debt exchanges may be explored, where financial creditors may be permitted to trade debt on their books on a transparent platform. So with this, it will allow them to offload risk at earlier stages when they have earlier signs of distress. So in this paper, we have employed DID methodology and found that post-IBC, the credit channels and performance of distressed firms improved more as compared to non-distressed firms. That is all from our side. Thank you.
You mentioned something about about automation of loan contracts. While I do agree with that, and our company NESL is providing that, but how do you conclude from the study about this requirement of automation of loan contracts?
This is not a direct conclusion from this study. Actually, we have our study shows that IBC Act is relevant, but now there needs to bring in more improvements in IBC. So this is one of the methods by which IBC can be improved.
Differences approach, right? Now there could be ex ante differences between the firms because you have a treatment and control group. So how do you know that? Because I don't think there is a matching propensity score matching that's been undertaken to understand pre-existing differences. Would that be something that you would?
I have taken firm fixed effects in my empirical model. So that takes care of
So,
that.
okay, so then you wouldn't sort of, but how would you still know the parallel?
That parallel trend assumption, if placebo test results are insignificant, it shows that parallel test assumption is,
Okay, so you've taken
valid.
the fixed effects.
Yeah, I have taken firm
instead.
fixed effects and time fixed effects.
Okay.
I have not taken industry into time fixed effects because I'm only taking for one sector, that is manufacturing sector.
Right.
Yeah.
What I found was that most of the implications are not following from the results or findings of your research. Can you point out any particular area in which findings of your research are clearly can be used?
So my findings are pointing that IBC has helped these distressed firms in assessing more finance. Now, this enhanced assess can be increased by these measures which I have mentioned in the implications, that we need to develop our debt markets as well. We need to have more robust systems, like automation of the loan contracts should be there. So these implications are not a direct implication from the research, but the research, it says that IBC is helping the distressed firms to improve their performance by getting more finance on time. Now, that time period within which they can get that finance, we need to shorten that time period so that their value can be saved on time. Yeah, for those countries it's less.
It's not IBC. He said before IBC. He said before.
I said before IBC it's 4.6 years.
But I have few questions here. One is that I doubt your data regarding the recovery, 42.5.
So that was from Economic Survey 2020.
2020, no. Today's
2020, yeah.
So if you see, so that's slightly outdated, because if
Now
you look at today's data, will be less than 30%. That is why. Yeah. Second,
Yeah, so that data is in today's newsletter, which has been
so
released
that
today. Yeah.
Your data should be more updated.
Okay.
Do we research?
Yes.
It should be based on 22 March, not.
Right.
Second thing, duration also is somewhere around 470 days, not 340 days. Duration of CRP average is 470 days as per IBBI data.
Okay.
Third, whatever you say that the stressed firms are getting more loans, it is not reflected in the by empirical data on the ground. If you look at the banking sector growth of credit, still last year was around 8 to 9%, previous year was 6%, and which mainly is growing in the retail, not in manufacturing. Okay, so empirical data doesn't show really what your survey is showing.
So which report are you talking from?
Every report you see, RBI report or even economic survey, the growth of credit in the country is not more than 9% in last year, 31st March 22, and previous year it was not more than 6 to 7%. And this includes retail credit, which is growing by 14 to 20%. Retail means individual credit or housing loan. Manufacturing credit is actually going down because of IBC, because of many recoveries, but not much credit.
Post IBC you are talking
SR
about?
still reduced the bank credit by 42,000 crore recovery. Bank have not been able to match that with further loans of that size. That is what I'm coming. So your credit is actually reducing. Then coming to your point of like.
So if you can mention me the exact report, like I can study that and I'll correct it if it's.
Later, Then your third observation is regarding the cost of credit for distress fund, distress asset. I think there also it will not be matched by the empirical data. Why?
So basically that empirical data which you might be talking about, that is on individual level. Here I'm taking comparison. We are comparing between distressed and non-distressed.
I am talking about distress only. I doing distress asset.
Okay.
So what I'm telling is that this cost may be going down because of haircuts, not exactly because of more credit. See, when a resolution plan comes, banks or COC takes a haircut. So the 100 rupee loan becomes 30 rupees or 40 rupees.
Right.
So next year when the unit is revived, the cost of credit is on 30 rupees. So 70 rupees is written off.
Okay.
So you have to look into that. This is not because of more credit or better terms. This is because of haircut, the cost is coming.
Okay.
That maybe you have to keep it. And then another reason, corporate credit growth is still not happening. And distressed credit since morning, people have been saying that interim finance is not available. You are saying credit is available to the stress fund. But minimum the stress asset fund can get is the interim finance.
So there's a difference when they are mentioning it, because they are mentioning it at an aggregate level. What I am
before admission into IBC, but before admission into IBC, but companies distressed. They are talking.
They are getting more credit. You want to
after admission into CRP and interim finance is not.
because post IBC now the creditors feel more safe to lend to even these firms.
Because coming from a banker, I deal in more than 1,000 cases of IBC.
No, right, sir.
So I can give you the real data, like my experience.
Okay.
Maybe you are right. That the credit available to distressed firms is still difficult, because even credit available to normal firms is difficult at this stage.
Okay.
Bankers are in a stage where they are not risk averse as of now. Okay. So this credit may be like reason may be the funding of resolution plan, which is also very rare. Like out of 480 resolutions happened under IBC, I don't think more than 10 or 15 resolution plans have been funded by banks. Maybe maximum 15. Like Ruchi Soya is one big example, where the plan of Patanjali was funded by the banks. So there also your empirical data doesn't match with my data.
Okay.
I don't see many funding of resolution plans also. So these are some of my.
I'll take a suggestion, sir, and
One observation.
Two things.
Actually, the data which is you have done is basically not just IBC related firms, because you've done the stress by way of net worth.
Yeah, sir.
So it is possible that these firms are able to reduce the debt based on some kind of settlements with the creditors because of the fear of IBC.
Yes,
so,
sir.
So that is a possibility.
That also might have happened here for some of the firms.
So that's a possibility.
Yeah, that
because we have these distressed firms are not just the IBC firms. These are a larger sample, and based on the selection by way of net worth.
And
so they could have reduced this debt by way of some kind of settlement, and also by way of cost, maybe could have gotten some additional collateral, again because of the fear of the IBC, fear of losing control. So that is a possibility.
Right.
But I think there you need to do some more research.
Okay,
sir. Two things I liked about your presentation here. One is of the remote litigation you suggested.
Yes, sir.
Because there are many compliances where a formal order is required from NCLT by the RP and liquidator. If such applications are segregated, where main litigation could be focused for adjudication. So that is a very good suggestion you suggested. Very important thing one you suggested is of alternate dispute resolution mechanism, which is not there in IBC. But under the Companies Act section 442, there is a mechanism of mediation is provided. And we have filed an application. But since this section of Companies Act is not included in IBC, the adjudicating authority is not applying that section. So your suggestion is very good of alternate dispute mechanism. If that section is included under IBC, then many before the admission, that mediation process of the Companies Act could be applicable under IBC. So there is a very good suggestion and a very important aspect to avoid the litigation process.
I'm
Thank
sure,
you.
sir, the people from IBBI will be noting this. Thank you.
Sorry to cut that short, but we are constrained with time. The second and the final presentation for today's session is, the topic is the effect of bankruptcy reform on default risk of firms, evidence from India. It would be presented by Dr. Aishwarya Krishna and Dr. Jayadevan.
You might have taken it. Slide change. Should I use the mouse only? I think Mr. Singh must have taken it. Yeah. Thanks. Okay, good evening, everyone. So my topic for the day is effect of bankruptcy reform on default risk of firms, evidence from India. In the last 10 years, about 90 countries have, done some sort of bankruptcy reform. And India is also one among them. So in 2016, as we have all been discussing from morning, IBC came into being. Now, the research question that we are asking in this paper is that what has been the impact of this legal reform on the economic distress of a firm? Okay, so that is the first question. And if it has increased, then what might be the reasons for that? If it has decreased, then what could be the reasons for that? So these are the two research questions that we are going to address in this paper. So let me just give you a background to how we came up to these questions. So in the year 2019, we got in the year 2020, we got MCA 21 data, and this was for all the firms starting from 2011 to 2020. So that's about 12 lakh firms. And then we sort of, decreased the number of firms to about 9 lakh based on the asset size. So we took all those firms with asset size greater than 1 crore. And then this study came as, a repercussion of that study. So where we did the bankruptcy prediction of all those firms, listed and unlisted, using machine learning models. Now, coming to the uniqueness of this study. So why is this study important? What is so unique about this study? So basically, effect of credit rights improvement has majorly been studied for listed firms. Okay, and in the case of India, Bose, Philomeni, and Malik 2021 does it. And then there is another paper by Joes 2020. Those people also study for listed firms. And then till now, only developed markets were studied. And of course, we do have a few papers who are studying emerging markets as well. And then the studies majorly concentrate on variables from financial statements, to measure default risk. Now, what we are going to do is we are going to compare between listed firms and unlisted firms. Because of the enormity of the data that we possess, this study becomes extremely important. We are looking at, small firms as well, right? And then it is India focused, and we are also adding some governance variables. Now, what could be the governance variables that we are adding? For example, percentage increase in median remuneration of the directors of a firm. That's a governance variable. Then we are adding how many board meetings is a person, is a director attending. So the attendance of the director for all the board meetings. So that's another governance variable that we are adding. And various other governance variables, especially important 3 auditor level variables also we have added, thanks to the MCA 21 database. All right, so the motivation, why are we doing this? Mainly look at the ratio of downgrades to upgrades. This is a very important economic distress metric, right? So we collected this data from CMIE Provis, wherein we have the ratings of all the rating agencies like CRISIL, CARE, etc., right? So we have taken all those downgrades to upgrades ratio, and we have plotted here, and you can see that this has sort of increased. And then one good thing is that post IBC, our score, the World Bank score for resolving insolvency has
kind of increased. The red line that you see over here is for India. The green line is China, and there the blue and the purple line is for US and Japan. Right, so this comes from the World Bank data. Now, coming to the literature, so listed, unlisted, mainly all these firms, all the studies that we have kind of seen look at listed firms. Now, for example, Brazil, when it introduced its credit reform, that was in 2005, they found that greater the credit rights, lower would be the cost of debt. And then the Italy case, right? The Italy case, 2016 paper by Rodano. So they have stated that there is increase in credit demand. The interest rate has also increased after the reorganization reform, but the liquidation reform does not give the same result, right? And then the UK result, increased costs for borrowing, for proceedings. Now, all these studies, basically indicate that there is an increase in credit. Now, that becomes sort of an income side argument, okay? Now, India-specific studies. Now, let us look at some studies like the Visaria 2009 paper that looks at DRTs. And they say that there has been a positive effect on the probability of repayment. So that would be the probability of repayment has increased. And then there is another Vaughan, Lilienfeld, Mukherjee, and Visaria 2012. So increase in interest rates they are finding. WIG 2013, right? So they look at the Sarfazi Act, reduction in secured debt they found, right? And all these papers have, different sort of, results that they find. Now, coming to the hypotheses development. So what are we doing basically? We have adopted for the first research question that we are asking, what happens to the distress risk of firms post-IBC? Has it increased? Has it decreased? Now, what is distress risk? That is another question that we have to address. So we measure distress risk by the logistic regression framework, and we have thrown in all sorts of variables into the equation, governance, be it geographical variables. So we have added even state level variables into this measure. So the distress IT, the left-hand side is basically taking 1, 0. So if it is a distressed firm, it takes 1. If it's a non-distressed firm, it takes 0. Now, how do we measure the 1 and the 0? That is basically the economic default, the rating default that all these firms are getting from the rating agencies. So if a rating agency gives a default rating, then it takes the value of 1. And more importantly, it's not only the rating agencies that we are looking at. So we have also integrated the TransUnion CIBIL database into our study. So the distress also takes 1 if you are a willful defaulter, okay? So we have basically rating default and willful default in the measure of distress risk. Then to look at why this has it happened because the debt structure has, increased or decreased? So we also look at the IBC, how it has affected the leverage, and then we look at how it has affected the cost of borrowing. So again, as the previous presentation also carried out a similar sort of study, wherein they also look at the DID framework. Even I have also looked at the DID framework to test hypothesis 2 and hypothesis 3. But the first one is our major result, whether default risk has come down. Okay, so let's just look at the data set once before we go to the results. So what all have we integrated here? So starting from 2011 to 2020, we have about 5 types of filings in MCA, okay? So one is XBRL, another is Ind AS, another is AOC 4, 2018 to 20. The data structure is totally different when compared to AOC 4 of 2015 to 17. and then the 23 ACA and 23 AC starting from 2011 to 14. So this entire exercise of aggregating all the forms, the data of all the forms into one single data set is a big exercise because the variable names are different. So we had to do a lot of data crunching there. And then, of course, we have also integrated the market-related data. So if you are a listed firm, then obviously you have stock prices, you have volume traded. So all these data variables are also coming into picture if there is a listed firm. And then the rating defaults and, of course, the willful defaults. So these are also being aggregated into the data set. All right, so let's just look at the basic summary statistics. We have about 10,422 firm years, listed firm years, okay? And this is, of course, after cleaning. In fact, for many firms, the balance sheet was not balanced. The balance sheet, it was not balancing, right? The A is equal to L plus E equation was not balancing for many firms. And then for a lot of firms, simple audit of fees was negatively reported. So we had to do a lot of data cleaning to get it to this level. And as you can see, for listed firms, we have the default rates. 2012, it's about 4.12%. As it goes on, the next highest that we are seeing is in 2016. And then, of course, it's coming down later. And then for the unlisted firms, we don't see very high default rates because the rating agencies and TransUnion CIBIL database are not following these unlisted firms. So these agencies are following just the listed firms, but that's why we are getting very few defaulted firms. But the good part is that we still have 7,637 defaults. That is exclusive default firms, okay? So the first time that you're defaulting, that is taken as your economic default. And then we have about 337 defaults in the listed category. So we have a good number. 7,600 is a good number to do this entire logistic regression. Okay, just to, so I have kind of merged all these databases, but why leave IBBI data? So let's do that as well, right? So let me just give you a sort of view about what happens if I get in IBBI data into the picture. Out of 443 CIRP filings that we have, only 205 have matched with our MCA data. This could probably because of the asset size filter that we have put in. And then the CIBIL plus IBBI. So we have merged TransUnion CIBIL database plus IBBI. So there as well, out of about 106 willful defaulters from 2016 to 20, we just get one firm that matches with IBBI data. Then ratings plus IBBI, we have 142 CIRP firms that are matching with the ratings data, out of which 110 have a default rating. So that's a good thing. So 110 default ratings out of 142 CIRP firms. And rest of the firms, believe it or not, there are about 4 or 5 firms which have a AAA rating and a CIRP filing. A4 rating, A3 rating, and a CIRP filing. So that was very shocking when I did this sort of merger. Then rating upgrades and downgrades. Out of 138 firms, that is the CIRP firms who had rating downgrades or upgrades, we observed that 108 firms had a reaffirmation and just 80 were downgraded. So this is the entire big picture when we get in IBBI data into the picture. So, okay, very quickly, the univariate tests. We did the pre-IBC and post-IBC univariate tests. And we see that long-term leverage has actually, come down post-IBC. So the previous study that we saw, the previous paper, it showed that the leverage has increased, right? So the short-term leverage has also seen a decrease. Cost of credit, well, that has also decreased. But cost of credit, it gets ruled out when we do the DID framework. Okay, the tangibility of the firms has also come down. And very importantly, the probability of default, right? The probability of default has seen a very good decrease post IBC. So that we are going to test it in a multivariate framework. Okay, so the multivariate framework shows very clearly that the default risk has come down post IBC. IBC takes the value of 1 if it's more than 2016. So the year is more than 2016. So we see that in all the 3 models where we include state variables and when we include governance variables, I have not shown those results here just due to the paucity of time. So the default risk has reduced post IBC by 0.22% for the listed firms. And for the basic model, we use Altman's 1968 variables. And of course, this is the DID framework. I'll not explain the equation there, but we find that default into IBC, which is our main DID variable, showing a negative coefficient, which means that post IBC, the debt structure, that is the leverage, has come down. And look at the probability of default. So this is something that we estimated using logistic regression. And this is the time series average of all the firms. And this has clearly come down even post IBC. And for unlisted firms, again, the long-term leverage is showing a negative effect post IBC for unlisted firms. So this is the data which has about 8 lakh firms. Okay, so very quickly, let me just, so this is the logistic regression. Again, here the probability of default or the default risk of these firms have come down post IBC. Now, here as well, DID framework for unlisted firms. Again, default variable is showing, the default into IBC. So that variable is again showing positive for the unlisted firms. And very interestingly, the cost of borrowings is not showing significant effect at all for listed and for unlisted firms. So there has been no effect on cost of borrowing for listed as well as unlisted firms. So that is the major conclusion that we are drawing. And of course, for the question whether we have done the matching, propensity score matching, well, we didn't do the propensity score matching, but we have matched it based on the asset size and the industry, following Altman again. And we found that the results are robust to that as well. So just to conclude, for the listed firms, using logistic regression framework, we find that the default risk has actually reduced post IBC. So we measured the default risk using logistic regression. Expansion of creditor rights has decreased corporate borrowings of firms that have a default rating or is a willful defaulter. And then defaulted firms have a 0.8% higher cost of borrowings when compared to the non-defaulted firms. No effect of IBC is observed. So in both the cases, listed and unlisted, IBC is not showing any significant effect on the cost of borrowings. Default risk, again, for unlisted firms, very similar results. Default risk has reduced post IBC. In the basic model just uses the financial statement information. Of course, when we put in the governance variables as well, governance variables, also auditor level variables. So all these variables, even if we put that, the default risk is on a decreasing trend. And of course, IBC has decreased the corporate borrowing of unlisted firms also. And default firms have had a higher cost of borrowings when compared to the non-default firms, but effect of IBC is not observed. So that's it. Thank you so much for your patient hearing.
Yeah, I have a couple of questions. You use some data of willful default.
Yes.
So what is the source for that?
TransUnion Sibyl database.
Willful default?
Yes. So we have taken all those willful defaulters above 1 crore. We didn't take the 25 lakh above because our data entirely we are taking only 1 crore above asset size.
Okay. Now
We
you've
scrape
also
it from the website.
you've also shown that this probability of default has come down.
Yes.
Could it also be that as you see generally banks and financial institutions have been more circumspect on corporate lending? So could it be because of that?
It could be. I don't know how to control for it.
Yeah. So it could be because of that.
It could be
if you
because
generally see, this aversion to lending is there.
Right. Hmm.
And most of the credit growth is on the retail side. So that could be one factor.
Yeah.
For
So in another presentation I attended, they were talking about a methodology to control for that as well.
yeah,
Something
so you can
called
think of
parallel
that
lending.
as a
I'll try
further
that out
research
as well.
project.
Yeah.
And finally, this cost of borrowing you are showing decline. But if you see, have you?
Borrowing,
Yeah.
Post
But
IBC, no effect.
yeah, but you showed some decline in trade, isn't it? Cost of borrowing.
No, probability of default has come down, but cost of borrowing post IBC, I don't find any effect for listed and for unlisted firms.
Okay, fine then. That's all from my side. Thank you.
Yeah. Hi, Asoria. Yeah, this side. Sorry, I'm thinking back. So thank you for this nice presentation. So I'm Sumit. I'm a PhD student here at IMA. I don't work in this area, so I have a clarificatory question to you. I mean, so basically you are saying that IBC impacts the, the default risk, right? But I didn't get the mechanism through which the IBC can impact the default risk, because default risk will be governed by economic factors, right? Like the competition in the industry, or if the economy as a whole is doing bad, or industry as a whole is doing bad. So I could not.
Actually, the same comment we got from the CEA when we presented these results to the former CEA rather, to Mr. Krishnamurthy Subramaniam. He said, why have you not controlled for macro factors? You should have controlled for interest rates at the macro level. You should have controlled for the GDP growth rate. So we did that. So we found that the results are the same. So we have controlled for macro factors. And in fact, when we added interest rates as one of the control variables, that's when the cost of debt disappeared. The result on the cost of debt, till then, I was getting it to be coming down post IBC. But as soon as I added interest rate as a control variable, the effect sort of disappeared.
Can I give an explanation for that?
Yes, sir, sure.
So basically what I see is that the law will not have any impact on the economic factors. See, inflation, the interest rates, IBC will not have any impact on that. What IBC as an economic law has impact in the behavior of the borrowers. So here comes your willful default. A less number of borrowers are defaulting willfully now. That may be the reason the default risk has come down. Not because of any economic factors. Because the people are fearing default because the assets will be taken away by the creditors. They lose control. That may be the reason why your default risk is coming down. Second aspect I would like to say is that have you also examined the cascading effect of defaults? Because once a company defaults, then their vendors, their suppliers, it defaults to others also. Then they further default to their vendors. There is a cascading effect on the economy, understand?
That's a very good point, sir.
Yeah.
Because what I have done, I have taken, so once a company defaults, I took all the related parties of that company.
Yeah.
And then I sort of did a testing whether the other company that is a related party also defaults. And I found that there is a very...
Actually, we see in the normal life, because as a banker, I see a lot of time. If like NHI defaults on a EPC company, then that EPC company may be defaulting on 15 other vendors, and they are all our borrowers. So 16 borrowers default because one company has defaulted. So that also should be brought into the study.
MCA didn't give us the related parties of all these firms, so we had to take it from Provis.
And as regard this unlisted firm, these include the partnerships and proprietorship firms.
Absolutely, everything. But asset size greater than 1 crore.
Okay. But regarding your suggestion that the cost of credit has not come down, I think there will be a lag. It will not come down immediately because there is a change of behavior now. So if you today you see less probability of default, then that premium for default will go down gradually. So maybe after 3-4 years you'll see that, not today. That is my view. Thank you. Good presentation.
So MCA database it should be only for corporates, right? It should not cover partnership firms unless the LLPs. Only LLPs, not unregistered partnership firms. Yeah. Yeah. So only LLPs, basically LLPs and companies.
So you linked all the variables among the different reports. Or, oh, that's a very commendable effort. Yeah.
Hello, Aishwarya. Yeah, there is one last question from me. Actually, there is a suggestion from my side. Perhaps you have already covered it, but it is not actually very explicit in your presentation, that you are comparing the listed firm and unlisted firms on various parameters, cost of borrowing and default risk. And this is your uniqueness to study. But you have actually not suggested that what motivated you to do this comparison. Just because you have access to this database, MCA, this large repository, is it that the motivation to do the this study? Or if there is some your personal motivation to do that, then it has to come into picture. So that's
sure. I mean,
so that will actually add to your study. That's what I suggest.
Yeah. So I mean, the answer to that question, first I studied the bankruptcy prediction for US firms. So that's where it all began. Then now it's, I'm concentrating on Indian firms. There. So we found a basic literature gap here. So till now, Sarfazi Act was studied, DRTs were studied. There was no explicit study for unlisted firms on IBC. That's one motivation that I would suggest I have.
Your motivation will help to understand what is the managerial implications to others.
Okay.
Because academic gap is there, doesn't mean that it will translate.
Thank you. Thank you.
Thank you all for listening to the presentations and giving your valuable comments. Tea would be served outside, following which there is a data-driven insolvency research workshop, which would be held at the same auditorium. Thank you.
I will request again both the presenters kindly submit the final paper as soon as possible. And a very good workshop is going to be held at 6 o'clock in this PP Gupta auditorium. It is on the data available with IBBI and how the researcher can access it and to the further accelerate the research works. So please don't miss that. And of course, once again, please join at 8 o'clock for dinner. And right now, please join us for tea. Thank you. Thank you.
Session of the day. So we hope that you found the sessions engaging and informative. The presentations which were done by the in the research sessions that we had just before the session. So now we have Professor Ramanathan Subramaniam, Editor-in-Chief, and Ms. Diana Joseph, Managing Editor, who will speak a few words on Vikalpa, the journal of IIM Ahmedabad.
Good afternoon. I'm Ramanathan and that's Diana. I won't take much time. We represent Vikalpa, the journal for decision makers. Thank you. I just wanted to introduce the journal to you, and please do consider it as an outlet for your research. I do see some who have already published with us. It is an open access journal, probably the oldest management journal in India. And as the name suggests, we look for decision. The bulk of the researches has a significant managerial implication and for decision makers, which also I saw in some of the sessions. So this looks like good material that you may want to send to Vikalpa. And we do encourage interdisciplinary work also, which again I saw in some of the presentations here.
Yes, just that we've published a special issue 1.4 on insolvency and bankruptcy.
Yeah.
And yes, we look forward to interacting with you all once the sessions are done and look forward to contributions.
Thank you.
Yeah. Thank you so much.
Thank you.
Thank you, sir. Thank you, ma'am. May I request the members for the next session, Mr. Prashant Das, Associate Professor of Real Estate Finance at IIM Ahmedabad, Ms. Rebecca Perry, Professor at Nottingham Law School, UK, Mr. Mahesh Vyas, MD and CEO, Center for Monitoring Indian Economy, and Ms. Kokila Jairam, Deputy General Manager, IBBI, to kindly join us on the dais. The IBBI launched its first research initiative in 2019 with an aim to promote research and discourse in areas relevant for insolvency and bankruptcy regime in general and that in India. So this session is an initiative under the research initiative of the IBBI. With this, may I now introduce a noted scholar and professor, Mr. Prashant Das, who is an associate professor of real estate finance at IIM Ahmedabad, and he has also served as an associate professor of real estate finance and acting director of real estate finance and economics institute at EHL Lausanne, Switzerland. Sir has also been a visiting faculty at various universities across the globe and has also been serving on the editorial boards of various journals. Sir, may I please request to kindly address the audience.
Good evening, ladies and gentlemen. It usually takes me 3 to 4 weeks to prepare a talk like this in front of such an august audience. And in full disclosure, I'll be very honest, this talk didn't give me much time. And I had to prepare a few things to speak about. Thanks to my colleague, Professor Ram Mohan, I did what any millennial would do, Google. I followed what my MBA students would do. And the motivation to go to Google was not as frivolous as it sounds. Back in 2009, when I was a PhD student in Atlanta, Google started publishing its trends data. It started publishing trends data retrospectively. Google Trends data is one of the most powerful public sources of data that we as economists have access to. What they do is track searches, significant searches with critical mass of people in a time series trend. So I went ahead, and the first idea that came to my mind was to see if we could predict insolvencies and bankruptcies using Google Trends. When I went with that idea to my advisor, he looked at me with a very frowning face, as was very usual of him. And I had an econometric setup ready. I had a methodology, I had my literature survey. And I also was lucky enough to get data on the history of bankruptcies in California. But my professor wouldn't like the idea, not at all. So I wrote to Dr. Hal Varian, the famous microeconomist. At that time, he used to be the chief economist of Google. And I told him that, look, my advisor is not buying the idea that Google could be a useful data for research. And he sends me a bunch of papers that at that time were rather fledgling. I mean, no one knew about those papers, and some of those researchers were also not very well known. The idea was that we could use Google Trends as an important economic indicator for research. Fast forward 2-3 years, some of those papers became seminal papers. Da, Engelberg, and Gao have published 2 papers in Journal of Finance using Google Trends. And thankfully, my own paper got published in a good real estate journal afterwards. Well, long story short, the point that I'm making here is that I'm going to show you some slides which on the face value may appear tacky and cheesy to you, but I assure you that Google Trends data has been accepted as a legitimate proxy for macroeconomic trends. And the question is, why do people like me, why do, at that time, a young researcher had to lean on Google Trends data? Because good quality of data was not available. You know, PhD students are thirsty for data. And if you don't have data, you have to find means to get access to the data. And that was the solution. So when you look at Google Trends data, you are essentially looking at demand for information. So I'm going to show you demand for information about SARFAESI and IBC in India. I guess SARFAESI was introduced somewhere in 2002. Google Trends only starts in 2004. You see, the trends on SARFAESI has been quite stable, plateaued, but at a decent level. In other words, people have been curious and eager to learn about SARFAESI. But then you see something else comes up in 2016. And this hall is the best, is full of the right people to guess why 2016 October is important. That's when IBC was introduced. And suddenly the interest in IBC has spiked up. What this graph tells you is not what people are searching about. If we believe in the papers published in top economics and finance journals and many other social sciences areas, what you're looking at is common public's curiosity and eagerness to learn about. I guess this one is the IBBI. Then the next question is, what are people more interested in, IBBI or IBC? And if you look at this graph here, it's very clear, with due respect to all the IBBI dignitaries that we have in the room, people are more interested in the code itself than IBBI. In other words, it's not the institution building that has gotten people excited, it's the new series of phenomena that IBC has triggered in the country. So some of us may still not buy the idea that Google Trends that we see here are actual fundamental economic information. What if some people are just Googling it because they have nothing else to do, right? A lot of millennials, they're spending their time on internet and they're just Googling it because they see it in news. Many a times, the demand for information is triggered by the supply of information. And we must admire IBBI for its phenomenal PR that they have done, that the awareness about IBC in India is pretty good. So you might argue that people are searching for IBC or IBBI simply because there is a lot of news about it. Now look at this graph. You see that after 2016, the curiosity about both IBC and IBBI peaked, it plateaued, and then it fell down. And then let's go back to the previous slide again. We see that that is not the case with the overall curiosity about IBC and IBBI. That simply means that the quality of curiosity, the quality of the nature of demand for information about IBC and IBBI is more serious than what you could make of it simply by looking at Google Trends. That is the demand side. What about the supply side? In economics, there's a demand side of the equation, there's a supply side. Okay, we know that there's a lot of demand about information, about knowledge, about insights related to insolvency and bankruptcy. And by the way, all the trends that I've shown you are related to searches done within the Indian territory. This is Google Ngram. Ngram simply captures how often, in percent terms, a particular word has been used in books published all over the world. And Google indexes around nearly 1 million books of the world. So all important books have been indexed by Google Books. And if you see, bankruptcy is nothing new. The interest in bankruptcy was as strong in 1800s as it is today in relative terms. And then when you look at the recent decades here, since 2000, since the onset of the 21st century, you see that the supply of insights and knowledge about bankruptcy has drastically fallen. Does it mean that people are not studying bankruptcy enough? Does it mean that there is not enough research going on about bankruptcies? Not really, because this morning I collected some information on how much research is being produced in India related to insolvency and bankruptcy. And you will be surprised to see that the quantum of research produced by Indian researchers in 2021 related to insolvency and bankruptcy is almost as good as what was produced in a whole decade that preceded the 21st century. There is tremendous amount of interest among researchers about creating new insights about insolvency and bankruptcy. But we have a problem. The problem is when you start browsing through a lot of this research, a lot of it is opinion-based pieces. A lot of it is not using inferential statistics. And a lot of it is something that an economist or a finance researcher would look at with some degree of suspicion, because there is an issue of external validity, as we call it in academies. So what we need here is good quality data. And as you are all aware that as academics, we are greedy for data. You know, we smell it, and like honeybees, we swarm if there is one source of data available. IMF has in 2019 come up with a paper that categorically promotes the availability of insolvency and bankruptcy related data. And this is an NBER paper, I guess this is 2001. And being a student of real estate, my interest from IBC or insolvency or bankruptcy related work lies in the discount, the valuation discount that insolvent assets are attributed to. And if you see here, and it has also been reiterated in some of the earlier sessions that we have had, that one of the biggest problems with insolvency and the resolution process is the uncertainty in the valuation. So when a company goes bust, or when an when a borrower has defaulted, yes, there will be a price discovery process, but that price discovery process perhaps happens in an inefficient and an oligopolic market, where we do not have a benchmark to say whether the price at which the asset traded after bankruptcy was the right price. So that has already been pointed out as one of the biggest problems related to insolvency and bankruptcy related research. At the same time, when you look at countries like the US, this is a paper from 1999, published in Journal of Financial Economics. They had access to the data where they were able to pinpoint specific categories of assets, and studies like this allowed them to come up with an estimate of the discount given the nature of the insolvency in their country. And this is where we would like to be. So with full admiration to what IBBI has done and what IBC has been doing in this country, this is time that we had the right amount of data so that we could not only replicate what the West is doing, but perhaps do an even better job. And for God's sake, we are a 1.4 billion population country, and the amount of bankruptcies that we are going to see is perhaps going to be good enough. For researcher, it's not a bad news. And hence, ladies and gentlemen, I welcome you to this session where IBBI is just going to reveal some good news. So this session brings you good news that there will be data available. Thank you very much.
Thank you, sir, for your presentation on this unique and interesting research initiative. Ladies and gentlemen, may I now introduce another learned speaker, Ms. Rebecca Perry, who is a professor at Nottingham Law School, UK. She has authored a thesis on avoidable transactions in insolvency law, and her main research interests lie in the areas of insolvency law, in particular international and comparative insolvency law, with a focus on UK, USA, EU, India, and China. Ma'am, may I please request you to kindly address the audience?
Thank you, and I'm very grateful for having the opportunity to speak today about this project on insolvencies and digital economies. Now, it's an example of a sector-specific approach to insolvencies, and you might wonder why this, when you've had papers already on financial institutions, and then there might be other sectors that demand a sector-specific focus. But what I'll do in this paper is to outline why a focus on digital economies is likely to be important in coming years, given the importance of digital economies in modern society. So to give you an overview of what I'll be looking at in the paper, briefly I will highlight why digital economies are important, and including for India. I will highlight some of the challenges of digital economies, and in particular looking at what problems there will be in the event of an insolvency in this sector. So I'll look at the risks arising from insolvencies and how they can be handled. So looking first of all at the digital economy in India, it obviously is very important, and statistics back this up. So in a study by including McKinsey in 2015, it was thought that the IT sector in India could be worth $300 to $350 billion. And the IT industry contributes significantly to the Indian economy, around 8% in 2017 to 2018. And of course, COVID-19 accelerated a lot of dependence on digital economies. It enabled us to work from home in a way that we would only previously have done in the office. Cloud computing, for example, can enable you to have the same desktop at home as you have in the office. And of course, we are familiar with how technologies can facilitate collaborations, planning of projects, rapid accessibility of services, and so many other aspects. I've given this paper a couple of times to Indian audiences, and this is the first time when I've actually been in the country. The rest of the time I've just been stood in my house communicating via Teams or Zoom or some other. And so ways of working have really changed, and it may be that laws need to change in response to that. As an example of India's strength in IT, of course, there is outsourcing, and India being among the top 5 destinations for London tech companies. Part of the reason for that is that comparatively, India has got a good legal framework to support these contracts that other countries don't necessarily have. And I've already gone through some of the benefits. Easy accessibility, so consumers will use technology all the time, paying bills online, contracts that are signed electronically are much more hygienic than pen and paper in the COVID age. And it enables greater social inclusion through digital ID cards, where India's got a world-leading example, generates employment, and lots of other benefits. The potential of digital economies has been noticed, I think, by virtually every country, so that there will be digital economy strategies in many countries, so not just India, but also China, Pakistan, Bangladesh, and Nepal as a program as well. So it's an area that is attracting attention, but what doesn't tend to be attention grabbing is what would happen in the event of an insolvency. Briefly, the challenges of digital economies, as we know, these are global businesses, and it can be difficult for any one country to regulate these businesses as a result. I use the term supranational for that reason. They're not just international, but potentially they are beyond the reach of regulators, simply because if a regulator gets tough, then the business can easily relocate to another jurisdiction. Other challenges are that existing concepts that we know, such as property, can present difficult questions because of the nature of assets and rapidly evolving categories of intangible assets that we have to think about the legal implications of. Also, there can be a potential lack of understanding of the technologies that we use. In the same way that the banks got into difficulties because nobody really understood the complexities that were presenting risks, we have the same issue with digital services, arguably, because of the technical nature of those businesses. And you've got a mismatch where there will be people who will know the technical side, but not the insolvency side. For example, the risk of insolvency is mentioned in computing science literature, but only to the extent of, oh, that would be really bad. And the details haven't been worked out. One of the issues is too big to fail potential, and I'll come back to that in a moment. So multinational nature, I've already covered this, but there are problems for regulatory potential and also conflict of laws issues, because, for example, in cloud computing, your data might be in another country because that's the most cost-effective way to organize it. And there will be case law that will come up in that context. So the challenges to existing concepts, as I've said, issues of property, also issues of liability. If you have something like blockchain, an unpermissioned blockchain where anybody can edit the code, what happens if something goes wrong? Who is going to be liable? Well, the answer may well be that in that environment, if you get involved, you're taking a risk and you have to suffer the consequences, because in unpermissioned blockchain, for example, you don't have necessarily the same approach to law that you would have in commercial contexts that we're used to dealing with. Going back to the point about potential lack of understanding, for example, I'll use cloud computing as an example. Lots of people use cloud computing every day without even realizing that they're doing it, because we use it to store data, we use it to access services, and lots of other things. But we don't really know what that means. Most people would tend to think of something like this weather map symbol as representing the cloud, and it hovers above us somehow, and our data ends up in the sky. But all it means is that data is stored off-site. It's not on your computer, it's in a data center somewhere. And that presents difficulties potentially if that data center gets into difficulties, because how do you get your data back? I'll come back to cloud computing in a second, but the focus obviously is on failure prevention. We don't want failures to happen needlessly, and there are approaches to good corporate governance and good data management standards that can be adopted. Cybersecurity can also be important. Having robust systems for that can help to mitigate possible risks of insolvencies. So partly it's about having an environment that encourages the sustainability of digital services. And certainly this is the focus in the UK and the EU. So rather than looking at what happens if something fails, there are robust systems in place to protect essential digital services. And alongside that, you've got self-regulation by, for example, cloud service providers and by international standards. So in the UK, this was, while the UK was still a member of the EU, the Network and Information Systems regulations were adopted. And this is a law which protects the national infrastructure. And it includes lots of different things, but it includes digital services because of how important digital services are in day-to-day life. So in the 2018 regulations, digital services are included among sectors which need a high common level of security and which are subject to risk management and reporting requirements. So there's a big emphasis on spotting trouble and making sure that nothing develops into a real risk of real risk to businesses. Included in digital services are lots of things that we will use every day but aren't familiar with. So things like top-level domain name registries, domain name services, and internet exchange points are really important, but most of us don't know what they are. So when we go on the internet, it's easy because all we have to do is remember the name or go into Google or whatever, and the top name domain name registry will tell the computer who that is in terms of a string of code. So you don't have to remember the string of code. All you have to remember is the name, google.com or whatever, and the top name level domain name registry will identify that. The domain name service is like a telephone directory, so again that's important for internet traffic, and internet exchange points speed up the pace of internet traffic. If you send an email, it will ping from one point to another, and the more points you have, the quicker it will be. So if you have a low number of internet exchange points because some have failed, then internet traffic will slow down. If the domain name registry or the domain name service falls by the wayside, then internet commerce instantly becomes much more difficult and in many ways impracticable. Of a lesser importance, but still included in those regulations, are cloud computing, which I'll come back to because I think that's one where there are real risks. Also online marketplaces and search engines, which I don't think present such real risks because of the availability of competitors. You can just switch to a different service, which you can't do so easily with cloud computing. Going back to a point I made earlier, at its worst, the digital services sector present too big to fail potential in a similar way to the banks. Because what you've got is a concentration of business around a small number of market players. And the way that the sector goes tends to be that it becomes more and more concentrated. So unless regulators step in, it's, you're going to have, or you do have, huge global businesses. And it's a risk that's been noted by Lloyd's of London in the cloud computing sector, saying that as more companies rely on the cloud to operate, a select few providers have come to dominate the market. This reliance on a small number of companies creates the potential for systemic risk for service users. So if the cloud computing company fails, then the risks that presented by that are huge, and large possibility of economic loss. Tech providers can and do fail, and these are a couple of examples that, in a paper that I did with Niti Shikha, we found in India. So there have been examples of failure in India, and then in other systems. This is a UK example. So this was a data center operator. So one of these places, that's what they look like, where you've got lots of different machines where data is stored. This data center failed. And rather than shutting down, which would have caused the loss of the data, it requested funding from customers for £1 million. So if you add 2 zeros, that's the amount in rupees, to enable the business to continue operating and for customer data to be safeguarded and securely extracted. And that it was said that that needed 16 weeks. Why does it need that long? The process of data extraction in high volume is a slow process. It's not like we're used to in the movies, where somebody copies a whole hard drive onto a data stick in 10 seconds while the bad guys come in. And it's much more difficult than that. And we can be dealing with terabytes of data. And it's telling that if Google or if Amazon want your business, they will send a truck to collect the data. That's the volume of data that we're dealing with. It's not something that fits onto a little data stick. It requires a truck to transport it. And so it's not a straightforward and simple process to get your data back if the cloud company fails, and it needs time. There have been examples in the US as well of cloud companies that have failed. So Fusion Connect, Nirvanix, and Mega Upload and Mega Cloud. So examples do occur. There are lots of reasons why a service provider can get into difficulties. Ones that we'll be familiar with from any company, such as mismanagement, reputational damage, terrorism, natural disasters, COVID-19. And one of the difficulties in this area is that businesses are interconnected. If you use one digital service, that may involve lots of different companies that you have no idea about. So if one of those fails, that can bring down your whole transaction. So it's not even the main company that you're dealing with. It could be one of the ones in the background that makes life difficult. And that's one of the reasons why Lloyd's of London thought that the risks in this area were difficult to anticipate. So coming to insolvency now, what happens in the event of insolvency? So typically, a filing of a petition will bring about an automatic stay. And what impact does that have on your ability to recover your data? There may be difficulties there for customers and questions to be answered by the legal system. Also, if you've got an external manager coming in, they've got a steep learning curve because they're going into a technical business where there might not be many staff around to ask, and they might not realize that the company is holding highly valuable customer data, and that can lead to difficulties. Also, insolvency procedures aren't really geared up for managing digital service insolvencies. The particular problem that's presented is if you've got a digital service provider that is failing and is not viable. If it is viable, then there tend to be procedures that can be used to rescue it, rehabilitate it somehow, and ensure continuity of service to customers. But outside that, if the business is failing, there's no procedure that really is designed to provide a parachute so that is a soft landing and the company is wound down gradually while the interests of customers are protected. Liquidation's not really about ongoing trading unless it's in the interests of creditors, and it's not really geared up towards protecting the interests of customers. So we have a tension at the heart of digital economy insolvencies that customers will want the business to continue temporarily while their data is retrieved, but that is against the interests of creditors because obviously it generates further costs, and therefore there's potential public interest element that might require a sector-specific approach. Now, of course, you might be thinking, well, isn't it for the consumer to anticipate risks and structure their dealings with digital service providers in a way that limits the risks? And there are things that can be done, such as due diligence, cybersecurity, also various contractual approaches which cover specific aspects, but there's a limit to how effective they are. Insolvencies in this sector haven't really been thought about by many jurisdictions. The only example that I could find is in Luxembourg, where there is a law that clarifies the property issue, that it gives rights to customers to recover intangible property from a debtor. So you've got clarity around what would be a potential legal question mark in some countries, but note that this doesn't provide a supporting framework to keep the business going while that asset is protected. So Luxembourg introduced that as a way to be a first mover in terms of providing an infrastructure for cloud computing. Arguably, it didn't go far enough, and other countries can do more. So to conclude, what we've got here is an area which combines two technical areas, insolvency and computer science, and it needs expertise from both to really work out where the risks are and how they can be handled. And arguably, thought needs to be given to whether a sector-specific approach to insolvencies in this area needs to be developed as part of a digital economy strategy, so that the potential of these economies can be maximized and customers can have confidence in the companies that they are using. Okay, so I will not keep you from your dinner any longer, and I think there's time for questions as well. I think it was a mistake to mention dinner. So, and you've all had a very long day, so I don't blame you if you don't have any questions. And
Professor Perry,
yeah.
I have a question.
Yeah.
So this is a very interesting viewpoint. What you're saying is that, suppose there is there's a company which manages gargantuan customer data, and it goes bust. Then what you're arguing is that the data itself is such a big asset that we need to safeguard it. So have you seen such incidences, such litigations, for example, in the UK, where something like this has happened? Because in today's world, Facebook and Twitter and Uber, they're all about data. So it's a very interesting viewpoint.
Yeah, the examples were on the slide. So there have been examples of failed data service centers and cloud service providers. And there have also been outages that give us a hint that if those companies that suffer outages were to fail, then the economic consequences can be disastrous. So there is already evidence that this would be tricky if one of the larger companies failed. But it's not happened yet, and it may be that we need to be proactive so that we can anticipate the risk and it can be mitigated.
For example, I mean, just a counterfactual. Suppose Facebook fails,
yeah,
for whatever reason. People could kill to get their data, right? So how do you see the role of computer science in or IT for that matter to play a role in this?
Yeah, I mean, there have actually been papers written on how devastating it will be for people if Facebook fails because of the personal connection it has. That wasn't really the angle that I was thinking of, but of course it is relevant to consumers as well. And it may be that there's a too big to fail angle there. But I think these issues need to be worked out. Yes.
Having access to that particular data, while Facebook does have a meaningful access to that data, though limited by the user's choice, but then it has a meaningful access to that data. Probably data centers were not having. So
yeah, and obviously they can't get into the data, but they do have it, and if it's not stored anywhere else, then it's gone. So there are two different risks there, and the Facebook one wasn't really the focus of this paper, but you are right. It does interact with personal data in ways that need to be thought about.
If we generalize this concept to one of shared risks, do we look at insurance and reinsurance to sort of think about this framework? A data center might go bust, but...
Yeah, shared risk is a very good point, because that's the way that the computer industry looks at it, that they can only go so far, and it's really for the customer to identify risk and take steps to mitigate it. I forgot what the rest of your question.
No, my point is, I mean, should we think about data centers, and if there is a risk of the data center not being operational, leading to customer data loss?
Yeah, the better approach is that customers do anticipate it and don't have what's called a single point of failure, so that if that company falls by the wayside, then that is some important bit of
So
business
that's from the
gone.
customer side. What about from
Yeah.
the data center side? Is there insurance? Is there a concept of shared risks from the data center's perspective? Do they store their data, for instance, at some other point?
Yeah, I don't know if there's specific insurance of what's safeguarded by the data center. They tend to have standard terms that are quite limiting about their risk of liability. So there may well not be.
And a clarificatory question here
Yeah.
to the group. Suppose you do take insurance from a data center perspective, how do you value the particular asset? I mean, is it just the plant and machinery, or does it have a sense of the data?
Yeah,
also?
intangible assets can have quite high values. So it really depends what it is, but there'll be people who would be able to value it and give you an opinion on what it's worth. But insurance could cover you for the loss, but it wouldn't necessarily get you your data back.
Thank you.
Yep.
Banks have stored data in data centers, which are operated by private entities. But there is also a disaster recovery arrangement. So one possible solution is for all users who are using data centers to have a disaster recovery center which is operated by a different entity. Now, I do know of banks and many other IT sector entities who have data centers, they have disaster recovery centers, but for convenience of operation, it's often that both these entities, the data center as well as the disaster recovery center, are operated by the same entities. So maybe it could be a good measure to have these two entities, the data center as well as the disaster recovery center, operate by separate entities. So in case the disaster, the data center entity goes into bankruptcy, so we have the fallback of the disaster recovery center.
Yeah, that's a model that could work if it enabled continuity of service to protect the data. I did in a previous paper look at another possibility, which is a levy for the cloud service providers, depending on the volume of user data that they handle. Perhaps they could contribute to a levy which would cover the costs of an insolvency. But that goes back to these issues of what's called regulatory arbitrage. So any one country being able to impose a levy can be difficult, and it might be something that needs international attention. Okay.
Yeah, I have one question.
So we need to close the Q&A session now because it gives you a break before you have your dinner, I think, and I will be able
ladies
to-
and gentlemen, actually we are running behind the schedule, so we can take the questions during the dinner session. Thank you.
Okay, thank you.
Thank you, ma'am, for your elaborate presentation on one of the most topical areas and its relevance for insolvency landscape. Ladies and gentlemen, we now proceed to the workshop on data-driven insolvency research by IBBI, which is being led by Mr. Mahesh Vyas, MD and CEO, Center for Monitoring Indian Economy, and Ms. Kokila Jairam, Deputy General Manager, IBBI. We look forward to hear from you, ma'am. Sir. Thank you, Archana. Very good evening. We are running behind schedule, so we'll try and keep it as short as possible. But I think Professor Das has already put a very difficult question to me. Good news. So I'm not sure if people here are fans of Kung Fu Panda, but I am. So there's Master Oogway, the wise old tortoise master. He says, there's no good or bad, there's only news. So I have only news. You can decide as to the good and bad of it. And Mr. Vyas, I would request your interventions
as in when you think necessary. And I would also like to defer a couple of points to you through the presentation. What happened, I mean, all management students here and people dealing with businesses would understand that a typical business cycle before 2016 we would have thought of would include only 4 steps: creation, growth, maturity, and decline. A very typical one. Of course, you have 5 stages, 7-stage business cycles, etc. and all that. But so once when IBC came into play, we saw the introduction of an insolvency process that could kind of enable the recreation of failing businesses. So to make that possible, it could happen even in the decline phase of a business, where the business could take the bank's restructuring route, or if they have a feeling that that business is not viable anymore, they could take exit through the voluntary liquidation option. And if at all they defaulted and were insolvent, then the code provided for, of course, pre-packs if you were a corporate MSME, and for a resolution through the corporate insolvency process, or if there was no scope for any resolution, then the business got liquidated. Sorry. So once this expansion of the business cycle was in place, we also found that we expanded the information cycle also around our enterprises and businesses. There was an earlier system of information available, which I think Mr. Vyas here would be able to address more comprehensively than I could. So if you...
Okay, so I will intervene whenever I can regarding this subject. So the first slide that Ms. Jayaraman showed us was about the business cycle and how that is changing because of the existence of IBC, IBBI, etc. So when it comes to creation, when it comes to formation of companies, I think the best thing to look at is the MCA database. So that's now more or less comprehensive, at least insofar as companies are concerned. When it comes to partnerships, proprietorship, we still have a challenge. But at least one thing is clear, that if you want to know how companies are being formed, how many companies are being formed, MCA website gives you fairly good information regularly, how many companies are getting formed regularly. So creation of companies is possible to see over there. The challenge is after that. So the first thing she has here is business reporting. MCA is good. Listing disclosure, SEBI is fine. That's good. But SEBI is or listed companies is an extremely small set of companies compared to all companies we have. We have lakhs of companies, more than 1 million companies, and we only have about 5,000 listed companies. Of course, those are the more important and active companies, nevertheless. So I think what is important is for there to be a database on the performance of companies, not merely the existence of a company. So the MCA database will tell us that there are these 1 million companies in India, and so many are, deregistered sometimes. A very small sliver is, but all you get is a stock of companies over there. But to know what has been the performance of companies, I think you require a database which has got a database format of the profit and loss statement, of the balance sheet, of the cash flow, wherever possible. Now for that, you require to build that database, and the MCA database is still not able to provide those performance indicators in as much of detail as we would like to. So you rely upon companies like CMI. Sorry, I'm doing a little marketing pitch here, but I'm helpless on that front. Is that you need to use the prowess database to actually understand how have companies progressed, how have they matured, as the slide showed over here, and how they progress into distress. So I think before you come to IBBI, before you come to NCLT, etc., you see distress in financial companies. So I think any scope of building a database to study, to do research on the subject of insolvency, we first need to start from the beginning, which is stress forming in companies, which is best seen in the financial statements of companies. So I think we require to look at the larger set over there and then progress from there into something more difficult. I'll take a minute more. Is that we can see distress in financial statements, but that's last year's information. That's still dated. So you still, are really behind the curve. So the better information is actually available with places where default happens. So default happens primarily with banks. Only banks know that. And then you have information flowing from there. You become an NPA afterwards before you go on to coming into the insolvency business. So I think it'll be good. And this is a suggestion to IBBI that if it becomes the nodal point for it to actually be the place where all the data is collected. The challenge over here will be that banks will not be willing to give and will not give details of the companies that are defaulting. They'll not give the names of the companies, for example. So if IBBI can play the role of anonymizing this information and bringing together the rest of the information, then motivating the researchers to come in, that could be a good thing. IUs can play a good role as well in that, to become the central point or participate in the central point to ensure that all the information comes together so that research can happen.
That's a law. So that's IBBI regulations provide that the default has to be reported by a financial creditor within 7 days.
Report to who?
Report to the IU.
To the IU.
Yeah.
Okay.
So
and does the IU make it public?
No.
So that's the challenge for researchers.
Yeah. IU does not make it public except at the macroeconomic level. We present only macro data. See, IU is not a public credit repository. Access to IU is restricted to persons as provided in the IU regulations. But there are some interesting aspects. In fact, I'll take another minute just to draw the attention of this august audience. The regulations provide that the auditor of the corporate debtor, any company, has access to the IU. That is a very little known provision, but it can be used to great effect. And it does not require the consent of the borrower also. The access provisions in the regulations provide that submitter can of course access, all parties to the debt can access, the debtor, the co-applicant, the guarantor, IBBI and AA can access, and besides that, the auditor of the corporate person is a very, very important provision. So he can independently verify all the data in respect of submissions by financial creditors.
Yeah, I'll just respond to that. The challenge over here, the objective, I think, from IBBI's perspective here, is to make data available to researchers. Okay, so if the data is available to an auditor, it's still too bilateral. It is still too transactional. What is required over here is for us to be able to pool all the data in, to anonymize it appropriately, so that researchers can then take off from there and help us understand what's happening to companies' performance and how is insolvency working out. That's the objective. So I hope we can work towards that.
Sure. And just one last point, but we do make available data at a macro level. So that's there on our website. So for example, we will tell you how many defaults have been reported, what is the default percentage across various categories of borrowers, individuals, companies, corporates. What is the trend of default? So all that is there. But other than that, it is, because as I said, it's not a public credit repository.
Thank you, sir. Thank you for the interjection. IBBI, in all its functions, creates a lot of information by itself, and it also collects and collates information from other institutions and other agencies in the insolvency ecosystem. So we act both as a data creator, provider, and an aggregator at various levels. And the kind of information that we create or aggregate at the IBBI is kind of put to use or used by different categories of users. They vary across, their demands vary, and the kind of rigor that they use, apply on the information that we provide also varies. So broadly from the media use doing reporting on the insolvency incidents, to the parliament and the regulator and the ministry making policy interventions. All of this, a lot of this is today being done on whatever evidence that we've been generating from the data that we put together. So apart from IBBI, we also have the information utility as part of our ecosystem. The other service provider agencies are also available. And with the NCLT going into an E mode, we have more of information flowing from the NCLTs also, which right now is not readily available, but should be there anytime sooner once the NCLT is more digital friendly. So moving ahead, I'll just quickly run through all the information that the IBBI currently offers. A lot of you have already used a lot of this data to prepare your papers, and so I will just only quickly list out or give you a glance of what information is available. So on top of our list is the corporate insolvency resolution process. That is the largest chunk of information that IBBI currently gives out. If we look at the newsletter or any publication, the core of it or the heart of it is our CIRP and the reporting that goes around it. I'll just take a minute here to delve on the IBBI's database. Uses SIN, the company identity number, as its unique identifier. So almost all the data is identified with the SIN. So this SIN offers a lot of scope for researchers who can use it. So today through the presentations, we saw a lot of papers being presented for listed companies, unlisted companies, certain sectoral representations. But there is still a lot of scope that remains if we are to use the SIN and draw down the various options that can be available. For instance, ownership. A company's ownership can be known from its SIN number itself. But so far we've not seen any studies or research as to did ownership make a difference to those companies being in insolvency, being liquidated later on, or things like this. So just the fact that we are using SIN as our unique identifier opens up a lot of scope, and we would request researchers using our data to actually think of exploiting it more constructively. Other than that, we could disaggregate data based on the type of creditor that the IBC gives, maybe the age-wise, the age of the process, the age of the companies, and depending on the kind of outcome that the process has given, or in a way to also do it depending on the professional's performance in that process. So these are quick snapshots of the information that we currently house on our website. These are all available in PDF and Excel downloads. And we also see that regular downloads happen, and we also have special requests from researchers for additional information, which this is aggregated at one level. We do have disaggregations of these parameters. So those also generally are provided when researchers have reached out to us. So that's resolutions. You can see we have the trigger, the applicant, the concerning NCLT bench or the geographical distribution that we can draw down from there, the status when it came into IBC, and then when resolution happened, what actually was the value that we realized. And similarly, we do have a lot of aggregated data that we give out for the outcomes of our liquidation process. Here again, alongside the basic data, we also provide what happened at the end of the liquidation process. So how much was realized, what worth did the assets have, and how much did actually get redeployed. And there is this unique category throughout the day. We've been listening to people talk what happens outside of the code, how withdrawals kind of help further the objective of IBC, even without going through the CIRP process. Yes, we have a limited set of data available on process withdrawals. So this has also been made available to researchers on request. And going ahead, similar to our corporate insolvency process database, we do also have an extensive disaggregated database on liquidation and voluntary liquidation processes. So this is our outcome in terms of what happened when a company was finally dissolved. And the process of voluntary liquidation is slightly different, but despite that, you can see how the exit option that the IBC brought out has actually helped companies exit. And another important set of data that we have, or information that IBBI currently hosts, is that on insolvency professionals. These professionals are regulated by IBBI, and we do offer a lot of information on almost all the details of these professionals. Coming to think of what data or information can help us do, IBBI has recently launched a service to applicants and creditors to make a more informed choice when they are trying to choose their professionals. Suppose we have a couple of bankers here. And other operational creditors could also, key in some of the parameters they would want their insolvency professional to have, because before they can make a choice and name him as the professional that they would want to conduct the process for their borrower. So it offers a wide range of information, all objective, that has been put together based on the professional's performance, the number of assignments and all that. So this kind of service, though a small element, gives out a lot of value for the market. Coming back, probably Mr. Vyas would be able to add a little more value as to what other services, or if we could expand to other areas where the information that we currently have or could generate and use further.
No, I think this one was a very useful piece of service where I can go and look for insolvency professionals and their details, their information. So I think this is clearly very valuable. But this is a service, and there can be similar services more in the direction of helping the ecosystem in their transactions. So it's a little different from the research agenda. But when all this comes in pipe delimited format for researchers, then it starts becoming very exciting. So we'd like to see how all this information can also be packaged and made available to researchers. So I think this is just a very good service for the ecosystem. It works fantastically. I think this is something one should applaud.
Thank you, sir. And I wouldn't want to add more to it because Mr. Chowdhury from NES has already briefed us on what the IU has to offer. So in terms of research questions that we see happening in this arena, in the insolvency domain, we are still limited to, certain focused areas. And a lot of the other questions remain almost untouched. There are a lot of areas where we've not even bothered to look at. So we would encourage researchers to take a look at all the areas which are yet to see any research or any attention. Especially, we've been tracking the performance of the code and the outcomes, but after resolution, what happened to the sustainability question of these resolved companies, or what happened to those resources that were redeployed through the liquidation process unaddressed. Similarly, if there were companies like startups or MSMEs which go through an insolvency process, so their predictions for insolvency would be very different because the risk and resilience in that segment of businesses would be very different from the larger corporates or the medium-sized corporates and their insolvency issues. And similarly, even when we are talking about operational enterprises, businesses running fine today have to be prepared for the eventuality of maybe an insolvency situation. So if that's the case, we do talk about a resolvability index, how an enterprise should prepare itself and keep itself resolvable at all points in time, and how should businesses strategize growth and productivity measures to make resolvability an aspect of it. And similarly, a large amount of focus over the decades, both in the West and currently in the last decade in India, and particularly after IBC, a lot of work has gone into predicting insolvencies. Of course, that's one area that requires a lot of answers. Again, when companies in the twilight zone, there's a lot of questions of companies do take a lot of preventive measures, and we don't know what those preventive measures are, how they affect their insolvency or default expectations, and did IBC make a difference to the kind of preventive measures that companies were earlier taking and the measures that they are currently taking, or maybe in the long term, given that behavioral change in debtors is also to be expected and changes to financial contracts are expected in the long run, how will these be internalized? All of these research areas are largely unaddressed, so researchers here should take your focuses to these areas of questions also.
I'll add one more thing to that. I think researchers can do a huge service to society if we can find the relationship between business cycles and corporate distress, so that we, at least to some extent, ensure that corporate distress is not equated with stigmatized capital. So every failed entrepreneur is stigmatized oftentimes. But failure could also be a function of business cycles. It could be a function of many other externalities. So finding the macro conditions under which distress happens is a matter of research. I think that's what I think you were trying to get at. But delinking business cycles or externalities compared to specific cases of business failure. And there could be cases of fraud as well, but basically it is business cycles, there could be company-specific things, and there could be other things. So research in that area would be immensely helpful to ensure that capitalists don't get stigmatized.
So we've opened up a lot of questions for you. I hope, Professor Das, it's good news. So, of course, a lot has been said and has always been, we continue to say that evidence-based policy making is important and all of us should be doing it. So, IBBI is slowly taking steps to get the first item of this long list of enablers in place. We're trying to give you high quality evidence on relevant topics that we think we can do. So, in terms of the evidence or the information that we are hoping to generate would be both objective quantitative data, and because it's an economic legislation, we cannot separate the law and the jurisprudence from the economic outcomes. So both of them go hand in hand. And there are a lot of questions of quality in terms of reliability. And in this ecosystem, given that we have the court in place and it's a legal process, of course, there are a lot of challenges inherent to standardizing information generation, or its collations not as simplistic as one would think it to be. Despite that, we do take measures to ensure that whatever we are making available is accurate, and keep it as objective as possible, and wherever we are picking samples, that they are as representative as possible. And given that issues or limitations of data, there's always this question of credibility. So at least IBBI has always ensured that data that IBBI gives out is something that you can trust on. And And in terms of technical rigor, like I said, because this is a legal process in operation, so it needs to be, every piece of information needs to be understood in terms of its position in the law. So that technical rigor is also what we've tried to incorporate in generating and providing the information. And of course, in terms of practical considerations of handling data, I think Mr. Vyas would be better placed to give us a few more thoughts.
So, to react over here, there is this worry about reliability, credibility, and so on and so forth. We need to figure out how much responsibility can we take as providers of data. So, for example, when CMI provides data about a company, about balance sheets and so on and so forth, we cannot be held responsible for the financial statements of companies. We take it as a given. So what is more important, at least from a researcher's point of view, will be, from a database building point of view, will be to ensure some degree of standardization of the data. If you change the definitions too often, then that makes it very difficult for researchers to use the data. So what is important, like CIN is very important in ensuring that I can walk across from one source to another to see the same company information being put together. Similarly, I think what's more important for the building of databases and the providing of databases is to ensure that we maintain a certain degree of standardization and stability in the way the data is put forth. Now, if you worry too much about whether this is credible or not, who is holding responsibility for what is the question you need to ask. Are you certifying this data to be right, or are you merely putting together the data and making it available? Saying, I have high fidelity with respect to the source from where I've got the data, and no more than that. If the source itself is fraudulent, you can't be responsible for it. You can, at the most, if you know it, highlight. But for the rest, credibility, reliability are slightly over hyped things in building of databases. What is important is lots of data and standardized data. I mean, don't give unreliable data or not credible data, but don't fuss too much over it. What's more important is standardized and lots of data and very fast.
So I think that was not so much good news. So yes, all data sets that we have and all information we have comes with a lot of caveats and limitations. Like we said, we don't intend to change definitions, but when courts change their rulings and end up changing definitions, we can't help it. We'll have to include it in our data collection efforts. And similarly, delays and incomplete reporting is also a possibility. So researchers, when you are accessing information from the IBBI database, please feel free to contact us so that we would be able to brief you on the lags or the missing portions or gaps. And right now, we do not have a robust system to put out all information in the public domain, but of course, we are working towards it. In the meanwhile, we've been addressing all research requests that have been coming to us. So we would encourage all of you to ask, demand, when there's a demand, then we would be forced to provide that information. So put out this request to all of you to raise questions, to ask for information, which then we would also be forced to dig out and give it to you. So that's the future. We hope eventually we reach some place where, somebody can say that, okay, if we go to IBBI, then IBBI's database will give me information on the history of the company and probably a good look at its prospects into the future, something like that. So with that, I think I should say thank you. We did target to complete in half hour, but I think we've exceeded by 5 minutes there. Thank you. So I think it's too late for me to take any questions, but we are here for dinner, so please feel free to raise any points that you would like to discuss. May I request everyone to please be seated? Thank you, ma'am, for this comprehensive presentation and taking us through the intricacies of the novel research initiative by the IBBI. Ladies and gentlemen, may I now request Mr. Sandeep Garg, Executive Director IBBI, to present a small memento as a token of our gratitude and appreciation for the contribution to the speakers. May I request Mr. Prashant Das to kindly accept the memento. Can we have a round of applause, please? May I request Ms. Rebecca Perry to kindly accept the memento. May I request Mr. Mahesh Vyas to kindly accept the memento. May I request Ms. Kokila Jairam to kindly accept the memento. Thank you so much, sir. Ladies and gentlemen, we at IBBI and on behalf of IIM Ahmedabad extend our heartfelt gratitude to all the distinguished dignitaries, panelists, presenters, and other invitees for sparing their valuable time and gracing us with their presence and contributing to the research initiatives. We also thank the participants and stakeholders who joined us online, and we look forward to have your participation tomorrow for the second day of the conference. And here we conclude the day one of the conference. So ladies and gentlemen, I request you to kindly join us for dinner at the lawn outside the auditorium. Thank you and good evening to all.